Right. Good morning and welcome, everyone. My name is Madison Calhoun, and I'm the Educational Programming Attorney at the Environmental Law Institute. I'll be today's program host. On behalf of ELI, I am absolutely delighted to welcome you to TSCA Reform 10 years later, an annual day-long program on the Toxic Substances Control Act, brought to you by ELI, the George Washington University Milken Institute School of Public Health, and Bergeson and Campbell. We're thrilled to see all of you here with us to celebrate the 10-year mark of the conference and, of course, of the passage of the Lautenberg Amendments. Today's conference is packed full of fantastic content for you. We are back to hosting the conference in a hybrid format this year. The program is taking place live at the George Washington University's Jack Morton Auditorium, and it's also being live streamed to hundreds of registrants across the country. Our online viewers can find the full agenda on the event webpage at eli.org. You can find it on the programs. For the folks in the room, you can find it on the programs that are seated at the tables. I'm going to give a few quick opening remarks, and then I will turn things over to our next speaker. First, I want to thank our co-sponsors, the George Washington University Milken Institute School of Public Health and Bergeson and Campbell. Thank you to George Washington University for hosting us in their beautiful space today, as well as to their team for all of their assistance making today's conference possible. This conference is also made possible by the generous support of Bergeson and Campbell, Beveridge and Diamond, Squire Patton Boggs, and Wiley Ryan. Thank you to each of those firms for their support. Additionally, I want to thank our steering committee for the conference. You'll be hearing more about them shortly, but they each put so much time and energy into creating an engaging and thoughtful program today. Last but not least, I want to thank all of the fabulous speakers who will be joining us today. You can find their full biographies along with other resources that our speakers have shared on the event webpage. For those in the room, there's a QR code at the registration desk that will link you to that. If you are not familiar with ELI, we are an internationally recognized, nonpartisan research, publishing, and education center working to strengthen environmental protection by improving law and governance worldwide. We convene professionals representing divergent perspectives on important policy questions to build bridges, foster common understanding, and explore areas of ultimate agreement. The opinions and positions expressed by any program speaker today are theirs alone and do not reflect the views of the Environmental Law Institute. We have several staff with us in person today. Should those of you with us in person need any assistance, please find one of us. We're all wearing green lanyards, and we'll be happy to answer any questions you may have. For folks watching online, please be aware that the live stream is not being monitored. If you have a question or need assistance, please email events@eli.org, and we'll be happy to help you out. For folks in person, we have coffee and tea available on the second floor. We'll also be offering a complimentary lunch on the second floor and on the lower lobby later today. We will take audience questions if time permits at the end of each panel. We ask that you please stay seated and raise your hand if you have a question, and someone from the ELI team will bring a microphone around. And with that, I will turn things over to my colleague, Cecilia Dietrich, to tell you a little bit about ELI and about our toxics program. Cecilia is a staff attorney here at ELI. She currently leads ELI's plastics and toxics work. Cecilia holds a JD with honors from the American University Washington College of Law. And I will turn things over to you, Cecilia. Thank you so much.
Thank you so much, Madison. And I just want to echo her thanks to everyone who worked to make today's conference possible and offer a special thanks to Madison herself for all the incredible work that she's done over the past several months to bring this event together. And thank you to all of you for joining us today, both in person and virtually. As Madison said, my name is Cecilia Dietrich, and I lead ELI's plastics and toxics work. For decades, ELI has helped advance understanding of complex toxics issues through research, education, and convening, bringing the legal community together to discuss and address some of the most pressing issues of the day. At present, our research team is engaging in an exciting initiative to track and analyze trends in toxics litigation. As part of that effort, we recently published the Current Trends in Toxics Litigation Report, which is available on ELI's website, and it examines developments in the evolving landscape of U.S. toxics litigation. More broadly, this work is intended to inform and advance discussions in this area, illuminate connections across toxics litigation, and support progress towards a healthier and more sustainable future. Beyond our reports and publications, ELI offers a wide range of educational resources and convening opportunities that help practitioners, policymakers, academics, and other stakeholders engage with complex environmental issues and learn from one another. Today's conference is a perfect example of this work in action. Our steering committee, a group of dedicated professionals and recognized experts, has developed an outstanding program of panels and discussions for you all today. To help set the stage for those conversations, I'm honored to introduce Lynn Bergeson, managing partner of Bergeson & Campbell, a renowned expert in chemical law and regulation. In addition to many publications, Lynn is also the host of a podcast, All Things Chemical, and has made countless contributions to the field as a practitioner, thought leader, and educator. She has been an exceptional co-chair and an invaluable partner in bringing this event together. Please join me in welcoming Lynn.
Thank you, Cecilia, for that very warm welcome. And good morning, everyone. That's your cue to say good morning back. Good morning. Thank you for being here, and welcome to our online audience as well. I really want to welcome everyone on behalf of our steering committee, which includes Madison and Cecilia, Dr. Maria Doa, Mark Duvall, who was on stage, Martha Maripes, Karen Schmidt, and my wonderful co-chair, Bob Sussman, who has worked extraordinarily hard to bring in all aspects of the TSCA stakeholder community. So welcome to TSCA Reform 10 years later. Hard to believe. You know, we started this collaboration literally 10 years ago when the first TSCA Reform 1 year later program was off and running. We wanted to celebrate the enactment of the Frank R. Lautenberg Chemical Safety for the 21st Century Act. Our goal then, as it is today, is to bring all the disparate and diverse voices in the TSCA community together to talk about the many issues, science, regulatory, legal, social, policy, that we are grappling with. In that regard, we invited EPA to participate in this program, but EPA declined to do so. It is obviously a very important part of this TSCA stakeholder community. We wish they were here, but they are not. You know, that this program consistently, year after year, has commanded the presence of hundreds of registrants and participants tells me that there is broad national interest in TSCA and Lautenberg implementation. And if you think for a minute, you know, why is that? Why are people interested in a federal law? To me, it's because TSCA and Lautenberg implementation raises foundational questions of extraordinary relevance to public health, environmental protection, manufacturing operations, chemical innovation, supply chain dynamics, and most basically to our fundamental ability as a society to assure chemical safety. After all, what could be more relevant to everyone in this room and everyone in the United States? Every product and every convenience we enjoy is touched in some way, shape, or form by chemicals. I mean, that is a fact. How chemicals are tested, how new chemicals are reviewed and regulated by EPA, how unreasonable risks from existing chemicals are identified, prioritized, and regulated, and are all, to me, significant both national challenges and have deeply, deeply personal implications. TSCA's reach has always been broad, but Lautenberg, more than anything else, has made TSCA more muscular, more relevant, and more consequential than at any time in its 50-year history. We are here today to discuss TSCA and its implementation of Lautenberg these past 10 years, and to consider what's working. There are things that are working, clearly. What's not working? Clearly there are things that are not working well, if at all. But also, and it's so important, given the venue in which we are at right now, to celebrate, really to celebrate, no matter how vigorous our differences of opinion. And there are lots of differences of opinion, but we can be respectful and have good, solid discussions about TSCA implementation and gather today as friends and colleagues and as interested stakeholders, all committed to fulfilling TSCA's promise to assure chemical safety. I think it's very important not to lose sight of that, given the divisive nature of the times in which we live. I think this year is perhaps more consequential than ever EPA has experienced significant change over the past 18 months, as has the federal government writ large. The courts are now firmly engaged in ruling on a variety of issues, and they are going to do so in our new Loper-Bright, relatively new Loper-Bright, Chevron deference-free world. We are awaiting promulgation of the third risk evaluation framework rule, as well as judicial rulings interpreting chemical risk management decisions, rulings that will almost certainly influence Section 6 interpretations and rulemakings and decisions for years, if not decades to come. And maybe, we might see some legislative change this year. Who knows? Maybe. It is within this exciting, dynamic, and very evolving landscape that we have put together an extraordinary program today. We're going to be considering key aspects of TSCA and then some. Steering Committee member Mark Duvall is going to kick us off by leading a discussion of TSCA risk evaluation. Mark, I think you're going to be focusing on the forthcoming final risk evaluation rule, the formaldehyde risk evaluation, and other key aspects of risk evaluation, just a fundamentally important and very divisive topic these days. It's going to be followed by our second panel, moderated by Steering Committee member Martha Maripes, who will consider chemical risk management. Martha is going to be addressing the ongoing litigation over the 5 risk management rules, the role of chemical substitution in the selection of risk management options, the pluses, the minuses. We could have an entire day of discussion on this topic, of TSCA Section 121 citizen petitions in compelling Section 6 rulemakings, and lots of other of the recurring issues in TSCA Section 6 debates. Our third panel is going to discuss the ever-popular topic of new chemicals, a topic that we at Bergeson and Campbell spend an awful lot of time talking about. New chemical regulation has commanded attention almost since the beginning of the Lautenberg era, and that debate and those issues have not abated one bit. Greg Schweer, a former esteemed member of the Office of Pollution Prevention and Toxics, will moderate the discussion, and Steering Committee member Dr. Maria Doro is going to serve as a panelist among other TSCA new chemical experts. And then our fourth kind of standard panel that you've probably picked up over the last 10 years, that we have risk management, chemical evaluation, risk management, new chemicals, and then a panel of current interest is our standard offering for these programs. So the fourth panel, which includes, as I said, Karen Schmidt, Steering Committee member, is going to be addressing the pending TSCA legislative reforms. Pat Rizzuto, as you all know, is a highly respected journalist focusing on toxics with Bloomberg's Law Environmental Desk, will moderate a discussion of what these legislative initiatives are, whether they address TSCA deficiencies such as they are. There's so much debate on whether TSCA needs legislative tinkering or reform, and if so, how, and whether these legislative drafts do the job. It's very unclear what's going to be happening legislatively, but I think most of you would agree with at least my assessment that even if there's no legislative reform, perhaps not even reauthorization of fees, that the debate that these legislative measures has inspired has been both constructive and creative. In addition to these standard so-called panels, the 4 that I've just enumerated, we have 2 very special panels to commemorate this, I think, a very important milestone of 10 years later. First, Dr. Lynn Goldman, Dean Emerita of George Washington University Milken Institute School of Public Health, and now current full-time professor here at GW, former EPA Assistant Administrator for Toxic Substances, and world-renowned pediatrician and epidemiologist, is going to lead a wonderful conversation between 2 people uniquely well-suited to talk about what was going on 10 years ago and where are we at. Dr. Goldman will be featuring a discussion of the Honorable Tom Udall, former U.S. Senator from New Mexico and former Ambassador of the United States to New Zealand, and Bonnie Lautenberg. Long an advocate of chemical safety reform, Bonnie joined with Senators Udall, Vitter, and Inhofe 10 years ago in ensuring that her late husband, Frank Lautenberg's commitment and vision for reforming TSCA would be fulfilled by the Lautenberg amendments. Dr. Goldman will guide that discussion of their roles in TSCA, and also their views on where we at right now, 10 years later. So really looking forward to that, Lynn. The second special panel is a panel discussion led by Jeremy Bernstein, a distinguished editor or publisher of Inside EPA, of 8 panelists deeply engaged in both TSCA reform and in TSCA implementation. As the expression goes, each of these people was in the room or in the room adjacent 10 years ago, and each is uniquely well-suited to share their views on the foundational question of what we are here today to answer. 10 years later, where has Lautenberg gotten us? Are we better off? ELI President Jordan Diamond is going to then offer some closing remarks and conclude the conference. Before I turn it over to Mark to lead the discussion for the first panel, I want to also join Cecilia and Madison in thanking our sponsors, the Environmental Law Institute, the G.W. Milken Institute School of Public Health, most especially Lynn Goldman, and Bergeson and Campbell, and pay special thanks to our fabulous team, Heidi Lewis and Emily Shear. I can't tell you how much time and energy goes into pulling these conferences off. We started this discussion in February, and everyone, the steering committee, our team, ELI's team, Dr. Goldman, has worked tirelessly to make this program the success it will be. If you have not thought about becoming a member of ELI, I think you should consider it. ELI's mission is to focus nonpartisan, innovative, thoughtful discussion on key environmental challenges of our time. EPA or ELI plays a pivotal role in fostering discussion, and its unique role in deliberating on such discussions is more crucial now than ever before. Finally, a special thanks to our truly brilliant panelists. Each of them has committed countless hours in preparing for this day, and their contribution of their intellect, their intellectual curiosity, and their time and expertise is really going to make today the success I know it will be. And finally, a quick reminder that full biographical information and biographical statements on our panel moderators and panelists is part of your hearing, part of your materials in our handouts. Also, I want you to note that the panelists, moderators, and others contributed curated material on TSCA that are also available online. We spent a lot of time trying to pull together material that will foster the discussion, the diversity of views, and just enhance your understanding of the depth of the issues that we're going to be considering today. So please don't overlook the fact that they are there in your handout materials. Now I'm going to turn the program over to Mark Duvall, Principal at Beveridge and Diamond, to moderate the risk evaluation panel discussion. Please join me in welcoming Mark Duvall.
Well, good morning, everyone. Risk evaluation. So what is that? It's the process under TSCA Section 6B that enables EPA to determine whether chemical substances or their conditions of use present an unreasonable risk to health or the environment, including with respect to potentially exposed or susceptible subpopulations, but without regard to cost or other non-risk factors. And if EPA determines that a chemical or its conditions of use present an unreasonable risk, EPA must proceed to risk management rulemaking, the topic of the next panel. In the 10 years since the enactment of the 2016 amendments, EPA has completed 23 risk evaluations and 3 draft risk evaluations. They include ones for each of the initial 10 chemicals, plus legacy uses of asbestos, half of the first 20 high-priority substances, and 2 manufacturer-requested substances. Risk evaluations are generally massive documents totaling hundreds of pages. In preparing them, EPA seeks to effectuate key science-related provisions of Section 26 of TSCA, consideration of the best available science, the weight of the scientific evidence, and reasonably available information. Risk evaluations include consideration of science policy questions as well. Not surprisingly, risk evaluations often prove to be controversial. Today's panel will discuss some of those controversies. I want to introduce these panelists, starting off at the far end with Kelly Lester, who is a senior attorney at Earth Justice. And next to her is Rashmi Joklar, Science Policy Director at the Department of Epidemiology, Population Health at Stanford University. Next to her is Kimberly Wise-White, Vice President, Regulatory and Scientific Affairs at the American Chemistry Council. And on my left is Judah Prero, counsel at the law firm of Arnold & Porter. So let's get started with the Risk Evaluation Framework Rule, which Lynn mentioned. In 2017, the first Trump administration adopted a procedural risk evaluation framework rule. The Biden EPA had problems with several of the risk evaluations that the Trump EPA had produced under that rule, so in 2024, the Biden EPA revised the rule. In 2025, the second Trump EPA proposed revising the 2024 rule, essentially back to the 2017 rule. Litigation challenging the 2024 rule has been put on hold by the DC Circuit pending outcome of the current rulemaking. TSCA Section 6b-4 says that a risk evaluation is to determine whether a chemical substance presents an unreasonable risk under the conditions of use. The 2017 rule and the 2025 proposed rule would require separate risk determinations for each condition of use. The 2024 rule requires one risk determination for the chemical as a whole, while identifying the conditions of use that significantly contribute to that determination. This has been a major subject of contention. My first question is, why do we care? What's the practical significance of one approach versus the other? Judah, you want to start us off?
Thank you, Mark, and thanks to the organizers and for inviting me to participate today. It's always a pleasure to come and speak about TSCA. Now, I know not everyone always shares that opinion. At least people I hang out with socially don't necessarily think that that's the case, but I know I'm in good company here today. And so, Mark, I'm glad that the way you styled the question is looking at practical significance, because I know in years past we've discussed the legal significance, and there's plenty of briefs, comments that people could pick through to see all the legal arguments. And so looking at it from a practical standpoint, and from what I hear from clients as well, so one issue with regards to what we'll call the whole chemical approach is that it's hard to understand, notwithstanding the fact that EPA may have articulated how it goes about deciding which are the driving conditions of use or the exposure scenarios. It's still difficult to ascertain how that's actually done. That while there's words and you can read them, but in practice, it's a little bit difficult to understand, and especially since, just because of the way the program has been rolled out, there's just a limited set of scenarios what one can consider. And so that leads to a little bit of unpredictability and a lack of understanding by the potentially regulated community as to exactly how EPA goes about making these determinations. Now, I'll just add that notwithstanding the comments they just made, if you just look at the context of what EPA is evaluating, which are high priority chemicals, so you would guess that there is a likelihood that they're going to be found, that they're going to present a risk, and so, meaning as a whole. But the question is, if you are trying to identify what the drivers are, that's where there's going to be a gray area, and so that leads to questions. But I think another area which perhaps is more important is that if you would take the position that EPA didn't have to make a decision or a determination on the chemical as a whole, but rather it had the ability to do it on a condition by condition of use basis, that potentially could allow EPA to be a bit more, if I could say, nimble, if you could use that word for EPA, on moving forward with regulatory actions. If they weren't bound to take action upon the completion of an evaluation of every single use, every single condition of use, but rather it's it's not difficult to envision a scenario where they have a significant amount of data on a substance with regards to use and exposure. And while it's what they have determined is it's not necessarily an imminent hazard, but it definitely warrants attention and they can move forward. So if they were able to make determinations on a condition of use by condition of use basis, so then they could move forward with potential rulemaking and let the other areas lag behind a little bit. But they can't do that now. And so they have to wait until the entire evaluation is done, make that final determination, and then move forward. So I think it sort of it constricts, it handcuffs EPA a little bit in their ability to regulate those scenarios where they think that they might want to do so sooner rather than later.
Thanks. Anyone else want to speak up on that?
Yeah.
I thought you might.
Also, thank you to everybody for putting this together. I know it's a tremendous amount of work, and I actually share Judah's excitement at getting to talk about TSCA because my friends similarly don't want to talk about it as much as I do. So I would push back a bit on this characterization that there is confusion in the risk evaluation documents when they're taking the single determination approach. If you look at these documents, what they do is they actually go through and calculate risk for each of the conditions of use, and then they identify which ones are significant drivers of a finding of unreasonable risk. And so I think it's quite clear when you take a look at the document as a whole for the regulated community what might be coming down the pike in risk management. I also think one practical difference that's really important is that the use-by-use approach doesn't really allow you to look at risks posed by combinations of conditions of use, which is something that TSCA requires EPA to protect against and contemplates that EPA will look at in a risk evaluation. And so if you're looking just piecemeal at the risks posed by a condition of use in isolation, you're not looking at real-world risks from people who are exposed from multiple conditions of use. I think one other quick practical difference that I'll note is that the judicial review provisions end up looking very different if you're doing a whole chemical approach versus a use-by-use approach. And so you could end up actually in this really inefficient circumstance where you have some conditions of use that have been found not to present unreasonable risk that are immediately challenged, are held up in litigation for years, as we know is often the case in the TSCA world. And then the rest of the chemical is sort of proceeding towards risk management. And then what happens if that no unreasonable risk determination was found not to be proper? EPA would have to do it again. So I don't think the efficiencies from a use-by-use approach really, on balance, weigh in favor of that. Yeah.
Another issue arising under the risk evaluation framework rule is the scope of risk evaluations. Under same section 6B4, EPA must, within 6 months of initiating a risk evaluation, publish the scope of the risk evaluation to be considered, including the conditions of use that EPA expects to consider. So, Kelly, maybe you've got a view on this. Does this require EPA to address all conditions of use or only some? And how can EPA efficiently consider multiple conditions of use?
Yeah, so it does require them to look at all conditions of use. There is some discretion that the administrator has to determine what constitutes a condition of use. So it can look at whether it's a circumstance under which a chemical is known, intended, reasonably foreseen to be manufactured or processed or used, et cetera. But once it's made that determination, it can't then say, okay, we're going to take this out and not consider it in the risk evaluation. And so that expects to consider language really just reflects the reality that risk evaluation is a multi-year process. And at the beginning stage, you might not know exactly what circumstances constitute a condition of use. Things might change, uses might be discontinued, information might be provided by manufacturers that put into the scope of the risk evaluation some circumstances that were not known at the time. And so that's really what that expects to consider language represents. This was, weighed in on by the Ninth Circuit. They've confirmed that you can't say this is a condition of use and not look at it. That was in the Safer Chemicals case. Yeah, I'll stop there just so that I'm not filibustering on risk evaluations.
Kimberly, do you have any thoughts on this?
Yeah, let me jump in. And I'm not a lawyer, I'm just a lowly scientist. And so, I think about where you started, Mark, where we have seen the risk evaluation framework change over the last 10 years. And when we think about, I think we all agree that what we'd really like to make sure is that the chemicals that are on the market or that are entering the market are going to be safe for human health and the environment. And we all have that shared goal. We know that EPA has that as their primary mission as they're evaluating chemistries. What is not helpful is when the goalpost changes in the framework rule. And so you don't have an accurate understanding of what the criteria and the data and information that the agency is going to be utilizing to actually determine whether or not there is or is not unreasonable risk. Part of that is definitional. I mean, I know we've had a long-term debate on what unreasonable risk actually means, what's reasonably foreseen, what that means. And then getting to the most recent point on the scope of the risk evaluations, yes, it's critically important to understand where the agency is going to be scoping, what specific conditions of use they're going to be looking at, and then how they're going to evaluate those conditions of use as part of the risk evaluation. One big challenge that we've had in that risk evaluation process is not understanding the scope of the risk evaluation. So which conditions are going to be considered, which conditions are not going to be considered. And while I agree with Kelly that there is opportunities for additional conditions of use to potentially be realized or to be discontinued, it's also left up to the agency to communicate that accurately to the public. Otherwise, they're not going to be able to provide the data that the agency needs to be able to actually inform their decision making. And so when the scope of the risk evaluation changes, throughout the risk evaluation process, and you go into that process providing the agency data on conditions of use that you believe that they're going to be evaluating, and then you see a risk evaluation that includes additional conditions of use that were not included in the original scope, it puts stakeholders, it puts the public at a disadvantage because that data is not available. And oftentimes, because of the finite timeline that the agency has to be able to complete their risk evaluation, you aren't able to provide that data in the timeline that's able to inform the risk evaluation decision making.
One of the hallmarks of the Biden EPA was revising the risk evaluations of the first Trump EPA. The first Trump EPA completed 10 risk evaluations, and the Biden EPA then decided it needed to reconsider most of them. And the second Trump EPA has announced that it's reconsidering 2 of the Biden risk evaluations. Meanwhile, EPA has missed its statutory deadlines to complete multiple risk evaluations and is under a consent decree to finalize them. How should EPA balance the need to improve risk evaluations that it considers inaccurate or incomplete against its need to get things done, to complete risk evaluations in accordance with statutory deadlines, so that it can move on to risk management? Anyone have some thoughts on that one?
So maybe I'll kick us off. So I think that the agency can really look at being very clear on what they need to make their decisions, right? Because timelines are important. I think it's unfortunate that we are 10 years later and we are just barely getting through final risk evaluations of the first identified chemistries, realistically, because they've been revisited across administrations. And that's because there's been changes in the evaluation of the science policy and the data and the framework that they're utilizing. I mean, I think we need some consistency and very clearly articulated frameworks and data requirements that will allow the agency to move forward in a timely fashion and also allow the stakeholders not to be debating, I think, over the course of years about what the process looks like. I think part of the challenge of the timeliness for the agency right now is that the policies keep changing. And so it is trying to get some, solidification in what that actually looks like moving forward, and then be able to utilize that to underlie the evaluations moving forward. Otherwise, you don't get risk management decisions, you don't mitigate unreasonable risk, and then ultimately the public suffers.
Other thoughts?
Sure, I'll jump in. And I think we've seen since EPA started the whole process just about a decade ago until now, that EPA has definitely learned that what they know and what they don't know. And they have learned that the regulated population that they thought is the regulated population isn't necessarily the case, and that there are more people who are brought in, there are more industries, there are more uses. And as we've seen that EPA engaged in a pre-prioritization process where they put out, this is what we're thinking about, step up, and that enables word to get out, and it lets people realize EPA is considering something. And if either affected companies or industries don't want to be put in a position where EPA is moving ahead with an evaluation with what stakeholders believe is incomplete information, it allows people on the front end to get engaged and provide that information. And so I think while we're definitely engaged in a learning process, and that includes EPA and all interested stakeholders, and I think it's clear that EPA has definitely learned that in order for it to complete evaluations in a timely fashion, it means there's a lot of planning involved. And that means getting word out as early as possible so that people can provide information so that when EPA does conduct evaluations, it's done with the most robust set of information that it has.
So it's important for all stakeholders to do their part to help EPA develop the best risk evaluation it can, ideally within the statutory deadlines.
I think that's exactly right, Mark. I mean, this is about coming to the table early with EPA coming to the table with stakeholders, recognizing that these are the chemistries that we plan on evaluating through the prioritization process. This is where we scoped it, so this is where we're going to be focusing our time and attention. This is where we do or don't have sufficient data to be able to inform our decision making. It allows stakeholders to come to the table and provide that data. It also allows them to be able to coordinate better with some of the other federal agencies. So if there are already reviews that have happened, either by another federal agency or by another global agency that have recently evaluated those chemistries, then they might be able to, have conversations with those other agencies to say, okay, well, how did you get to your decision making? Are we using the same data? Is there some data missing in the pool that we currently have? Or is there something that would drive a different decision if there was a specific data point that's missing?
Okay. Well, let's move on to IRIS, a much discussed topic over the 10 years. EPA's Integrated Risk Information System, or IRIS, has produced many detailed hazard assessments of chemicals, including those undergoing risk evaluations. Some IRIS assessments have proven particularly controversial for their science policy judgments. In April 2026, the EPA Deputy Administrator issued a memorandum on the future development and use of risk assessments that said, going forward, regulatory programs, rather than the group that produces or did produce IRIS assessments, will develop their own hazard assessments. And in effect, it ended the IRIS program. Rashmi, what's your reaction to that?
Well, understandably, my reaction is not very happy. Thank you so much for having me. It's an honor to be here as another scientist on the panel. I will try to emphasize the importance of the IRIS program. The IRIS program was established in the 1980s to intentionally separate the risk assessment process from the risk management process. IRIS has, since their inception, generated 572 different hazard values for unique chemicals. And these toxicity values have remained relatively insulated from political and policy influence. They also adopt the most rigorous scientific methods to derive those hazard values. And so it really is within the EPA a jewel of scientific rigor and producing hazard values that can then be used by other programs within the agency. It's also an emblem of government efficiency. When you have one group that is insulated from the political and policy from those influences, coming up with these science-based hazard values, they can then be shared across programs, and it reduces time and resources that are required to derive those values and being replicated by other programs. So for very, very many reasons, the IRIS program is so important to establish the scientific foundations for chemical risk assessment.
Other thoughts about IRIS?
Yeah, I would just uplift one thing that Rashmi said, which is that it really does reduce inefficiencies. And so to the extent that we're sitting here talking about how can EPA meet their timelines better, how can they work towards this backlog of risk evaluations to eliminate a program that provides this information that can be used in risk evaluations, and to instead ask individual offices to do that is sort of counterintuitive.
Kimberly, any thoughts?
Of course, I have some thoughts here.
Oh, my goodness.
So surprising, I have thoughts. So I've spent actually a good bit of my career evaluating assessments that have come through the IRIS program, and I have found that it has lacked scientific rigor and has oftentimes not been transparent in how they have gotten to their determinations of hazard assessments specifically, and incorporating even peer review feedback as part of that process. So while I believe that the original intent of the program was really focused on trying to be supportive and support the agency's work for their risk evaluation processes, I don't think it's been living up to that mission. There has been calls for more than a decade about the challenges that are associated with the IRIS program. And so while we think about how can you do science better within the agency, having the program offices focus in on where they have regulatory needs, where they have data-specific needs that they have to drive decision-making for public health risk, I think that's a better use of the agency's time and resources. Also, I recognize that there is a lot of data that has been generated by the IRIS program, and it has consolidated scientific information, but it has also overlaid some policy decisions that have not necessarily been aligned by other jurisdictions. And so there is, I believe, a way to be able to transition some of that information where you have access to some of the scientific information without the policy overlays that have hindered, I think, the ability of IRIS program to be effective. And I think it is, important that the program offices understand and really have the lead on the data that they need to make regulatory decisions moving forward. Oftentimes as well, let's not forget that IRIS assessments haven't been very timely either. So we've been talking about the TSCA risk evaluations, and we're 10 years later, and we've had just over, 10 or, more assessments that have been completed. Oftentimes it takes more than 10 years sometimes for an IRIS assessment to be generated. So that's not really helping a program office that has to make decisions for a regulatory purpose either. And so I think revisiting and rethinking how the agency generates and it has available information to make their decisions is critically important if we want to get decisions made in a timely manner, and we want to make sure that they're using the best quality science to do so.
I might respond to that quickly and say that just the sheer number of chemicals and hazard assessments that IRIS has turned out really speaks to its efficiency. And you laid out the process of science being responsive to policy, but I will counter that and say that science, especially the scientific assessments that will eventually underlie chemical regulations and protect people and children from harmful exposures, should be insulated from policy and from political decisions. They should be rooted in the best available and most rigorous science, and that is the purpose of the IRIS program.
And I would say I would agree with you that it should be separate and independent from the policy decisions. I don't believe that IRIS has been doing that. I think that realistically, if we look at, for example, the cancer guidelines that allow the agency to use a no threshold approach, and we don't see that enacted by the IRIS except for perhaps one time with chloroform, then that's a challenge when we know for sure that there is data that supports a threshold approach for multiple chemistries that have been adopted by other jurisdictions but have failed to be adopted by the IRIS program. To me, that is a policy decision that is being made. It's not a scientific decision when other scientists in other jurisdictions have looked at the exact same data and made a different decision.
Well, speaking of thresholds, let's focus on a recent risk evaluation from this one on formaldehyde. In the last full month of the Biden EPA issued a risk evaluation for formaldehyde. And a year later, the Trump EPA issued draft revisions that would, if finalized, they're still in draft, significantly change that risk evaluation. These draft changes highlight several science policy issues, as Kimberly just mentioned. For example, the changes no longer rely on the IRIS assessment. They would determine that the cancer of particular interest, nasopharyngeal cancer, has a threshold with respect to formaldehyde based on sensory irritation. And so the draft changes rejected the usual linear low-dose model for this cancer as advanced by the IRIS assessment. The draft changes also relied on an uncertainty factor of 1 for interpersonal variations rather than the usual factors of 3 or 10, and that had significant impact on the risk calculations. So what do these proposed changes mean for EPA's science policies?
So maybe I'll kick us off, and not to get too in the weeds here, maybe we can just keep it at a high level. This is realistically about what does the data tell you, right? And formaldehyde specifically is one of the most well-studied chemistries, and it has thousands of publications associated with it from a toxicological perspective, from an epidemiology perspective, from a mode of action perspective. And so when we look at, you have, an EPA that has evaluated it at one point in time that, again, decided that there was not a threshold approach associated with the formaldehyde data. Given what we know about that chemistry, given what we know about other jurisdictions that have evaluated formaldehyde recently within the last several years and actually identified that there was a threshold, you have to ask yourself, well, why is that data not being considered, or why hasn't there been a scientific debate about it? And this is where I would say, one, that you need to look at the scientific data and you need to understand, does the process that I have allow me to apply a threshold approach, for example? In this case, it does. And what are the reasons that the agency has decided to move away from that threshold approach? And lay that out and actually put that forward to a peer review committee, for example, which didn't happen originally. And so when you have these scientific issues, I would say, that are, I think, significantly debated among a particular chemistry, to not have that raised during a peer review meeting, you get to these points where you have an agency coming back and revisiting those choices. And quite frankly, revisiting choices back and forth across years doesn't really help anyone. We want everyone to start with the first solid, highest quality science from the beginning and being able to move on those decisions because we have confidence in the science has been adequately evaluated. I can tell you from personal experience, having worked on formaldehyde for more than a decade of my own personal career, is that the science does not support not having a linear approach. It really does support a threshold approach in this case.
Rashmi, I can feel you vibrating.
Yes, of course.
Sorry.
Please proceed.
Subtle, am I? Kimberly, you mentioned that there are thousands of studies on formaldehyde. That is true. The chapter is closed. The science is resolved. Formaldehyde is a carcinogen. It's a known carcinogen. It's been classified by multiple authoritative bodies as a carcinogen. Not only that, it's also mutagenic and genotoxic. And these are mechanisms that multiple scientific authoritative bodies have suggested require a non-threshold approach to assessing cancer risk. You can look into the literature, you can look into these authoritative statements. These are decades-old conclusions. This is not new science. Formaldehyde damages DNA as a pathway to the cancers that have been underscored by IRIS assessments and then peer-reviewed by the NASEM. It was not a standalone IRIS assessment. It took multiple years to complete, multiple rounds of peer revision, and then it was also peer-reviewed by the National Academies of Sciences, Engineering, and Medicine and endorsed by the NASEM. I don't know what more robust of a seal of approval you need from the scientific community that a non-threshold approach is required for formaldehyde cancer assessment.
I would say that, one of the things that's important that hasn't been mentioned, and again, this is kind of in the weeds, is that what we do know about formaldehyde, specifically in the case of the nasopharyngeal cancers, is that formaldehyde does not get past the nasopharyngeal nasal, right? So it's not moving throughout the body. I mean, there is a significant amount of data that is radio-labeled formaldehyde to be able to demonstrate that it doesn't move through the body. The other thing I think that's important about formaldehyde to know is that our bodies make formaldehyde, right? So we actually need it for metabolism. And so it is important to understand that, if there really was a no threshold approach to formaldehyde, then how is our body able to metabolize it and utilize it? And how are we able to exhale it? And we're all in this room. I think I've exhaled a sufficient amount of formaldehyde that is above what the IRIS value is for formaldehyde right now. And so I don't think anybody here, creating or keeling over from cancer. And so I'd say that, that has to be taken into consideration when we're thinking about whether or not a threshold is actually relevant for a chemistry like formaldehyde that is actually produced endogenously by the human body and required for metabolism.
I might respectfully push back and say that the argument that formaldehyde is required for metabolism is just not going to stand against the fact that formaldehyde is a known carcinogen. It's in multiple consumer products that we encounter on a daily basis, and it's in our environment. It's in the air that we breathe from industrial sources that are not being regulated. Those are not levels that can compare to the minuscule concentrations that may or may not be generated through metabolism of certain compounds. Those are apples and oranges. We need structures to make sure that the formaldehyde that people are exposed to, and especially people who live near facilities that are releasing millions of pounds of formaldehyde are exposed to, are reducing those harmful exposures. The threshold approach is the most scientifically rigorous method to actually coming up with a quantitative value to determine cancer risk. That then will plug into risk management. So there are many steps that come after that, but again, this is becoming a non-science issue. The changes that have been implemented in this re-evaluation of formaldehyde are not science-based, they're policy-based. This is no longer the scientific process.
So Kimberly mentioned that there were other authoritative bodies that have looked at these issues, and in particular, a number of bodies in Europe recently looked at essentially the same database as what EPA looked at, and concluded that yes, formaldehyde does have a mutagenic mode of action in addition to the one that drives the threshold conclusion, but that at low doses, the body's endogenous production of formaldehyde sort of overwhelms the additional aspects of it. On a more general basis, how should EPA weigh the judgments of other bodies outside the United States, such as Europe or Canada, and to what extent should it just make up its own mind?
Yeah, why is EPA even trying to consider those assessments? IRIS is an EPA body that made the conclusion that formaldehyde should be regulated, cancer should be assessed using a non-threshold approach. That is an EPA entity. It was then endorsed by the National Academies of Sciences, Engineering, and Medicine. I don't know why there's any need scientifically to seek out other assessments.
And I would respectfully disagree that there is a need to look at other assessments. I mean, if we just think about scientific discourse collectively, science moves and changes, and the reason why it's so important is that there is a scientific debate like we're having right now. And when there is other data that's available or that has been generated by another jurisdiction, I think it is important, while it doesn't supersede or circumvent the existing agency's authority, I think it's important for them to take that information into consideration and to understand why they might be planning to make a different decision from a jurisdiction that might have just recently evaluated that same chemistry. Because I think if you don't do that, then you're doing a disservice to your own review by not taking into consideration other scientific opinions that have been evaluated at that point in time.
So the December 2024 Biden EPA risk evaluation found that for some communities, the highest risk exceeded the 10 to the minus 6 benchmark, particularly those near releasing facilities. Nevertheless, it did not find that there was an unreasonable risk to the general population. What's the relationship between the risk benchmarks of 10 to the minus 6 for general population, 10 to the minus 4 for workers that EPA has traditionally relied on, and its ultimate goal of determining unreasonable risk?
Well, and again, not to get into the weeds for our audience here, but this is really all about being very clear about what the initial benchmarks are that you're evaluating unreasonable risk by. And so having the agency be very clear that this is the benchmark that we're using, this is the 10x by 4, 5, 6, 7 that we plan on using to determine whether or not there is unreasonable risk and why we've selected that, why that may be different from other scientific jurisdictions that have evaluated that same chemistry and selected a different value, I think is critically important. When that moves around across assessments or is inconsistent across assessments, that's where there's, I think, concerns. And this is true for formaldehyde, but realistically, that's true for any chemistry that might be going through this process. When you don't have very clear benchmarks or a priori criteria when you're evaluating chemistry, it's very hard to understand when something is likely going to be an unreasonable risk and when it's not, and when there's realistically data or gaps that are missing that might need to be filled to address that question.
Yeah, I agree with that. So this is actually something that we've been seeing. This has become something of a moving benchmark, a moving goalpost. So traditionally, as Mark noted, 10 to the negative 6 was used as the unreasonable risk benchmark for cancer risks for general populations. I'll call it 1 in a million because I'm not a scientist and I don't like talking about scientific notation. But the 1 in a million benchmark has been traditionally used. It is something that EPA in the fence line assessment methodology, the fence line screening methodology, it endorsed that. The SAC has endorsed it. It is now shifting. So in the 1-2 DCA risk evaluation, for example, using that 1 in a million benchmark, EPA found that some 80,000 people would be exposed to lifetime cancer risks that are unreasonable. Instead of actually finding that those risks are unreasonable to the general population, instead it said, actually, for general population, we're using a range now. We're going to say anywhere between 10 to the negative 4, 1 in 10,000, to 10 to the negative 6, 1 in a million. And so when you do have these moving goalposts, what you end up having is arbitrary decision-making that doesn't protect communities and ends up with risk management rules that are going to leave people who are living near these facilities exposed to elevated cancer risks. I'll stop there, but I have more to say on this. Go ahead.
I agree with you fully, Kelly. I also agree with you, Kimberly. There can't be moving goalposts when it comes to determining cutoffs for when you consider a cancer risk unacceptable. Find the cancer value using a non-threshold approach, but there are certain levels at which you need to start reducing exposures because there are appreciable risks to the population. The 10 to the negative 6 or 1 in 1 million benchmark, the context behind that is it actually originates from as early as the 1980s. The Clean Air Act actually has language about EPA striving to reduce exposures when the risks exceed that 1 in 1 million benchmark. This is EPA's own language. It has rightfully so been the practice to come up with regulatory action after risk exceeds that 1 in 1 million benchmark. And unfortunately, as Kelly was mentioning, that goalpost is moving and it's becoming inconsistent. And that is not good for public health.
So June 1, last week, marked the 1-year anniversary since the oral argument in the methylene chloride case. During that, and we don't have a decision yet, during that oral argument, one of the 3 panelists asked the EPA advocate, where did this 10 to the minus 6 threshold come from? It was as though they'd never heard of it. It'll be very interesting to see what that decision, if it ever does come down, has to say about this question. Let's move on a little bit. EPA must make risk determinations without regard to cost or other non-risk factors. What factors other than risk calculations, like 10 to the minus 6, if any, should enter into a risk determination?
So I can kick us off. I do want to mention that 10 to the negative 6, we've sort of been talking about it as though it's this bright line rule, and EPA has expressly said that it's not going to be a bright line rule. And so what they have ultimately done in practice is if they find risk that is exceeding that benchmark, or in the case of non-cancer risks, it's actually below the benchmark MOE, which is very confusing when you're drafting and proofing all of these documents. What EPA has essentially said is that will not be a bright line, but if you find risks that are exceeding the benchmark for cancer, they'll find a reason to call it no unreasonable risk, but they won't ever do the opposite. So if you find something that is slightly below the benchmark for cancer or slightly above for non-cancer risks, they'll just say, okay, that's fine, the chemical passes. And This is really problematic because you can't have this one-way ratchet where it's a bright line only for certain circumstances and not for others. And I will just say that this does seem to comport with some of the reporting that we've seen recently. There was this really great article from CNN from Renee Marsh a couple of days ago that talks about how scientists in EPA are being pushed to find no unreasonable risk, even if you have risk calculations that initially do appear to pose unreasonable risk. So I wanted to just clarify that when we're talking about this, how this benchmark is really treated.
Yeah, and maybe I can come back to that because, again, this is all about good science, high quality science and data that the agency can rely on, and being able to have a process that is very clear and accurate to the public as they look at it, and also to the risk assessors within the agency, because you want to make sure that they're following the same processes as they're looking or doing assessments overall, right? So if we, stick to what you mentioned, Kelly, about the changes in the margin of exposure related estimates, or what the agency considers their bright red line or not bright red line. I mean, yes, there is likely flexibility in what the agency is doing associated with a margin of exposure, but articulating that very clearly to the public, I think, is important. I think the other thing that we were debating about earlier was the threshold approach, right? And so there's always going to be a scientific debate among the scientific communities about whether or not a chemistry is or is not a threshold. And so, one of the things that, the agency could also be doing moving forward is when there is sufficient evidence on both sides of those is to present both of those so that the peer review panel and the public can actually provide content and feedback on that process. Instead of making a unilateral decision that will likely get arbitrated again, either through the scientific community or litigated at some point in the future. I think it's more efficient for the agency to be able to present that data and be able to say, well, we've looked at both cases and we're presenting that to our peer review community for this assessment. We're also presenting it to the public for comments on that about whether or not this makes sense or not and why.
I do have some skepticism that EPA will, if they're saying that they don't have the resources to consider, for example, all conditions of use as the law requires, that they're going to do risk analysis of all conditions of use using multiple PODs to derive the benchmark MOE.
I want to also elevate something that Kelly said previously, which is this departure ultimately from the scientific process. We've been seeing this very troubling trend, and this is, I have personally poured through the probably over 1,000 pages of technical risk evaluation documents at this point, task risk evaluation documents, and over the course of the last several years, there's a disturbing trend where risk assessors, and you can see this clearly in the narrative, are denying existing scientific evidence, dismissing conclusions of unreasonable risk, with no real scientific rationale. This is now reflected, as Kelly was mentioning, in the CNN article that just came out and in the peer article that just came out, that risk assessors in the current administration are being trained to find ways to come up with no unreasonable risk conclusions. This is no longer science. This is not the scientific process. This is storytelling. And I think that was actually a word that was used in the training video, is that risk assessment is a storytelling process. It is not a storytelling process. It is a quantitative, rigorous science assessment that then supports regulation that protects all of us from harmful chemicals. This departure from the scientific process into a storytelling risk assessment narrative is the most dangerous issue that we face right now.
Now that we've got that issue resolved, let's talk about peer review. Peer review is expressly part of the statutory requirement for the use of best available science, but at least in the case of formaldehyde, there were a lot of criticisms of the peer review process. What suggestions do you have for improving the peer review process?
I mean, I think there are some just base level suggestions for any peer review process. One is just to get the information out early. So to have a very clear understanding of what the charge of the peer review committee is and what the scientific questions on the table are, and be very clear of what you're asking that peer review committee to do, as well as for the public when they're providing comments in. I mean, if they're, in the case of formaldehyde, where we were just going back and forth about threshold or non-threshold approach, about uncertainty factors, about margin of exposure, when there are very key scientific issues like that on the table, being very articulate in presenting that to your peer reviewers so that you know that these are where we're looking. There's scientific debate on these issues. There's clear misdirection, misunderstanding about these in the scientific community, and we'd like to get an opinion from our peer reviewers on EPA's direction here. I think sometimes what we see in some of these peer review processes is that while there is lengthy charges, it kind of just gives a lot of wiggle room, right? And it's like you have a peer review panel of, 15 people, half say this, half say that, and then it meets somewhere in the middle versus having a real scientific debate about a specific scientific issue and then having what we would call a firm recommendation to the agency about how they believe the agency should move forward. A lot of times the agency has a lot of purview because it's fairly ambiguous in some of the peer review reports on what they should do. And so having the peer reviewers have a much stronger opinion about how they should move forward, I think might be helpful. Again, a lot of the times the information actually is not released out to the public very early in some of these peer review processes. Sometimes the peer review are very truncated. I mean, we know the agency's resources are relatively limited, and sometimes they have in the past, over the last 10 years, been evaluating multiple chemistries over the course of a week, which has presented a challenge for the agency as well. And then a lot of the materials oftentimes I think don't necessarily go out to some of those peer reviewers early enough, and so they don't really have sufficient time to really evaluate the materials before they get into the meetings.
So the TSCA program has the Science Advisory Committee on Chemicals, or the SAC, which is its designated scientific peer review committee. It's congressionally mandated under FACA. This committee is, and I agree with you that scientific peer review is an essential part of the scientific process. You need to have scientific debate. Multiple opinions should be weighing in on the scientific peer review process. However, that process should also be insulated from policy. Scientific peer review committees now, especially the SAC, we're seeing many members being nominated with financial conflicts of interest, direct financial conflicts of interest with the industries that manufacture the chemicals that are being regulated or being considered in those scientific assessments. One of the biggest improvements that can be made to the scientific peer review process of TSCA evaluations is to eliminate financial conflicts of interest on the SAC.
And there are conflict of interest and biased policies as part of the SAC process,
So one of my favorite acronyms in the TSCA area is NAMS, because I can never remember what NAMS stands for. It has to do with animal testing, or alternatives to animal testing. The 2016 amendments included Section 4H, which directs EPA to help develop alternatives to tests on vertebrate animals, such as computational toxicology and bioinformatics and high-throughput screening methods. Last week, EPA announced their approval of 13 new alternative test methods to replace the use of animal studies, also known as New Approach Methods, or NAMs, and solicited nominations for additional NAMs. What's the significance of these developments for risk evaluation?
So maybe I'll kick us off. And I'd say, one, NAMs are very promising, but we also have to make sure, because I think we all would prefer to use less animals for regulatory testing overall, which is what the NAMs are supposed to do. They have to be predictive though. So we have to be able to have confidence in the fact that when you test a chemical through a NAMs process, that any of the results, whether adverse or negative results that you get, that they are actually predictive of what you likely see in an in vivo model or a human model. I think a couple of things there. I mean, the ACC, who I am employed with, we have a long-range research initiative that we've done a decades-long work for NAMs-related research in coordination with multiple stakeholders. We also know that the National Institute of Health Foundation has a NAM validation effort that has been going on as well, where they're looking to pull stakeholders together so they can get a better understanding of the NAMs that exist and be able to validate those approaches so that they actually improve regulatory decision-making moving forward.
I will say that we're at a critical point when it comes to new approach methodologies. As Kimberly said, they do hold promise in terms of rapidly screening chemicals for toxicity. That's one of their many advantages, is you can put multiple chemicals into a high throughput dish. I'm probably getting very technical now, but there are many advantages to new approach methods. We eventually will need to move away from animal testing. That is the reality. However, we're not there yet. The policies are preceding the science. There are policies now that NIH just released last year that now require NAMs to be a component of any federally funded grant. This means that you can't just run an animal toxicology study and get that funded by the NIH anymore. You have to incorporate an element of NAMS. So we are going to be generating a lot of NAMS data as a scientific community. There are not significant guardrails or policies in place for the implementation of NAMS in decision-making to result in health protective rulemaking. And I will detail a little bit on the kind of disturbing patterns that we've seen within the agency on the implementation of data from NAMS. In the Office of Pesticide Programs, we've seen NAMS being used to downplay neurodevelopmental toxicity risk for a class of pesticides called organophosphate pesticides that we've known for decades cause neurodevelopmental harm in infants and children who are exposed. We've also seen in recent risk evaluations where NAMs are being used to replace existing animal and epidemiologic evidence when there was existing high-quality cancer bioassays, for example, showing the potential for p-dichlorobenzene to cause tumors in rodents. That was dismissed using pathways that were derived from new approach methods. There's an industry-derived framework called the RECAP framework, which is now being used to waive the need for cancer assessment altogether in TSCA risk evaluations, waive the need to look at cancer based on a NAMS-based framework. These are not health protective implementations of NAMS. NAMS do have promise. They are probably the future of toxicology and of risk assessment, but we don't have the structures in place to prevent agencies like EPA from using NAMS to downplay risk and hazard, and that is another danger that we're facing.
Thank you all. We've talked to some degree from an industry perspective and from an NGO perspective, but another group of stakeholders in risk evaluations is federal agencies. Under Section 9D of TSCA, in administering the statute, EPA must consult with other federal agencies. How can EPA do that better than it has in the risk evaluation process? For example, how should EPA consult with OSHA on assessing workplace exposures? Judy, you want to start us off?
Yeah, I think I'll just pick up on something that I mentioned earlier, which is the earlier you start doing things, the better. And I think as we've seen with some of the evaluations, particularly where it came to concerns that were raised in aerospace and defense industries, where in the end of the day, it was the Department of Defense that had to directly engage with EPA because they believed EPA didn't fully understand the extent to which certain substances were used and the criticality of those in national defense, for national defense purposes, that if there had been that engagement earlier on, it would have prevented the slowing down of the process. And so, to that end, and as I mentioned before, I think EPA is learning this, to engage on workplace exposure issues with OSHA earlier, to get them involved in the process, and not necessarily even OSHA, but also just in those areas where there are bodies that have expertise in that area, they should engage. But clearly, there are going to be other agencies that have either regulate uses or involved in uses which will be affected by EPA action. And so to the extent that EPA doesn't come to a decision and then run this by other agencies and say, hey, are you good with this? It'll save them time and angst and having to rework things if they started that process, the consultation process, at the beginning, the same way as I mentioned before, that just to get stakeholders involved early on in the process.
Other thoughts?
Yeah, I would echo what Judah said. I think at the beginning of the process and prioritization and scoping, it is really important to get the other federal agencies engaged during that time so you can understand the conditions of use that they're using that particular chemistry in and why, for example, and any data that they might have already generated associated with that. The other part of that is what Judah mentioned, which we haven't talked a lot about here, is on the workplace exposure. So workplace exposure assessment specifically is an area that hasn't been well seeded by EPA in the past. And so it's really something that is very new to them over the last 10 years of really doing occupational exposure related assessments. So when you have agencies that have experience in this and that have been doing occupational exposure assessments for a long time, it's beneficial for EBA to tap into some of that experience, to understand what kind of workplace assessments they do and why, what approaches they've utilized in the past and why they've utilized those approaches. It doesn't mean that EPA has to adopt wholeheartedly that assessment approach, but it is important that if there's already expertise that exists with other federal agencies, especially expertise that is not currently housed within the agency, that they leverage and utilize that moving forward so they can make better decisions going forward. The other piece of this is on the compliance. And so while I think there's the panel next is going to get into risk management, you also need to make sure that you understand when you're making decisions about the risk evaluation process, are you going to be running counter to risk management practices that already exist with another federal agency like OSHA? And understanding where there might be discordances or challenges in compliance with that and having that conversation early so that the agencies can talk through what is the mechanism for risk management compliance associated with an unreasonable risk determination and how they can move forward so you don't have miscommunication or duplication in regulations among two agencies that might be disparate or different.
So just on that point, I do think there are I think consulting with other agencies for their data early makes sense. I think there are some sort of limitations on that, though, and some guardrails that EPA should be implementing, which is not just merely looking at what regulatory limits there are, for example, but actually looking at what emissions or what exposures are actually occurring. So we know that there are often emissions limits for certain chemicals that are regularly violated. And so just a flag of caution that EPA shouldn't just say, okay, well, under the Clean Air Act, this is the amount of this HAP that is allowed to be emitted, and saying that's enough, that's all we have to do for looking at exposures. I think the only other piece is that I don't think that comparing risk management approaches is really appropriate at the risk evaluation stage. That's something that comes later. And so while I think it's important to have early engagement, I would just put a flag of caution that anything that would get into the non-risk factors that are driving risk evaluation and driving a risk determination would be inappropriate.
And Kelly, let me just weigh in that I didn't want to conflate both the risk management and risk evaluation. I was just mentioning the risk management as the second piece of an opportunity for coordination with the federal agencies.
Yeah.
So EPA's authority to collect fees to support risk evaluations in Section 26B is going to expire at the end of September, unless Congress acts to extend it, and there'll be a panel talking about legislation. But EPA's current budget request to Congress calls for reducing TSCA funding by eliminating 61 full-time equivalents, and also the money to pay them. So EPA is going to be looking at less money to conduct risk evaluations, which raises the question, how can EPA reduce the cost of risk evaluations and reduce the time needed to complete them?
So maybe I'll weigh in here. I mean, I think obviously I'm not in a position, and none of our stakeholders are on the stage, to speak to what Congress will or will not give the agency and how the agency can or cannot use the resources that it has. But I mean, I think one of the things that's probably most important is that the agency needs to be able to have the science and data that it needs to make the right decision to move forward in the risk evaluation. And so they need to think about if there are efficiencies in their process that don't compromise the science, that don't compromise the data, that allow them to move more efficiently, then those are things that they may be able to look at. But I think we all want to make sure that there's high quality risk evaluations moving forward and that the agency is able to do that in a timely fashion.
I'll be the broken record. It's the same thing that I think we've all been agreeing upon throughout the entire panel, is that EPA has to engage early and often. And if they're able to get as much good quality information that they can on the front end, it'll just make the process move smoother. And as I said, also, I think they're learning that, but it's a process and it's just going to take time.
I've mentioned throughout the panel several improvements that could be made to the scientific process of TSCA risk evaluations. I want to emphasize that these improvements will not cost more money or take more time. These are, simple, in some matters, Excel spreadsheet calculations that EPA can be adding on. Starting the process of risk assessment with a rigorous systematic review is probably the most beneficial thing that the agency can do to improve efficiency. They start off with a complete evidence base, all of the reasonably available information that they can obtain to make hazard and risk determinations down the line, early and very early in the process, ideally. Starting off with the most amount of rigorous scientific information that's then evaluated in a rigorous way is the most efficient way to result in a health protective risk evaluation.
I agree with that. And I think to add to that, not excluding exposure pathways or known conditions of use at the front end of a risk evaluation, so you don't end up in a situation where the Biden administration, for example, had to then go back and look at exposures to 1,4-dioxane that had been omitted from the initial Trump 1 risk evaluation.
Well, I've learned a lot about risk evaluations, and I want to thank this distinguished panel for all your thoughts and contributions. And I encourage you to remain in the audience to the extent you can, because there's lots of interesting stuff to come ahead. With the next panel on risk management starts in about 30 minutes. I think we've got a break now. So thank you all.
Thank you so much to our speakers. Thank you to Mark, Rashmi, Kelly, Judah, and Kimberly. We so appreciate you all being here. We will now get started right with our second panel, which is on risk management. Moderating this panel, we have Martha Marapice, who is a partner at Wiley Ryan. She's a recognized leader on TSCA matters. Martha provides strategic counseling to clients on how to navigate TSCA's NCP effectively, negotiates consent orders on their behalf, and advises on how to best practice confidential business information in TSCA submissions. She assists clients as they navigate EPA's existing chemical prioritization, risk evaluation, and risk management processes, and advocates for reasonable workplace requirements associated with their condition of use. She's also on our TSCA Reform Conference Steering Committee. Martha, I will turn things over to you to get us started. Thank you so much.
All right. Thank you. And welcome, everybody. And apologies in advance to the folks over on the side. I have my back turned to you a little bit. But we want to, I've been just excited to be part of the steering committee for this event. 10 years is a big deal. And we're going to talk about risk management in this panel discussion. With me to have the discussion, we have Keith Bradley, who's a partner with Squire Patton Boggs, and Marissa Smith, PhD, senior regulatory toxicologist with the Washington State Department of Ecology, on the screen with us today. Here next to me in the room is Bob Sussman, who's principal with Sussman and Associates. Next to Bob, Reagan Gieschenschlag, who's director of chemicals, materials, and sustainability policy with the National Association of Manufacturers. Next to Reagan, the Honorable Michal Friedhoff, PhD, Senior Policy Advisor with Holland and Knight. And next to Michal is Randy Rabinowitz, who's Executive Director of the OSH Law Project. We've asked Michal to kick off our topic today. So Michal, I want to turn it over to you.
Thanks. Well, hi, everybody, and thank you so much for the invitation to this annual gathering. This is the time of year when my social media kind of explodes with reminders on a near daily basis of pictures memorializing TSCA votes, the White House signing ceremony, the many TSCA parties we had after the bill was, finally finished, the first major rewrite of an environmental law in a generation. It's really hard to believe it's been 10 years. And of course, none of us look even the tiniest bit older. So I always think when talking about where we are and where we're going, it's good to start with a bit of the past. The original 1976 TSCA, like so many of our bedrock environmental statutes, was born of decades of our collective failure to manage the way chemicals were used, made, and disposed of. After trees in the Love Canal neighborhoods turned black and people started noticing that their kids' hands were burned when they came inside. After the Cuyahoga River caught on fire more than a dozen times. After cancer clusters in communities surrounding old factories started to be found. After about 20 million people participated in the first Earth Day in 1970, and after Richard Nixon created the EPA later that same year. And I think it's important to remember that as Congress was writing some of our other bedrock environmental laws, like the Clean Air Act, the Safe Drinking Water Act, it was the Nixon administration that asked Congress to write what ultimately became the Toxic Substances Control Act, saying, quote, "We should no longer be limited to repairing the damage after it has been done, nor should we continue to allow the entire population or the entire environment to be used as a laboratory." There's been a lot of debate about what 1976 TSCA did or did not include, and what 2016 TSCA did or did not change. For example, I've heard people insist that workers were never part of the original TSCA. But that's simply not the case. The truth is they were there from the start. When the head of the Nixon administration CEQ testified before Congress on the need for the law, he used a few different examples related specifically to workers. For example, he talked about how vinyl chloride had been on the market for decades before it was classified as a carcinogen, after a number of workers had already died of the rare liver cancer that it caused. The original 1976 law even had language in it that ensured that if EPA regulated a workplace use of a chemical, that wouldn't trigger the preemption of the rest of OSHA's rules related to the safety of those same workplaces. And as much as we all know about the famous court decision striking down the asbestos ban that tied EPA's hands on existing chemicals until the law was rewritten, you can go onto EPA's website and see some of the rules they wrote that weren't struck down. There are several TSCA rules from the 1980s that are only about workers. So, and of course, although OSHA has written some chemical-specific safety rules, many of them date from the 1970s, and their webpage, at least at one point, said that those rules were outdated and inadequate. That's a quote, to protect workers' safety. So for those who think the 2016 law is the only reason why worker safety has been front and center for EPA's TSCA risk management work, that's just not the case. Worker safety has always been a central focus. But it's useful to talk about what did change in 2016. Congress just didn't want EPA to regulate single uses of chemicals anymore. It wanted a comprehensive scientific look at the way each chemical was made and used, and then a comprehensive safety solution. In fact, we had to write specific provisions to allow EPA to move forward with several single-use rules that it was almost ready to propose. Provisions EPA actually came to Congress and asked us to write just to be sure that our new comprehensive risk evaluation and risk management system wouldn't prevent them from quickly addressing some pretty significant risks for chemicals like methylene chloride and TCE. So for those who believe that EPA has the discretion to categorically exclude uses from its review, whether that's risks from drinking water or air emissions, risks to workers, risks to consumers, or risks for risks to communities, I'd say the legislative history really doesn't support that view either. I simply don't think that a systemic failure to protect consumers, communities, and other potentially exposed subpopulations is legally defensible or consistent with the chemical safety goals that Congress had. That said, with all 5 Biden-era chemical safety rules still under litigation, and with 0 proposed, revised, or finalized rules in the Trump administration, there's also a lot that's unsettled, and more I think that EPA could do to shore up its rulemaking efforts. So first, there's been a lot of debate about the way the use of PPE is considered. It turns out the first Trump administration OSHA told the first Trump administration EPA not to consider the use of PPE when making risk determinations, and the Biden administration adopted that policy. I still think it makes sense, especially because when you look at OSHA's top 10 list of most violated safety rules, PPE is always on it. So information reasonably available to EPA generally doesn't support assuming that PPE is always provided and appropriately used. And in fact, no OSHA rules allow routine reliance on PPE use. It can only be used when other ways to reduce the risk are exhausted. I do strongly agree that in risk evaluations, EPA should analyze whether PPE mitigates the unreasonable risks it finds and tells everyone what they found. And to that end, I thought the risk communication in several draft or final risk evaluations released earlier in this administration did a good job at saying, yes, we found unreasonable risk, but you can see it goes away or gets smaller when PPE is used. Second, there's still considerable debate about whether a risk determination should be made for the whole chemical or separately for each use. I can tell you that we believed there would be a single risk determination for the whole chemical substance when we were negotiating the law. But I also acknowledge that we didn't game it out precisely. I think that a requirement to make separate use-by-use determinations could make it difficult for EPA to make a determination that aggregate exposure from multiple uses of a chemical pose an unreasonable risk if each individual risk does not. I also think it could complicate EPA's ability to effectively regulate consumer uses if it also found that distribution and commerce to consumers or retail establishment for sale to consumers did not pose an unreasonable risk. So there's an area that I think there is the most opportunity for EPA, industry, and labor to work collaboratively is to further flesh out what an effective and implementable worker safety program might look like. When I was at EPA, we entered into an MOU with OSHA in the hopes of doing that, but I think more work would benefit everyone. More could be done by industry to make sure EPA has a complete understanding of the way chemicals are made and used, including the way workers are protected. More could be done by EPA to sync up the timing associated with required and follow-up error monitoring with any similar requirements that OSHA has. More could be done by EPA to consider how a facility that makes or uses more than one TSCA-regulated chemical at the same time could comply with more than one TSCA rule at the same time. And more could also be done by industry to ensure EPA has usable air monitoring data for specific uses in order to support any assertion that whatever EPA is proposing can't be done. Finally, I think it's important to remember why the risk evaluation and risk management system was needed in the first place. It was because in 1976, Congress grandfathered in tens of thousands of existing chemicals without requiring any further review under TSCA. So for decades, as other environmental laws were used to clean up the air, water, and land, TSCA did nothing to prevent more contamination from occurring in the first place. In 2016, Congress was clear that it wanted the TSCA existing chemicals program to be a conveyor belt that imposes the necessary protections for a chemical and then moves on to review and regulate another existing chemical until EPA was done. But with only 5 existing chemical rules on the books and no apparent progress on proposing or finalizing new rules in the past year and a half or so, I'd say the conveyor belt isn't working terribly well right now or terribly quickly. I hope that changes. I'd also say that whether you're a company that wants federal chemical safety rules in order to avoid different state laws, or you're a worker who rightly doesn't trust an OSHA rule written more than 50 years ago, or you live somewhere that's surrounded by industrial facilities, or you worry about the chemicals that might be in the toys your kids play with. We were all invested in building a credible federal chemical safety program 10 years ago. And I hope that we remain just as invested in that same goal for the next 10 years and beyond.
Thank you, Dr. Friedhoff. We're now going to start with our panel discussion. And as you all should know, Dr. Friedhoff led the TSCA program for several years in the Biden administration as Assistant Administrator of OCSPP. And given the case that Dr. Friedhoff has made in her opening remarks, a compelling case for EPA's workplace authority, I'd like to ask our panelists if you agree with EPA's approach today to protecting workers in Section 6 risk management rules. Or has EPA taken an overly expansive role in regulating the workplace? And should it pull back? Randy, would you like to lead off?
Yes, I'd be glad to. Thank you for having me. And I just want to preface my remarks by saying they're my own thoughts as someone who's practiced occupational safety and health law for more decades than I care to admit, and not those of my clients. So I think that EPA has done a generally good job in mirroring OSHA's approach to comprehensive health standards. And by that I mean for the 35 to 40 chemicals for which OSHA has adopted comprehensive health standards, each has followed a pretty similar pattern of setting an exposure limit, setting an action level, requiring certain monitoring protocols, initial monitoring, periodic ongoing monitoring, depending on how high a level the initial monitoring identifies, reliance on the hierarchy of controls, limited use of respirators, except for a handful of operations where engineering controls and work practice controls may be infeasible. And I think EPA has done a really good job of incorporating that model. The EPA risk management rules differ from the OSHA rules in a couple of respects, which I don't think are inconsistent. So the first respect that they differ in is the ECHLs are substantially lower than OSHA's PELs. And there's a good reason for that. The first is OSHA has never been able to reduce a risk below the level of 1 in 1,000, and EPA has set its target for unreasonable risk at 1 in 10,000. So of course the levels that EPA sets are going to be an order of magnitude lower than the lowest levels OSHA's been able to adopt. But for the most part, OSHA's exposure limits were based on science from the 1950s and the 1960s and consensus standards that were in existence in 1970 when Congress grandfathered them in, and they have not been revised since. EPA is working on 50 more years of science. And so we would expect that there would be differences in what the outcomes would be. So I don't think having a lower exposure limit it makes it any different. It's not an exposure limit that OSHA will be able to enforce, at least under the current regime, but it does require compliance by industry. And I think the two other major differences are OSHA comprehensive health standards all include medical surveillance requirements. EPA's do not. And EPA lacks, I think there's a consensus that EPA lacks the authority to require medical monitoring in workplaces. And then the second, the more notable difference is when OSHA sets a standard, it does an industry by industry evaluation of what controls can be expected to be incorporated. And the courts have said that when OSHA does that analysis, it gets a presumption that its exposure limit is feasible and can be met without respirators. EPA is not doing that level of use-by-use analysis of the way in which different industries are likely to comply. So EPA has left it up to employers to do the analysis themselves, which I think gives employers more flexibility to reach an outcome that differs from the ECHL. But it does shift the burden onto employers to do the analysis and figure out what the the limits of engineering and work practice controls are before they implement respirators. I would say that one other significant difference, and I don't know that this has real impact for risk management, but OSHA rarely quantifies non-cancer risks. OSHA quantifies one risk, usually cancer, and if it hits the 1 in 1,000 mark, it doesn't quantify anything else. EPA has set about quantifying most of the hazards that they find, and in a number of risk evaluations, it's the non-cancer risks that are driving the risk management and not necessarily the cancer risks. And so the couple of other differences, significant differences, are EPA is covering all owners and operators. So OSHA is an employment law. It's not a chemicals law. So there have been a lot of debates under OSHA about how you deal with leased employees or independent contractors or other people who may be on site but don't report to the owner of the work site. That's not an issue under EPA because they're regulating owners and operators, and their rules are not tied to the employment relationship. So I guess that's my assessment of how that EPA has done a pretty good job of following OSHA. And I would say that the two agencies are talking a lot more than the last panel suggested. It's just that they're talking privately, and EPA is not publicly disclosing the nature of those discussions. So.
Thank you. Those are great perspectives. Do other panelists have additional comments on the EPA-OSHA relationship?
Yeah, definitely. On behalf of manufacturers, I think that conversation between EPA and OSHA, it would be beneficial if that was more transparent and provided in the record so that the manufacturers or the industry can have more insights onto OSHA's input into those risk management rules when those options are being considered. I think generally my view is that there is room for improvement, and I think Dr. Friedhoff hit on some of those areas in her remarks for EPA's approach in risk management rules. Some of that would be it would be more transparency and more consistency, maybe a framework or reliable rules of the road so stakeholders know what to expect and what information should be provided to the agency and how those risk management, EPA is picking those tools to address that unreasonable risk when it's identified. What I've heard from some of my members are inconsistencies in some of the risk management rules that we've seen so far, creating confusion and increased complexity that makes it difficult to implement at the facility level. Some of those are differences in monitoring cadences, which you mentioned, acceptable PPE, compliance timelines, and maybe treatment of impurities or byproducts. And that makes it challenging, and you highlighted this as well, when a facility is trying to comply with multiple of the risk management rules that we've seen. So it doesn't necessarily mesh with the holistic workplace safety approach that these EHS professionals or industrial hygienists are accustomed to implementing at the facilities that they're, considering and trying to protect their workers and then comply with the necessary regulations, having a single plan for a specific chemical when multiple chemicals are used in the workplace.
Did you want to say something about it?
Yeah, just quickly, I wanted to reinforce Randy's point that there is considerable alignment between the framework that OSHA historically has used to regulate the workplace and the framework that we see in the 5 risk management rules that Michal described, and so I would caution all of us against leaping to the conclusion that EPA is somehow creating a whole new scheme for workplace protection, which has no resemblance to what OSHA has been doing for a very long time. I think the level of alignment is pretty high. Now, there are differences, and those differences, I think, reflect differences between the two statutes, as Randy was saying. And the biggest difference in my mind is that the OSHA Act is based on the concept of regulating to the limit of feasibility. And the TSCA risk management framework in Section 6 is an unreasonable risk framework. EPA must identify whether the substance poses an unreasonable risk, it cannot take into account cost and non-risk factors, and then it must do what is required to eliminate the unreasonable risk. That's a very different approach from the feasibility approach that we are seeing on the OSHA side. But I just want to emphasize that some people are making the assumption that we have a real serious and fundamental problem because EPA is regulating the workplace after years of OSHA regulation. And I don't think we really have a problem. And in fact, in some ways, from the standpoint of worker protection, we have the best of all possible worlds here. And I think the 5 risk management rules are pretty compelling evidence that EPA is using TSCA to materially improve protection of workers.
So Martha, can I just add one quick comment? I would agree with Reagan that EPA should disclose some of the comments it gets from OSHA and NIOSH on both risk evaluation and risk management. I would also add that my clients have tried to introduce those in court, and at least many of those comments during the first Trump administration disagreed strongly with the approach EPA was taking to risk evaluation.
One piece that I would also like to add on the general alignment with OSHA's approach, I think when it's not fully consistent, that does create, or at least from what I've heard, creates a lot of confusion with those safety professionals trying to implement OSHA's requirements and TSCA risk management rule requirements. So when wording is just slightly different, right, and you're looking at your risk management plan, those are kind of interpretations that those safety professionals are having to take on and slice how to put their safety plans together at the facility. So I think more consistency, especially around like definitions of terms and those areas, could be really beneficial.
Can I add just a couple of thoughts? One is that although the sort of the concept of an ECHL, the concept of an exposure limit, and then you have to engage in controls to keep below it. That is obviously similar to how a lot of OSHA standards work. The devil is in the structure and the details. So one thing is the holistic approach that EPA is attempting is massive. To say I'm going to write down any given chemical. And I should, by the way, I should preface, as Randy did, these are my own thoughts, not those of my clients, not those of my law firm. But to say I'm going to take this chemical and I'm going to write one rule that just covers how it gets used across everything. I took Randy's point that it's on the employer now, different from the OSHA regime. It's on the employer to say how we use it. But in an environment where there's a lot of skepticism on all sides, I don't think EPA trusts industry. Industry doesn't trust EPA, and there's in the Third Circuit right now, there's a case which is largely about whether EPA was whether it was proper to lump in a particular form of recycling and whether they had adequate reason for that. It's like a failure on the the industry's allegation is a failure to recognize that X is sufficiently different from Y and should be treated differently. In the OSHA framework, that kind of discrimination between different usage situations and different workplace models is very normal and natural, and the holistic approach tends to sweep that under the rug, even without intending, because it is such a massive undertaking. The other thing is that even if you wrote the same rule, and obviously, although as Bob said, it mirrors OSHA. We've also heard that it mirrors OSHA, but then they write the EPA will tend to write the standards much tighter. The enforcement mechanisms are so different under TSCA from what they are under the OSH Act that it is a different regulatory regime, even if the content of the regulation were the same.
Thank you, Keith, and thank you to all the panelists for addressing this topic. It's really front and center for risk management under TSCA. So we wanted to make sure we aired many of the issues for you today. I'd like to turn, if we can, we have a tremendous opportunity today with the panel because we have 3 attorneys with us who are involved in the litigation of the risk management rules that have been finalized by EPA. Oral arguments in the asbestos case, Texas Chemistry Council v. EPA, just took place earlier this week, June 1. And so I'd like to ask the panel, as this and other appeals of EPA's risk management rules proceed, how are these cases sorting out EPA's discretion to select from among the various risk management options in Section 6A of TSCA? Specifically, do you think the "to the extent necessary" instruction in Section 6A to address unreasonable risk places any constraints on EPA's authority to ban chemicals rather than to impose less sweeping restrictions? Bob, would you like to lead us off?
Yeah, sure. Well, I participated in the oral argument in New Orleans on June 1st on the EPA Part 1 asbestos rule, and there are multiple challenges to that rule. We have a labor challenge that Randy is spearheading. We have a challenge by the Asbestos Disease Awareness Association, which is my client, and then we have industry challenges, which are being spearheaded by the American Chemistry Council. So the fact that this case is being heard by the Fifth Circuit has enormous symbolic importance, because in 1991, it was the Fifth Circuit that overturned EPA's comprehensive 1989 ban on asbestos. And it was the frustration with that decision and the disappointment that in many respects was a big driver for reworking and strengthening the risk evaluation and risk management framework in Section 6 of the law. So here we were back in the court that had overturned the original asbestos ban, and that court was now 40 years later examining an EPA redo of the original OSHA rule. And let me talk about some of the arguments. I want to focus on the industry arguments. There were really two issues that are that industry is putting in play in that case. The first issue, interestingly, is whether EPA should have referred asbestos to OSHA and stayed its hand. And the second issue, remarkably, is whether EPA went too far in banning chrysotile asbestos, whether EPA should have refrained from banning chrysotile asbestos and instead relied on workplace controls to address the unreasonable risk. Now, from my perspective and the perspective of my client, it's somewhat surrealistic that here we are in 2026 and we're arguing about whether asbestos should be banned in the United States of America when asbestos has been banned by virtually all the developed economies in the world. So This is a kind of back to the future situation. And I think if you look at the industry argument, it is anchored in the language of Section 6 that Martha just mentioned, which is the obligation of EPA under Section 6A to impose restrictions that are to the extent necessary to eliminate the unreasonable risk. And in each one of the cases that are being litigated, a central issue is how that language should be interpreted. In the asbestos case, the industry argument is basically, well, we put respirators on our workers, and there's really no debate that if the workers are wearing respirators, the risk from asbestos exposure is going to be negligible. And so therefore, the additional step of banning asbestos use, particularly in chlor-alkali plants, was unnecessary to eliminate the unreasonable risk. And the EPA rejoinder in the litigation, and I think the policy response of EPA in the rulemaking is we're dealing with a chemical that is uniquely lethal and harmful, that has no safe level of exposure, and that over the many decades of its use is responsible literally for millions of deaths worldwide. And so do we really want to tolerate additional exposure to asbestos based on the hope and the assumption that everybody will be wearing respirators at the chlor-alkali plants, and they're going to be fully protected, and nobody is going to develop mesothelioma, and nobody is going to develop lung cancer, and no one is going to develop asbestosis disease. And so that's the issue that is before the courts. And I think that the way I would look at the language in the statute is that, of course, EPA does not have unlimited discretion to ban a chemical simply based on a belief that we need to go the last mile and be precautionary. But that said, EPA has a lot of scientific and policy judgment to look at the evidence and to make a determination, having characterized the risk of what is the most defensible action to take to assure that that risk is effectively addressed. And I would just submit that when you look at all of the 5 rules, particularly those that are being litigated in the courts, it's pretty darn clear why EPA decided that it needed to impose a ban. And I would submit that EPA's policy and scientific judgment was exercised in a very defensible way.
Now, Keith, my understanding is you're on the other side of the aisle on this case. How would you respond?
Well, so I'm not actually involved in the asbestos case, but I am involved in a few of these. I do think, so the initial question you asked is how much does that language to the extent necessary matter? it has to matter. That because it's the law. So I think, I mean, what we have argued repeatedly is that that means that having identified an unreasonable risk, the assessment has to be not only will this regulation eliminate that unreasonable risk, but is this necessary to eliminate the unreasonable risk? What the IT people tell me is that the foolproof way to avoid cyber attacks is turn off your computer. And yet we all still use them. In the methylene chloride case, there are a number of uses for which EPA prescribed an ECHL of, if I remember correctly, it was 2 ppm, and then a whole host of uses that they prohibited. And one of the issues in that case is whether the prohibition has any justification whatsoever, because the rulemaking record, the decision seems to say we have doubts whether these industries will be able to achieve the ECHL. That sounds to me like a far cry short of determining that it is necessary to prohibit those uses, because it's not a determination that it cannot be achieved. And if it can't be achieved, of course, then using it in those uses would be unlawful, because if you cannot use it without achieving the ECHL, then you can't do it. But the ban, instead of setting the ECHL, why is that necessary? I don't, that's a live issue in that case that I think the Fifth Circuit's going to take up. There's in the TCE case, one of the live issues in that litigation is that EPA allows the use of byproduct material that has trace TCE, that has small amounts of TCE in it, so long as it's being done on site, but does not allow you to take it to a different site to do the same thing, even though there's no finding in the record, I think, that the transportation in itself of materials that have got small amounts of byproduct TCE is actually contributing to the risk. So I think, where Bob and I might have a fundamental disagreement, I think we are probably on the same page. It sounds like that EPA is limited in what it can do by that language to the extent necessary. I think we would disagree about whether they've actually achieved that in a number of these rules.
So could I just offer a slightly alternative view? So labor unions have for 50 years fought against the notion that respirators are an effective means of protecting workers on a full-time basis. And so to the extent that arguing that EPA should set ECHLs instead of bans means that industry would have the option of requiring full-time respirator use, that would put an onerous burden on workers, one that in the TCE litigation, industry is arguing is completely unreasonable and will cause them to go out of business because the workers will refuse to wear them and they're going to have to shut down their facilities. But the unions have taken the position, and this is true in methylene chloride, that if the only way to reach an ECHL and fully protect workers is to slap them in respirators all the time, then EPA should ban the chemical where it can. Now, this becomes a lot more problematic for 6G exceptions, where EPA has determined that it can't ban it. And I can tell you that the unions have not yet taken a position on it. I'm not sure, but there's a real contrast between some of the representations that respirators will fix everything, and so don't worry, ECHLs are fine, and the position that some of the industry folks are taking in the TCE litigation that we can't rely on respirators because our workers will be up in arms. And it certainly, full-time reliance on respirators would be overturning 50 years of occupational health policy and industrial hygiene policy. And so we think that's a real non-starter, or it should be.
So I apologize, but this is really, really interesting, and I want to point out something for everybody what Ren just said. And I agree, these debates are ongoing. I do think that industry is not a thing any more than, it's like everybody's different, every market is different, every product is different. There are some commonalities and some underlying principles, but it doesn't shock me that it would be that a thing would work and be economic in one market and not in another. But the underlying proposition that Randy was talking about is really about what do we mean by to the extent necessary. I don't know that in methylene chloride respirators are the answer for how everybody gets to the ECHL, and I truly mean, as I sit here, I don't know. I might have known last year, but I don't now. Um, but let us assume that the ECHL, that if there's a 2 ppm ECHL for this substance in a condition of use, that the only way the employer is going to achieve that is by requiring everybody to use respirators full time. Let's assume that, like, so, and what Randy says is that's a terrible idea. And I understand the concern there, but as an interpretation, if we ask the question, what is to the extent necessary? And I don't think this is an easy answer. I don't think it's an easy question with an easy answer. Like, should that concern factor into the question of what is to the extent necessary? Or should it be part of the selection of, as you select, like, what weight do you give that concern in the selection of measures? I think is not trivial.
That would be why we haven't heard from the court for a year in the methylene chloride case, right?
Right.
It's very complex.
Any day now, any day.
Yeah.
I'll just
Again, let's explore this topic. And there are cases pending in the 3rd, 5th, 8th DC circuit. So we have a lot of opportunity for some mixed results here. Please go ahead.
Nihal,
did you want to go, or Randy, did you want to respond first?
Well, I would just say this is really getting into the weeds. In the case of methylene chloride, for example, it has been used in construction. The only respirators that work with methylene chloride are air-supplied respirators. It's unsafe to use them on construction sites because people are moving around all the time. So there's really no indication that Congress intended to mandate unsafe, impractical methods of compliance in lieu of just getting rid of the methylene chloride when there's substitutes that can be used in those instances.
That's a good word. Bob, please respond, but Marissa has been very patient. I do want to save a little time to talk about
Okay.
We have about 10 minutes.
I will try to be succinct. I don't think that we can really address this issue thoughtfully unless we keep in mind the level of risk associated with the chemicals that we're talking about. And when a chemical has serious toxic effects at very, very low levels of exposure and concentrations, it is in that situation where the agency needs to examine the pluses and minuses of relying on workplace protections that may be ineffective given the nature of the risk and the very low level of exposure as compared to taking the step of banning the chemical, which will provide a degree of protection against the risk that for that particular chemical, a respirator program is just not going to deliver. And I think TCE is a great example of this because the effects that were driving the risk evaluation for TCE we're seeing at incredibly low levels. We are talking about immunotoxicity. We're also talking about fetal heart malformations. And if you set an ECHL to eliminate those risks, it would be incredibly low. And in fact, industry said this ECHL that you wanted to impose is unachievable. We cannot get there So if your EPA and industry is saying, gee, we can't achieve the level of workplace protection that EPA says is necessary, what do you do if you're EPA? I don't think you can just walk away from it and say, we're going to allow any level of risk that is appropriate given the limitations of controls. And so I think in a situation like that, and in the asbestos situation, and maybe in the methylene chloride situation, the effects of the chemical are driving EPA towards a ban.
Interesting. There are lots of interplays in risk management, and one area we felt that was super critical to bring out in this panel discussion is also the state-federal interplay. And so I do want to turn to that topic, if we could here, in closing out our panel discussion. Consideration of substitutes, for example, is part of the economic assessment that EPA must conduct in a Section 6 rulemaking. And we have with us today one of the country's leading experts on conducting alternatives assessments, and that is Marissa from Washington State. So I'd like to ask Marissa to lead off on this. What role should the availability of substitutes play in selecting bans or other risk management options? How relevant is the safety of the substitute relative to the chemical EPA is regulating? Do states see the substitution issue differently from EPA? And finally, under TSCA or state laws, what should agencies and industry itself be doing to avoid regrettable substitutions? Marissa, I'd like to ask you to lead off on that, but also ask the panel and just open it up here in the last few minutes to also address state perspectives on preemption. So those two issues, substitution and preemption, please lead it off.
So I would suggest we let Marissa go on substitutes.
Yes, yes. No, I would like Marissa to maybe take the opportunity to answer both questions, but please lead us off. Thank you. Thank you, Randy.
Sure. Thanks so much for having me. So, from the state perspective and the information we have, we often see the move to safer alternatives is kind of shaped like a bell curve. It doesn't happen all at once. And that means you have your early adopters that move to safer alternatives relatively quickly. And then you have your stragglers that might continue using your high priority chemicals for a long time, even after safer alternatives are feasible and available. And so if no one has switched yet, then you're really in this technology forcing space where you're trying to figure out how do you shake something loose to get people to move to a safer alternative, to find a safer alternative, to find something that's going to work and avoid a lot of the risks that we may be worried about. And that's the space that we find ourselves in with chemicals like 6-PPD, which is an antioxidant, an antioxidant, really toxic to fish, particularly salmon, but it also helps make our tires safe. So we can't ban it tomorrow. But we do want to find a safer alternative, and we do want to keep it out of our streams and away from our fish. So that's a challenging space to be in. But in other times, you're in a place where alternatives are already really widely used, and a lot of manufacturers have made the switch, and some haven't. And in Washington, we have research programs that help us pave the way for safer alternatives. And I want to highlight that these programs really rely heavily on concepts from EPA's Safer Choice program. We didn't make it up. We borrowed heavily from tried and true methods for finding and evaluating safer alternatives. But we also have a regulatory program for chemicals and consumer products called our Safer Products for Washington program. And under this authority, we can restrict chemicals in products when safer alternatives are feasible and available. And this concept works because we focus on a specific product or use. We set clear criteria for what it means to be safer. And usually we make that determination of whether it's feasible and available based on whether it's used in other products that meet the same functions. So by the definition, this isn't technology forcing. And there's a lot of fundamental differences between our state programs and TSCA. But this relatively straightforward approach has helped us assess the situation and figure out what are we going to have to do to get this chemical out of products? Is it innovation or is it regulation? And it can be both. And I want to take this approach and kind of expand it a little bit and give you an example. We want to look at the needs of the specific chemical in the product. And that's really important because if you think about something like PFAS in food packaging, it helps keep your leftovers, your food packaging protects your leftovers, right? That's good for about 3 days. You don't want to eat your leftovers after that. But PFAS is going to retain its oil and grease resistance for a whole lot longer. So when you're looking for alternatives, you got to think about what's going to serve the purpose of the product, even if maybe it doesn't meet all the same performance requirements of that high priority chemical. And I'll just end with, EPA has the opportunity to look to states' work to figure out how we think about things like safer alternatives, to look to Safer Choice. Safer Choice is an incredible program, and we rely heavily on the work that has been done under that program. It's good to look before you leap. You kind of want to know, where are we going if we ban this? But you also need to retain some simplicity in that process because government agencies aren't manufacturers, right? We can take a look at a high level and say, well, someone figured out how to do it, so we think it's possible. But we got to work together to figure out all the kinks in the process and have those conversations and talk through the nuances. So I think keeping it at a high level is really important. And I can dive into preemption or I can pause. Please let me know.
Yep. No, I'd love to have hear how TSCA federal preemption looks from the state perspective 10 years into this, if you wouldn't mind.
Yeah, such a simple question too. Thank you. So we often share priorities with EPA, and that means we're working in a shared regulatory space. In a lot of ways, I think in Washington state, we would like to be preempted by protective national regulations. We do not have the resources to go at this alone, and regulations are often more effective when they're consistent. However, we have not seen protective and timely regulations coming out of TSCA, and there's just so much uncertainty from missing deadlines and redoing analyses. And that means we don't really know what to expect in terms of when and whether we'll be preempted on specific chemicals. And underlying all of this is our obligation to the people of our state and our legislature. We have to implement our state laws. And so that means we can't always take a wait and see approach. But it also makes it hard for us to act strategically. While we ultimately want protective national regulations, I would be really remiss to not stress the importance of state actions and the potential harm that comes from preemption by inaction. So I can think of a lot of examples where state regulations have led the way. So lead in wheel weights is a really good example. Washington state banned it in 2011, and a lot of states were with us in that. It was a big deal to get lead out of wheel weights. When you drive down the road, your wheel weights can contribute to lead in the environment. We know that harms kids' health. So this was a really important step. EPA just recently responded to a petition to take up lead in wheel weights under TSCA in the last couple of years. And they denied that petition because it had already been phased out because of state actions. So, we can think about similar products like copper in brake pads, flame retardants in electronics and furniture, phthalates in children's products. If we had waited for EPA to take action, we may still have lead in wheel weights. And that's a really important, point of this preemption, like preemption by inaction or waiting for EPA to act would have meant a lot of loss of public health and environmental benefits. So it's tricky to navigate this, but in Washington, we're not viewing potential preemption as an excuse not to act to protect our environment. And I think state actions can also serve as a really important asset to EPA because it can provide that insight. We talked about alternatives, but what about examples where states have banned it? All right, now you can kind of be like, what happened in Washington when they banned that? Can we take that nationally, or is there something special about why it works in Washington that it wouldn't work in another state? Or maybe there's a need in Washington that there's not in another state. So state regulations are really important, and they can serve as a test bed for state action, for national action.
Thank you so much for your perspective. And thank you so much to all our panelists for really exploring these important issues with us today. That brings us to time. And so I'd like to turn it back to Madison.
you so much, Martha, Keith, Dr. Friedoff, Reagan, Randy, Marissa, and Bob. We so appreciate having you all here today. We are excited to move straight into our keynote address for the day. If the panel wants to shuffle off stage, our other speakers will be coming on at the same time, but I'm going to go ahead and read the introduction as we get started. Thank you all again. So hosting the keynote conversation, which is titled 10 Years of Progress Under the Lautenberg Act, What We Have Intended and What Has Been Achieved. Our host is Dr. Lynn Goldman, who is a professor of environmental and occupational health and Dean Emeritus at the Milken Institute School of Public Health at the George Washington University. Formerly the AA for toxic substances at EPA, where she oversaw OCSPP, Dr. Goldman is a renowned expert in pediatric environmental health and chemicals and pesticides policy. She has engaged in translating research to policy through writing policy analyses and via congressional testimony in service of successful efforts by Congress to achieve passage of reforms, both to federal pesticide law and federal chemicals law, as well as legislation to enable California's childhood lead poisoning prevention program. Joining Dr. Goldman in hosting the conversation in person is Bonnie Lautenberg, who is the widow of the late Senator Frank R. Lautenberg, who originally introduced a TSCA reform bill in 2013 with Senator David Vitter. At Senator Lautenberg's funeral, Bonnie Lautenberg spoke with Senator Tom Udall to ask him to continue the effort of championing this legislation. She is an esteemed photographer, writer, philanthropist, and businesswoman, so thank you both for being here. And speaking of Senator Tom Udall, we are excited to have him joining this keynote virtually. The Honorable Tom Udall has a long and distinguished career in public service. He served as Ambassador Extraordinary to New Zealand and to the independent state of Samoa. He also served 2 terms as United States Senator from New Mexico and 5 terms as United States Representative from New Mexico's 3rd Congressional District. Earlier in his career, Senator Udall was elected twice as Attorney General of New Mexico and also served as an Assistant United States Attorney. His Senate committee assignments included the Committee on Foreign Relations, the Committee on Appropriations, the Committee on Commerce, Science, and Transportation, the Committee on Indian Affairs, the Committee on Rules and Administration, the Committee on Security and Cooperation in Europe, and the International Narcotics Control Caucus. Thank you all so much to all 3 of our speakers for joining us. As a reminder, you can find all of their biographies on the written materials page, so we encourage you to check them out in full. And I will hand things over to you, Dr. Goldman. Thank you so much.
Thank you so much. And thanks to all of you for being here today. I've been listening to the earlier sessions, and this has really been a wonderful conference. But I should just say, even though it's a bit belated, welcome on behalf of the George Washington University, the Milken Institute School of Public Health. And this 10th anniversary is just such an important milestone. You know, a bill that was enacted in 1976 and needed reforms didn't occur for 4 decades, 40 years, think about that. And we now have the Frank R. Lautenberg Chemical Safety Act for the 21st century. Frank's legacy is wrapped up in this. He dedicated so much of his personal time and energy to that, and Bonnie Lautenberg, his wife, carried forth with the banner of supporting this. And I actually want to start with Bonnie. And Bonnie, your personal story with regard to this. I mean, Frank, as you well know, spent most of a decade, 7 years, working on amending this law. Starting with the Kids Safe Chemicals Act, which he introduced in 2005, and which then had been reintroduced several times without any real traction. There was no real bipartisan consensus around moving something forward. And I think everybody knows that any one senator can almost block any bill, right? But also that eventually he was able to forge a bipartisan consensus, which resulted in a bill that President Obama actually signed. And so, and the tragedy for all of us was that Frank passed away in 2014 before he had a chance to see all of his good work come to fruition. But what was it like for you to watch this effort and to have an opportunity to help carry it forward?
Well, let me first thank you, Lynn, and for inviting me to be here. I was here for the 1st anniversary, the 5th anniversary, and I'm honored to be here for the 10th anniversary. I just wish we got more chemicals out of the way in these 10 years, but I'm really thrilled to be here today. Frank Lautenberg was an amazing man. He was, first and foremost, an environmentalist. He grew up in a family, his father was an environmentalist. He was a health faddist. Frank always said, my father was a health faddist. He cared about eating the right foods, and he was very much aware of everything around him. He even worried about clean air and probably clean water. So when his father worked in the silk mills of Paterson, New Jersey, and when Frank was 10 years old, his father brought him to the silk mills and showed him how dirty the environment was there. So he took his hand on the silk threads and said, you must never work in a place like this. This is polluted, it's unhealthy, and you must get a good education and have a much better life than I'm providing for you right now. And so he did. And then he,
Well, of course, we at EPA were very well Frank's commitment to the environment. He had been a real leader in terms of establishment of the toxic release inventory and many other things prior to TSCA. But what was it like for you when he was able to develop a bipartisan consensus for the bill?
Frank worked on this bill for years, and every year he could only get Democrats. He couldn't get one Republican. The frustration level was enormous. He didn't understand it because he felt it was the government was responsible for keeping the air clean, the water clean, to keep the environment clean for the people that live there. And he couldn't get over that he could never get a Republican, to co-sponsor his bill. And it was very frustrating to him. And it was terrible. But we finally, you want me to talk about what happened, how he actually got a co-sponsor at this point?
I would like to hear about that.
Okay, so this is a great story. So unfortunately, Frank was very sick, and he had multiple myeloma, and there was no hope. We couldn't cure his disease. And in April of 2013, he died in 2013, by the way, I'm sorry, not 2014. In April of 2013, Harry Reid there was a gun vote, and he needed Frank's vote desperately. He begged me to bring Frank down to Washington. Frank was very sick. This was April. He died in June. And he spoke to Frank, and Frank wanted to go. And we drove down to Washington, and we got to the Capitol building, and his staff was there. Frank was in a wheelchair, and they were sneaking him into the Capitol building because nobody knew he was coming for this gun vote. But sure enough, when we got inside the Capitol, Herb Jackson, who was a journalist for one of the New Jersey newspapers, was there with his camera. And I was furious. And I went up to him, I said, Herb, I hope you'll have the same respect for Frank that the journalists had for President Roosevelt in his wheelchair. They never showed him in his wheelchair. And sure enough, he never showed that picture. I was very grateful, really. But so we go up there, and now it's a gun vote. And outside the majority leader's office is a gorgeous room, and we were there with everybody involved with gun legislation, that cared about this issue. And now it's time for Frank to go into the Senate for the vote, and nobody knows he's coming, and they wheel him in, and it was bedlam. Now, I tell you, Frank couldn't stand at this point. He was not in good shape. But there were 3 amendments that day. There was background checks, which was Toomey and Joe Manchin, all right, with background checks. Dianne Feinstein's assault weapons ban, and Frank Lautenberg's magazine, where he was hoping to get, instead of 100 bullets on the magazine, 10 bullets on the magazine. Okay? Frank stood for every vote out of that wheelchair. Anyway, they all went down. The law didn't pass, but Joe Manchin never forgot that Frank came down for that gun vote. Now, Senator David Vitter was writing his own bill for about 3 years and went to Joe Manchin to tell him, to ask him to co-sign his bill. And Joe Manchin said, no, you have to go and work with Frank Lautenberg, Senator Lautenberg, and co-sign his bill, co-sponsor his bill. And I really believe that if Joe Manchin didn't have such respect for Frank and so grateful that we came down that day for that gun vote, he never would have told Senator Vitter to go and co-sponsor Frank's bill. But he did. And that's how he got a co-sponsor for the bill. And it was quite amazing.
No, that's very interesting, and it says a lot about how the relationships work, in Congress, especially the Senate, and how important that is. And I do think that connects to my next question to you, actually, which was, what was it like for you after Frank passed away and you were so engaged, continued to be engaged with members of Congress around the bill?
Well, as far as I was concerned, I had to do whatever I could do to keep this bill going. I didn't even go through the correct channels. I didn't know that you go to the Environment and Public Works Committee and talk to somebody. I went right to Senator Tom Udall. He was my friend, a great environmentalist, and he was the perfect person to take Frank's place on this bill. So Frank died on Monday. Friday was the funeral, and we had, I think, 40 senators. I mean, a lot of senators came to the funeral. But I went right to Tom Udall, and I said, Senator, I need you to take Frank's place on this bill. And he said to me, then I met him in Washington. He said, Bonnie, I met with David Vitter. We had dinner. I want to take on this project, but I want you to work with me on this project. Work with you on this project? What am I going to do? And Tom Udall and Jonathan Black from his office were so fantastic. They directed me. They educated me. They had me call people. And the nicest part about it was that everybody I called picked up the phone immediately. And they had such respect for Frank. I was so touched how people reacted, I must tell you.
I mean, thank you for that and everything that you did, actually. I mean, I now want to welcome Tom Udall, who, of course, you've all heard, picked up the baton, carried it for 3 years, and there was still a lot of work that was required to achieve bipartisan consensus and passage with near unanimous, actually, support by both houses of Congress. But Tom, you just heard from Bonnie, and I'm wondering what your perspective was about what her role looked like at you as the senator who is now the sponsor of the bill, and why did it matter?
Thank you, Lynn, and thank you, Bonnie. I hope you can both hear me very well. I first want to just start with the thing that you emphasized, Lynn, and that's the personal relationships in the Senate. Bonnie talked about it. Reason everybody picked up her phone right away is she was a part of the Frank Lautenberg team. So, and that's the way the Senate works: spouses, senators, the whole thing. And so it was really an incredibly personal building relationship that occurred within the Senate. But let me talk a little bit about Bonnie. And Bonnie, don't stop me, okay? She doesn't realize how much she did. Bonnie did incredibly important work. She made personal calls to members and talked to them about serious legislative issues, and in many cases persuaded them right away, or she educated them to come on later. She sat down in offices and convinced members to participate, to join the bill, to move to the point where they were going to sign on the Frank Lautenberg bill. And whenever we needed her, Bonnie, you always showed up. You were absolutely amazing in terms of this is a businesswoman, an artist. She was always busy, but she would drop what she was doing in order to get us to move things along, which was obviously with 10 years working on this was a very, very slow process. Her presence was different than a lobbyist and different than a staffer. And here's what the difference was. She was carrying Frank's legacy in a way that was undeniable. It was instinctive to her. She kind of knew it, she grew into it, and she got better and better at it. And she got this nickname. I don't know who actually did it. Bonnie maybe does, but she was nicknamed the 101st Senator because she made a real difference on Tosca. And I just want to just spend a brief moment because she mentioned Jonathan Black. He was my lead person in the United States Senate doing this for he was studying it the entire time I was there, and he was on top of this, and he served in administrations. He's now back in the Senate as a senior advisor. I also, Lynn, you and George Washington were just incredible. You, the things that you did in order to move this over the line was incredibly helpful. And then there's many people that are at this conference that I can't see all of them. I saw Mihal on the last panel that helped us all along the way. So I just thank all of you. So Lynn, back to you.
And actually, Jonathan's here. I should tell him to
Where's
raise his hand, identify him. Thank you, Jonathan.
That is Jonathan.
Yeah.
Yes, let's give Jonathan a big applause.
So, we realized that, over the 3 years that you were the lead author of this bill, that was actually, Tom, quite a battle. And could you talk a little bit about what that was like on the inside? 3 years is a long time.
Absolutely. Frank had really done the impossible. He found a policy framework that could work and began building relationships across the aisle. That's what was always amazing at Frank. There wasn't a member that Frank Lautenberg couldn't talk to. And to give you a little of my perspective, the reality in the Senate is that a single member, and this is something that could be very irritating, it would be something that could drive you crazy, but a single member can slow things down, they can stop progress, they can put holes on. And so it required working through every concern, every objection in order to get this done. And the moments of apparent progress, you'd have a little bit of joy. And then the next thing you know, Jonathan or my chief of staff or somebody would walk in and say, oh, so-and-so's put a hold on your bill. They'll say, oh, Senator, we got to tell you about this big obstacle that's facing you. And believe me, this required incredible patience. I underline incredible patience on the part of everyone. Bonnie, you were very patient. Lynn, you were patient. I know everybody was frustrated. And to me, it really felt like one step forward, two steps back. I kept thinking to myself, are we ever going to get this done? But Frank's legacy was so important to me. His heart was in getting a good bill. And that was, for me, it was like a really heavy weight on my shoulders because I took this on because I knew it was important. I believed in it. I cared about it. But it was a much different thing when Frank, I was doing it for Frank and I was doing it for Bonnie. I mean, Bonnie, I just listening to you here, it makes me a little bit teary in terms of how I feel about all of this because it was a remarkable experience over those 3 years, and I once again thank everybody. Back to you, Lynn.
Well, I think, just to follow up, what made the bipartisanship possible? Even at that time, it was becoming extremely difficult.
What was the question?
Let me start on this bipartisanship because it's something that I think is incredibly important to understand that that's what made this happen. That's what made it happen. The Vitter, Lautenberg, and then I had dinner with Vitter, and then Vitter stepped in. Both sides had something real to gain. That's the most important thing you should know. And what did industry want? Industry wanted regulatory certainty. That was something they weren't getting, and they really wanted that. And the health and environmental advocates wanted stronger protections for the American people. And there were many, many lists that you could make of that kind of thing. The broken law was serving no one. As Lynn mentioned, 40 years, and it hadn't worked. Court rulings and made it work even worse. And neither side was getting what it wanted in the whole Senate process. They didn't like the status quo. Inaction hurt everyone, and doing nothing was not an option. The key, and this is the most important thing in terms of how this all worked, the key was trust. It wasn't so much about getting an agreement, just getting an agreement. It was about getting everybody to trust each other, that they weren't writing a bill that one side was going to get everything they wanted or the other side was going to get everything that it wanted. And you know what trust does in this legislative process? And I include everybody because the groups were in, the industry was in, everybody was part of this. Trust allows the group to do what is needed. And trust also allows the group to get the bill across the finish line. The final bill became better because both sides shaped it. Consensus was a central figure, was a central feature of this bill. And I can't emphasize that enough. Consensus building is a difficult process. And so we just need to do everything we can in wherever we're going down the road the next 10 years to make sure it's a consensus building process. Back to you, Lan.
So, Tom, we're at a juncture where the fees need to be renewed. They're going to expire in several weeks, but also there are conversations around ideas that people have that this could be a time to try to amend TSCA. I think not a consensus, certainly more coming from industry circles and some members of Congress, but it's a political moment. And what do you think about the concept of using a political moment like this one to rewrite TSCA?
Yeah, well, this is the okay. Lynn, you need to speak up a little, or somebody needs to help me with your microphone. Was your question on the what's your message to the people who think they can use the current political moment to rewrite? Is that it?
That's correct. Yes.
Okay. Okay.
My sound better now?
Okay. No, thank you very much. I first want to say to everybody, no, this is a very, very bad idea. The 2016 reform, and now, you're all going to say, oh, well, he wrote the bill. He doesn't want a new bill. But it's the Frank Lautenberg bill, Bonnie. And Frank had a legacy, and this is a very good bill. The reform, the 2016 reform was a consensus result. That wasn't a weakness. It was what made it durable over the long haul. Complex and complicated legislation like TSCA on these difficult and technical scientific issues require a consensus process. And you could hear the previous panel of all the things that go into drafting a law. We have a great deal to learn here from history. In 2009 and 2010, Democrats had the White House, the House of Representatives, and the United States Senate. And the Senate actually had 60 votes for Democrats when Al Franken showed up 6 months in. So that the Democrats had a chance. Even with those majorities, And that trifecta, Frank Lautenberg wasn't able to push his chemical safety bill through the Congress. So once again, don't be heading down your own little road. Let's work on consensus building. The TSCA reform deal went through many different permutations of Congress and the White House, but ultimately prevailed. And listen to this, ultimately prevailed with a Republican Congress, House and Senate, and a Democratic White House and appointees at the EPA, Democratic. The EPA is a scientific agency. I don't want to link it with politics. But the top person is appointed by the president. And it took, and approved by the Senate. It took 10 years of consensus building between all the parties and stakeholders to get it across the finish line. Just because President Trump and his Republicans control Congress and the White House, it doesn't mean that you can jam this through. Anyone who thinks they can move unilaterally is misreading the history and the politics. And I think it's very important that we think about how do we approach the things we feel passionate about. The people that have talked here today, and you're going to hear later in the day, are passionate about chemicals. I am too. But let's follow a consensus building process. Thank you.
So, Tom, one of the realities is that the law has major resource constraints right now. And I mean, partly that is a factor that has led to the lack of being able to meet all the deadlines that were in the statute. There have been other problems as well. There have been flip-flops with policy making and all of that too, which doesn't help. But is this a sign that the system is broken, or is this something that can be fixed, in your opinion?
This is absolutely a solvable problem, and the solution is funding, not gutting the law. Much of what looks like failure is the consequence of resource starvation. And I underline that big time, resource starvation. Underfunding an agency and then pointing to backlogs is not a policy argument. I saw that over and over again in the Congress, where you would starve the agency, it couldn't do the job, and then people would stand up and say, oh, this is a crummy law, crummy agency, we should get rid of it. That's not a policy argument.
Bonnie, when you hear
the TSCA framework is a sound one. There is a good evaluation process, which the panel before us just talked about. There is a solid risk management. There are solid risk management authorities, and the preemption standards were carefully designed. And that last panel talked about some of those and how you're working with the states. What's needed is the will to resource the Frank Lautenberg law and the discipline not to relitigate every single inconvenience a stakeholder has. Every time you get a ruling in Washington, one ruling, people declare the law's bad and go down to the floor. The law's bad and the process is bad and the agency's bad. That's not the way to look at this, because it's a very different, complex, nuanced approach to things. There's a real danger in conflating implementation challenges with structural flaws. They require very different responses. Passing a law is important, but implementation is make or break for the law's success. Today, we don't need a new law. We need a united effort to implement a good law. And then we need the people to work with, the people that are out there, everybody, work with the agency to find the people, to get them to get in the job and start really get this statute up and running. And I'll never forget, Lynn, one of the scientists that you introduced me to and that Jonathan talked about all the time, he researched chemical laws all over the world. And when this passed, he came up to me and he said, I've compared this with every law in the world, including REACH, which is the law over in Europe that deals with chemicals. And what he said is, he says, we've got one of the very best laws in the world. He even went further than that. He said, we've got the very best. But a law is a law. It needs to be implemented. It needs to have good technical people behind it, and the agency needs to be resourced. And so that's the point we're in right now. And we need people to be working on that. Land, back to you.
Thank you for that. Turning back to Bonnie, when you hear these debates about potentially, revising the law, what thoughts go through your mind about that as a prospect?
I think it would be so tough. It took so much work to pass this bill that I can't even imagine opening it up. If they do open it up, I hope they will vote to get rid of really dangerous chemicals that are still out there. That's my biggest concern. When you think about Parkinson's disease and all these diseases today, they know that a lot of it is caused by chemicals that are in our environment, and we must do something about it. So I hope people in the industry get smart and realize it's not about money. It's about the safety and health of all the people living in this country.
Thank you for that. So I wanted to talk a little bit about the road ahead. And Tom, I'm remembering how back when you were still working on the bill, you visited us at George Washington University, and we took a blood sample to analyze for chemicals. My colleague at Emory University actually ran those analyses, and it was I think surprising for you personally that there were so many chemical substances in your blood. I mean, I think one thing that I had realized from my former experience at EPA is that at a time, many chemicals had been grandfathered into use before we understood about their persistence, and that they would continue to be in people's bodies, in the environment for a very long time. And we really had no knowledge about what the toxic effects of many of those chemicals were. I mean, it's hard to remember, given the concerns people have about new chemicals today, that it used to be just kind of almost like tens of thousands of chemicals were just grandfathered in to use with no review, and then it was very easy to bring new ones onto the market. But I understand, and I've heard this, that you're doing this again. And I'm wondering if you could talk a little bit about what it's like to directly, personally engage with that, with learning about your chemical exposures, but also why are you doing it again? Maybe you could talk about that a little bit.
You bet, you bet. Let me just comment on what Bonnie said earlier. If the Congress, if you open it up and the Congress has real guts and a backbone and says, we want to ban a chemical like asbestos, do it. But when you delegate to an agency like Congress has done to the Environmental Protection Agency to deal with chemicals under the TSCA Act, let them deal with the chemicals. Let them deal with going through the process, and Congress give them the money so that they can staff the agency and really do the kind of job that other people are doing all around the world. Many countries in the world are banning many more chemicals than we are, and that's what Bonnie was just alluding to. But let me talk about my blood testing for chemicals. Lynn, you talked to me about it, Jonathan talked to me about it, I think I talked about it with Bonnie, and I said, why do I want to know? That's usually the thing that most people, when I tell them about this, say, why do you want to know that? And here's my thought is because I cared, and I was a soul brother with Frank on all these kinds of environmental issues that he worked on. We have a right to know that. And so if I take a test, it puts it in a different category. And I make that test public so everybody knows every industrial chemical I have in my body. And so during the TSCA negotiations, my blood test showed chemical exposures that no one expected, industrial chemicals in a senator's bloodstream. That kind of personal story changed. And I told that story many times. I would talk about the chemicals. My office we had one chemical that was in all the furniture in my Senate office. And Lynn, I think you are the scientist that looked at these things. They said, "Oh, you know that furniture in your office, that's probably where you got that chemical." And I said, well, this is brand new furniture. I mean, the Senate buys good furniture. They keep it clean. It's going well. Why is that producing a chemical? Do you know what that's doing around a child? And they said, oh, it's probably not doing very good around a child because you're older. Children have much lower exposures. It has a bigger impact. So getting that out there really, really made a difference. And I told that story over and over again. It changed conversations. It moved the debate from charts and regulatory filings to real people. That's what it did. And and you ask, why am I doing it again, Lynn? I'm doing it again. This is the 10th anniversary. And I just want I'm doing a little different slant this time where we did industrial chemicals. Now we're doing plastics. And I'm sure you and Bonnie could tell us both that we've got nanoplastics, microplastics, plastics throughout the human body. And I'm going to release that publicly so people can see. And I've considered myself somebody who, for most of my life, I think with some of my younger years, I wasn't great at it, but I had a mom that always taught me about a good diet and things. I think most of my years, I've had a pretty good diet and I've tried to not expose myself to chemicals. So I'm doing the test again. And because the right question at 10 years is, there are two questions. And I think they're very important we should think about. Have we actually moved the needle on chemical exposures? Bonnie, that's what you were talking about. You were saying, what are we doing? Why aren't we making sure these kids don't have phthalates in them when they're really young? That kind of thing. And the second question, are families any safer? And when I say families, I'm especially talking about kids who have those low tolerances, and it can have a much worse impact at that early part in their lives. Now, I believe that TSCA was built on the promise that we have a right to know what chemicals are in our bodies and what impact they might be having.
I have to agree with
Back to
that, Tom. I mean, I think
Back
that
to you.
the plastics in particular, the small particles, when I was at EPA, one of the first things I learned was that the TSCA program operated with the so-called polymer exemption. The assumption being that these large molecules, you couldn't test them and that they wouldn't be harmful. And for whatever reason, it was beyond the scope of even the scientist's imagination that as those break down, they might form other substances that are smaller and could be toxic or could be carriers of other things. And so this is an area where we know very little. And so I will, warn you as your doctor friend that they may find things that, we don't have scientific knowledge about what that means for you. And I applaud your courage in looking. And at the same time, this, I think, is a story that is not going to end until we have more scientific research and much more evaluation and get away from simplified things. Well, we just exempt because of what the parent looks like and not the breakdown products and what it turns into. For both of you, if you had one piece of advice to give to, the people in the room, and these people are researchers, they're advocates, they're attorneys, they're public health experts, they're experts in chemical engineering. What does the next 10 years of TSCA require, and what would it look like? What should it look like? Any advice to leave them with?
That's a big question because there's so much work to do to further the success we had with the TSCA bill. But I just think I hope that there are people who are realizing how dangerous these chemicals are, and we really have to do everything we can to get rid of them in this country, in this environment. We're hurting our children. We're hurting at every age. There's so much disease. I'm repeating what I said, but I think it's terrible, and I hope they'll be smart and stop thinking about money and stop and talk about the reality of what's going on in this country and the diseases and how we're all affected by these chemicals. And that's what we have to do,
Tom, your one piece of wisdom that you'd like to close with?
Yes. Thank you both, and it's been wonderful to be with you. Margaret Mead famously gave, I think, very excellent advice. And I'm quoting her here: never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has. It's the only thing that ever has, a small group of thoughtful, committed citizens. So here in this conference, we have a great many thoughtful, committed citizens who care about TSCA and care about the American people and care about our children. And they care about the next 10 years and want to see a successful implementation. That's the central thing I'm talking about. Implementation, successful implementation. I challenge all of you here at this conference and anybody listening to this that's part of it to form small groups to build consensus for success. Build trust with each other. We talked about trust a lot. And get into groups where you have different points of view. You can do that in this conference. All of you care about TSCA. Additionally, you need to grow and foster your patience and discipline if you're going to be involved in this issue. Tackle the consensus needed to protect the American people. Then find leaders who will stand up for a successful implementation, a well-resourced implementation. And the first place that I would start with people, if you're talking to Congress, or you're talking to the state and governors and whoever the leaders are, in the United States Congress, we know it's the Appropriations Committee. The president puts forward a budget. The Appropriations Committee in the House and the Senate are the people that are responsible for adequately putting the resources in place for the EPA on this particular issue. And so you all should be meeting with them, talking with them, and find the ones that are really not just talking, but doing. That's what you need to analyze when you look at leaders. It's not just about talking, it's about going out and putting the dollars behind resourcing this agency. So go out there, engage, get it done, just do it. But I think Margaret Mead's advice is very, very important. Thank you, everyone.
I think we should hope that in 10 years we'll all be back here at this conference and we'll have great news to report. And I hope that's what happens.
I hope so. I think what I've learned today from the two of you, the importance of personal relationships, Tom, of patience, of listening, of commitment, hard work, all of the people who worked on this bill. A lot of personal sacrifice went into it. And the kind of bipartisanship that is harder and harder to achieve, but necessary to move anything over the finish line in our country. I do think that durable reform is possible. It's possible we have a bill that achieve that. I believe that we do. And I think it's possible, as you said, that in 10 years, we will actually be celebrating that we've done a good thing, certainly for our country, for our children, our grandchildren. So thank you all very much.
Thank you. Thank you.
Thank you.
Thank you so much, Dr. Goldman, Bonnie, and Senator Udall. We're so honored to have you here for this discussion. We'll now go straight into our third panel of the day on new chemical review. Moderating this panel is Greg Schwier, who is the owner of Environmental Consulting, LLC. He retired in 2020 after nearly 20 years at EPA, where he primarily served as EPA New Chemicals Management Branch Chief. In this position, he managed the risk management portion of the NCP, mandated by Section 5 of TSCA, and led NCP through significant policy and implementation changes resulting from the enactment of the Lautenberg Act. Greg, I will turn things over to you. Thank you all for being here.
Good afternoon, everyone. I hope you enjoyed your lunch. As Madison said, my name is Greg Schwier. I've got the honor of moderating this panel, which I think is going to be real interesting, so I'm glad you all came back. I'm going to give you a short overview of what we hope to accomplish during this one session, and then give you a short bio on all the panel members. So let's get started. As noted in the agenda for this conference, questions over EPA's implementation of the Lautenberg amendments to the TSCA New Chemicals program rose quickly, and spirited debate still continues over how well the program is working and for whom, what challenges persist, and what changes may be needed to improve the program. This panel will hopefully explore some of the key issues under debate, including the short and long-term impacts of regulatory decisions on new chemicals, whether there is a need to fix the program and what that would mean, how reasonably foreseen future circumstances are identified and addressed in the new chemical review process, and the role that pre-market review of new chemicals plays in protecting public health and effects on innovation and safer chemicals. So our panel's got 5 highly qualified members, 3 of whom actually served at EPA at one time. I'll give you a short bio on each of them. Larry Killeen is currently a senior counsel at Arnold & Porter. He represents clients on administrative, regulatory, and enforcement matters involving federal agencies such as EPA, USDA, FDA, and CPSC. Larry has broad experience advising clients on U.S. and international regulatory programs that govern commercial and consumer use chemicals, pesticides, and antimicrobials, as well as the products of biotechnology and nanoscale materials. Prior to joining Arnold & Porter, Larry served as manager in various risk management positions at EPA, including managing the TSCA New Chemicals program and programs overseeing microbials and pesticides. Next to Larry is Dr. Maria Doa. Maria is a PhD chemist and is currently the Senior Director of Chemical Policy at the Environmental Defense Fund. Dr. Doa's primary focus is on reducing exposures to toxic chemicals and through health protective implementation of TSCA and other chemical safety laws. Maria joined EDF in 2021 after a 30-year career at EPA, where she developed extensive experience in chemical safety, risk policy, and risk management of chemicals, including new chemicals under TSCA. She created and led programs to reduce risk to lead, PCBs, mercury, and asbestos, and to increase the public's access to information on toxic chemicals. On this side of Larry is Dr. Richard Engler. He's also a PhD chemist. He's currently Director of Chemistry with Bergeson and Campbell. Dr. Engler is a 17-year veteran of EPA, including EPA's New Chemicals program. He participated in thousands of TSCA substance reviews while at EPA and he draws upon this experience to assist Ferguson and Campbell clients as they develop and commercialize novel chemistries. Dr. Engler writes and speaks frequently about the opportunities for industry to use TSCA to its competitive advantage and the challenges newer chemicals and technologies sometimes face and present under TSCA regulations. And next to me is Jonathan Kalmus-Katz. He's currently a senior supervising attorney in the Toxic Exposure and Health Program at Earth Justice, which is dedicated to protecting people and the environment from the harms associated with toxic chemicals. Jonathan, like Larry, Maria, and Rich, also spent some time at EPA. He served in the New York Superfund office. His practice at Earth Justice focuses on litigation and administrative advocacy related to the regulation of chemicals and pesticides under TSCA, FIFRA, and other laws. And finally, we have somebody new to this system. It's Bill Wash. He's a seasoned and accomplished lawyer and executive who founded the Healthy Building Network and grew it to be the nation's leading authority on product transparency and healthy materials in the building industry. For over 30 years, Bill has been at the forefront of efforts to increase transparency, reduce toxic chemical hazards, and accelerate the transition to safer chemistry. Bill began his career advocating for environmental justice with Greenpeace and now coordinates an innovative, collaborative effort to mobilize global investment for systematically replacing hazardous materials with alternatives that are verified to be safer for humans and the environment. Okay, welcome. Okay, this should be fun. Okay, they all can't wait. Look at their smiles. Here we go. So let's get started with the first question. Why are pre-market reviews for new chemicals important to public health protection? And are we doing too much or too little to address potential risks? How should this be viewed given the higher standard for regulating existing chemicals? Jonathan, you want to start this one off?
I'd love to. And first, I just wanted to thank Greg and my co-panelists and everyone who put together today's event. I know other panelists have said it, but anyone who has suffered me talking about TSCA the other 364 days of the year knows how much I personally look forward to today. Robust pre-market reviews are absolutely essential for public health protection because time and time again, we've seen that if you don't adequately regulate chemicals before they come to market, it becomes exponentially harder and more expensive to do so once they're already in our homes and environment and bodies. And I think PFAS might be the best example of that. Look, when my parents were born, PFAS only existed in a laboratory. When I was born, I probably had PFAS in my blood, but nobody knew it. We weren't talking about them. And when my kids were born, 99% of the people tested in this country had PFAS in their blood. In the span of 2 generations, we literally contaminated the world. Now, the Department of Defense estimates that it's going to cost about $10 billion to remediate PFAS at military sites, and some studies have estimated up to $60 billion in cancer and other health costs from PFAS each year. If PFAS had been adequately reviewed and regulated before they were first commercialized, those costs and those harms could have been, if not completely avoided, significantly reduced. Congress understood that. When it first enacted TSCA in 1976, the Senate Commerce Committee report stated, the most effective and efficient time to prevent unreasonable risk to public health or the environment is prior to first manufacture. And that's one of the reasons that Congress gave EPA broader authority to regulate new chemicals than existing ones. To regulate an existing chemical under TSCA Section 6, EPA has to find that the chemical presents unreasonable risk. For new chemicals, it's enough to find that it may present unreasonable risk. Congress wanted EPA to be proactive here. So no, I do not think that EPA is doing too much to protect the public from new chemicals. The critique that you'll sometimes hear is that new chemical reviews can be unpredictable and can take a long time. When you look at the costs of haste and uninformed decisions, I certainly think that the ounce of prevention is worth it. And I wanted to just address one other argument that you'll sometimes hear about the new chemicals program, and it's, we've got this incredible new chemical. It's going to solve global warming. It's going to replace all these toxic chemicals. It's going to fix all our problems. But because we can't get it through the EPA review process, because it's taking too long or because of the potential regulation, we're not able to commercialize it. And I mean, that sounds great. Kind of everyone loves a super chemical. Here's what happens if you go to look up that chemical in EPA's new chemicals database called ChemView. you'll find the name of the chemical has been redacted, the chemical structure has been redacted, the manufacturer has been redacted, the place of manufacture has been redacted. Typically, the byproducts and impurities have been redacted. There is no exposure information. And sometimes you'll get lucky, there'll be an Ames test or an aquatic toxicity study. Often the only information that you have about the chemical's health effects is a comparison to another chemical, the identity of which is redacted. And that matters because that's the information that you actually need to understand the risks and benefits of the chemical and kind of why some reviews may take longer than others. Some of those redactions may be appropriate, some may not be. We could discuss that in another question, but I think my point is that until chemical manufacturers are willing to put their unredacted pre-manufacturer notices in full correspondence with EPA on the table, I do think you need to take their claims they're being treated unfairly or the process is broken with a pretty significant grain of salt.
Thanks, Jonathan. Rich, you want to weigh in on this?
Yeah, so I mean, I certainly agree with you. Your first point that robust new chemicals review is entirely appropriate. I certainly don't disagree on that, and I'm speaking for myself, not for my clients, and not for the firm. But the question in my mind is, you say if EPA concludes that a substance may present unreasonable risk, EPA is obligated to restrict it. What is not clear to me is the line between may present unreasonable risk and not likely to present unreasonable risk. And there's been debate certainly in the hearings over not likely versus more likely than not, and is that 51% versus 49%? Not likely is the language right now. Does that currently mean 49%? So we don't know where that line is, and I don't know that EPA has determined where that line is. What I can see from my perch is that if EPA finds any hazard other than low hazard, EPA is concluding that it may present unreasonable risk and restricting it. So is that right? I don't know how much we'll be able to discuss this. Is that the right interpretation? And if you do get to that may present, is there any way to prove that it's in fact not likely? There's basically no way to test to a not likely finding. You can't do IH monitoring. You can't do exposure monitoring. There's no way to come back to new chemicals and say, despite the fact that you found this low moderate hazard. I'm not talking about the new PFAS. I'm talking about a thing that is barely over EPA's low hazard threshold. You can't prove to EPA that it won't ever exceed, and therefore EPA comes to that may present and restricted finding. And as a green chemistry proponent, I'm very frustrated in seeing some really great chemistry be frustrated in the marketplace. I understand the transparency issue, but the things that you named that you cited as CBI and redacted, the law recognized those things as being presumptive CBI in PMNs, recognizing that innovators actually have a vested interest in protecting that to prevent competitors from duplicating what they're trying to do. So, I mean, we can talk about CBI transparency, but in the end, the question I think that we need to answer is, what is that threshold? What does the statute mean, that line between not likely and may present?
Does anyone else want to weigh in on this one?
I'd like to add something.
Okay.
One of an important reason why making good decisions is critical is because we will live with these chemicals for decades. It is so difficult to address an existing chemical. It's taken decades to deal with asbestos, decades to deal with TCE, with methylene chloride. I could go on and on. And so making that decision before something goes on to the market, we need to get it right, because if not, it will affect us for a long time.
Anyone else? Or we move on? All right, we'll move on. Second question. Is the process supporting the development of safe chemicals, as opposed to marginally safer chemicals, effective? How successful are these chemicals in supplanting harmful older chemicals? You want to follow on your previous?
Yes, and I think it's a theme. There are some incentives to develop safer chemicals, but I think part of the issue is when we develop these safer chemicals, we don't concurrently deal with even the riskiest of the chemicals to make room for these safer chemical and truly safer chemicals to take root on the market. And the market will adjust to an extent, but companies with these incumbent chemicals would like to keep their market share. And again, we had discussions about that this morning. And this points out the dichotomy between new chemicals and existing chemicals. We've heard a lot of discussion, EPA is taking too long to approve new chemicals, but it's a relatively short period of time. Whereas, on the other hand, for existing chemicals, it's a multi-year process. And again, it's making that room, the incentives to have safe chemicals, not just marginally safer chemicals on the market, but truly safe chemicals. And I think another disincentive gets to how the term safer is used. Many of us think of safer like safer choice, but I think others will think of it as, is it marginally safer? And I mean, I hear that now. When I was at EPA, I heard it, well, this one, okay, it may be associated with cancer, but it's not as potent as the one that's already on the market. And so if you approve that one that's marginally safer, you basically have the marginally safer one and the less safer one, and you don't have anything that's truly safe. And so this imbalance, I think, is why we see more things, the push to get more things on the market, and that are maybe a Me Too chemical. There are a lot of those, not significantly safer, and we don't create the incentives by dealing with the existing chemicals to encourage truly safe chemicals.
You want to respond to that, Rich?
Sure. So you bring up safer choice, which I think is a good example, because we've had a number of cases where a company has developed a very close analog to something that's on safer choice, where the difference is largely around TSCA nomenclature and not anything meaningful in the composition. So you've developed something that meets the safer choice standards, that very high threshold that EPA recognizes as best of the best, and then you'd bring it forward as a new chemical, and EPA says, oh, wait a minute, we can't put that we can't allow you to put that in a consumer product at any level. And that, to me, is baffling. How can it be both best of the best and be so unsafe as not to be in a commercial product? So this goes back to, where is that line between not likely and may present? If EPA cannot be sure, absolutely sure, that it's not going to be a risk, then EPA is issuing some restriction to include bans for some of these uses, that we really want these very good greener chemicals to go to market, right? We're not talking about the worst of the worst. We're talking about things that are very much like the best of the best, and yet they're treated the same way with some restriction that is, in the end, and I hope we'll talk about this, a market disincentive.
So could I just maybe add on to that? You noted that it's similar to something on safer choice, and I think there are 2 points on this. Sometimes the difference, the two chemicals can be similar, but the differences are very important and can be very important for toxicity or environmental fate. So I think that's an important consideration. And then the other thing to remember about safer choice, which is it's good, but it only deals with a limited range of uses. And this could be an issue where it's on safer choice for one thing, but a different use could have a different exposure scenario where it could make a difference.
You want
Yeah, thanks, Greg. I think we will, I think your next question also may lead into this, so I don't want to usurp the construct, but I don't think there's a real gestalt in the way in which TSCA is being implemented, whereby agency leadership is able to ask itself, Okay, are there existing chemicals we'd like to get off the market, and are there ways we can incentivize new chemicals as replacements? And I don't hear those ideas espoused from agency leadership. I don't hear them coming to the fore to offer motivation to various industries that might be able to contribute in that regard. And I fear that the amendments from 2016 did nothing to modify that, and in fact may be inhibiting as funding levels decrease, because I think the leadership at the agency is needing to be responsive to hitting deadlines on time, avoiding litigation, and really not being able to have either the resources or the presence of mind to step back and say, what do we really want to do environmentally? And are there ways that the existing and new chemicals programs could be more collaborative in terms of where we want things to move in terms of environmental policy? I fear that we'll argue over the edges of how to tweak this particular clause or that particular clause of the statute without empowering and enabling more visionary approaches to how you can use TSCA to reduce risk in the environment. It's my bias.
It's a nice one, yeah. Let's move on. You alluded to the next question being somewhat similar to what we're talking about now. That third question is, can components of voluntary programs like Safer Choice and a greatly updated version of Sustainable Futures be important adjuncts to the formal review process? You want to take a leap at this, Bill?
Sure. Thank you for the invitation and being on this panel. I feel like I come in from a parallel universe where companies who here in DC may be opposing any legislation or regulation or policy that would restrict any options on their chemical usage, while at the same time are working privately and collaboratively sometimes to reduce their chemical footprints based on intrinsic hazard. And we work with them to do that in order to improve the quality and accessibility of chemical hazard information, help them establish metrics to define safer chemistry based on intrinsic hazard, and to measure their progress year over year, all in an effort to accelerate the adoption of safer chemistry. Maria asked me just before we started, how often do you discuss TSCA? Never. Never discuss TSCA. And they're taking these actions in order to de-risk their business, not only from potential regulation or bans of chemicals or from potential liability, but really from the opinion in the consumer court of opinion on whether their product is safe and whether their company is trustworthy. And most people are not listening to the distinctions between exposure scenarios. As soon as you say those two words, their eyes glaze over. They're looking at whether they think this is a hazardous product. And so we're finding a lot of interest that these companies find it very logical to try to reduce hazards, the first part of the equation of risk assessment, and can they reduce their use of hazardous chemicals, reduce their toxic footprint, and communicate that effectively to their consumers ultimately. So yes, I do think that Safer Choice has a lot to offer in terms of how we look at addressing chemical usage in the future. I would agree with Maria about the reservations in doing that, but I think there'd be a lot of opportunity to expand that type of approach that could get a lot of support across stakeholder groups.
So Rich, you had mentioned Safer Choice to begin with. You want to talk about this and maybe talk about Sustainable Futures too?
Yeah, so I mean, I wish that Safer Choice and Sustainable Futures and doing those, designing to Safer Choice or using a Sustainable Futures assessment would make a difference in the outcome of a pre-manufacturer notice. But in our experience, it doesn't. So you can do a thorough Sustainable Futures assessment and show that there's not an unreasonable risk. And in the end, if when EPA looks at it, and they may go, we agree with your Sustainable Futures assessment, here's a consent order. So the magical threshold is that low threshold, low hazard for health, low hazard for eco. And if you can't meet that, then they're going to say, well, until you come back and show us that whatever else you want to do is not an unreasonable risk, we have to prohibit these other things. So your sustainable futures assessment might be, you might get a consent order that says you can do everything that you want to do in that sustainable futures assessment, but nothing else. And then, so you've got that order and that eventual SNR. So yeah, EPA lets the manufacturer do what they want to do, but you're carrying the baggage of the order and the SNR. And for something, if you're trying to develop something that's much greener, it looks weird in the market. You're like, I've got this much greener product. Oh, by the way, EPA's put this, this burden on me and you, customer, to document compliance, even though they said yes, it's not an unreasonable risk. So it's sort of the determination gives yes, it's not an unreasonable risk, but then the consent order takes away. No, we can't trust you to not do anything else.
Cool. So yeah, I want to respond to that because I think there's good reason for that limitation. Like basically, if you're coming in and saying, I want to use this chemical in a certain way, and kind of EPA does its analysis and says, fine, kind of the way that you want to use it doesn't present unreasonable risk, TSCA also requires the consideration of reasonably foreseen uses. And the reason that it does so is because once the chemical is approved, once the chemical goes on the inventory, anybody can use it for any purpose. So you might want to use it at 2%, but somebody else can use it at 10. You might want to use it in industrial process, somebody else wants to use it commercially. Or for consumer products. So yeah, like I think absolutely, like it's not a bug that EPA is saying, your use may be safe, we can reasonably foresee other uses that aren't, therefore we're going to restrict those. I think that's a core part of the new chemical review process.
Oh, I agree, except that EPA doesn't look at reasonably foreseen conditions of use. They just say, we looked at what you intended and anything else is impermissible. So that we've lost that subtlety of EPA identifying a reasonably foreseen condition of use. They just say, it might happen, and that's enough.
I think we disagree on that.
Oh, no, there's no question.
Yeah.
I think Maria wants to add something here too.
Well, I would say that EPA just doesn't say, oh, any other use. EPA has a huge database of all the new chemicals that have come in through time, and they look at similar chemicals and, oh, what's the use of those chemicals? So will this chemical likely also be used for that other use? They're not pulling it out of the sky. This is based on data. And frankly, I find that really helpful because you don't want something that can be, let's say with a worker safety program, where you can have risk controlled in the workplace, but it is likely to end up in a consumer product. And there are a lot of things like degreasers where that happens. So it's not pie in the sky, and I think it's important. And I think it also points out that a lot of TSCA is and I'm sorry, your eyes are going to glaze, ends up being between EPA and the company an argument over exposure because you're trying to control the risk. And that's a disincentive from going to safer chemicals. And if the focus was more on less hazardous substances versus can we arm wrestle over the risk, I think we would more readily move to safer chemicals.
I think just to be fair, and one of the lead questions was, does the process take too long? I think we're hearing very much why it becomes protracted. And I think over time, because of the necessity to make an affirmative finding and to do so in a way that's public, the agencies has become less creative in terms of how it might choose to regulate substances that are new. And I think there may be ways to achieve what I think in the last set of remarks are overall objectives. One is to have a pre-market review, perhaps determine based on the conditions of use that are intended that those uses should be authorized. Find a way to commit the manufacturer who's submitting the PMN to commit solely to what they've sworn to, let's just say, in the submission, and then still require other uses to come to the fore and be noticed to EPA. I think the statute even permits that, but I think we've obsessed over how many pages we can put in a 5E order, how long it could take us to generate a SNR, that I'm not aware that there's anybody in-house sort of saying, do we really need 50 pages if we could get somebody to sign on the bottom line that says, what's in my application, I swear I'll do for life. And if I deviate from that, I'll submit another notice. I think those things are achievable, would greatly truncate the period of time that's spent on these kinds of discussions to reduce exposure or limit uses and get everybody to where they want to be more efficiently. And I think it would kind of take the temperature down in the whole sort of review process and marketing. And I think it would also make people more inclined to not fight tooth and nail over the fact that you have to have a permission slip from the EPA to get onto the market if it didn't look like a Scarlet A.
Yeah.
So,
Yeah, I was going to say it's a lot like an LVE. I mean, what you're describing there is a lot like an LVE, where when the LVE is granted, what you put in the LVE is binding.
But there's a limit on it then.
Oh, yeah, there's a limit on tonnage,
right.
But
anyway, John, you were about
well,
to say something.
I mean, I think the LVE might be the answer. Like I think I share a lot of the goals that you said, and it actually sounds somewhat similar to the process that we have. And could there be more efficiency? Sure. But right now, EPA conducts a kind of robust assessment to determine whether the chemical presents unreasonable risk. And if it finds that your chemical does not, under the conditions of use, you go to market. If it finds that your intended conditions of use kind of don't, but that reasonably foreseen do, then it lets you kind of do exactly what you said. You sign the consent order, and you can go do that. And there's a SNR to keep everybody else saying, kind of, if you want to use this in another way that we haven't reviewed and approved, then you let us know and we evaluate that. I think the LVE, you have a more compressed time frame, you have less transparency because they're not going on the inventory, so they're not being reported to CDR. I think there are drawbacks to the kind of exceptions to the new chemical review process, but I think kind of, Larry, what you were describing, I think we already have the bones for that under TSCA. I think we can do that and are doing that to some extent kind of under the current system.
I agree. Having had not myself, but the agency had the opportunity to modify the 720 rules, they didn't go in the direction that I think I would have gone, which that's not for me to decide. But they could have gone in that direction and come up with a more streamlined approach where maybe there was a single page that you signed instead of a 75-page consent order at the back of your PMN that said, I swear, I wholly swear, I promise not to step on the crack and do anything that's outside of the confines of my application. That option could have been run up, and I would wager that it would have been harder for people to argue with, but that's not the Part 720 rule or 721 rules that we got. And I think it was a missed chance.
Well, I also think it's one of the things, at least in the Senate discussion draft of TSCA reauthorization, the stewardship pathway has this sort of model where you've done the assessment up front, you've done the sustainable futures assessment, you've shown that the intended conditions of use are not an unreasonable risk, and then EPA can look at that and go, yes, we agree, and then you can proceed to market with the binding conditions of what's in that submission and what those conditions of use are. By not placing it on the inventory, then you prevent the need for that consent order and the SNR that then follow on that complicate the supply chain so significantly. And I hope that that's something that we'll talk about with Bill, and I hope we get to that question.
Okay.
All right, let's go on. That was a good discussion. I mean, they're getting warmed up, folks. So, all right, question 4. We're making great progress. Okay. How can we better encourage and or provide incentives for the research and development of new chemicals that are significantly safer than existing chemicals for the same conditions of use? It sort of feeds into what we're talking about here. How should safer be defined, and what steps can submitters and EPA take during the review process to bring this information to the forefront? You want to lead this off for us, Bill?
I'll try. I think kind of listening to consumers and listening to the companies that serve them is a great place to start. And having greater transparency on chemical hazard data, greater accessibility to that, solving these problems of legitimate CBI versus those situations where a very broad perimeter is staked out and you can't get any information about the chemical whatsoever. So benefits not only society in general, but also companies that are the customers of chemical manufacturers, who are trying to deliver the function of those chemicals to their customers without any of the hazards or the risk. And they will deal with the exposure scenarios further down the chain, but they're really interested in reducing the hazards out front. And that's how they're defining SAFER. And in addition to the SAFER program, there are many private sector programs that are taking this approach. And I think companies would value some recognition of the progress they're making. In the apparel sector, for example, the Zero Discharge Alliance is moving in this direction. The electronics sector, the Clean Electronics Network, and the Responsible Business Alliance are both moving in this direction with hazard-based analysis. In cosmetics and beauty and personal care products, the Know Better, Do Better collaborative is another example of companies using the hazard-based information to systematically improve the profiles of their products, and to be able to assess for themselves, to characterize the chemicals that they're using, understand where the data gaps are, close the data gaps on hazard, and take the required action in order to systematically move themselves out of the chemicals of highest concern, and to share that data in a pre-competitive space so that the industry can move along. Even if they move along quietly, you can kind of transform the whole industry. And I just point out something that Marissa said earlier too. There are many examples where the industry is well beyond compliance and has identified whole classes of chemicals and certain functions that could easily be restricted or banned because the industry has moved on. And American manufacturers would actually appreciate that protection from overseas competitors who might not have the same standards. So that's my perspective. It's outside of the TSCA bubble. And people tell me that there's no chance we're moving to a hazard basis of anything at the EPA, but I think there's really a growing demand for that, even in business.
All right, Maria.
I just want to build on what Bill said. I mean, I heard transparency is an important component. I think focusing on hazard, which leads to trust. And so much of the conversation with new chemicals is about EPA in the industry and not about the other stakeholders, about the consumers, about the general public. And I think for EPA to move toward truly safer chemicals, and I know it won't focus on hazard, but maybe a way to push it some is for EPA to consider the other stakeholders. And I know they say they do, but there's so much of a conversation between EPA and the industry. I know labor is trying to get more information. They're not really involved that much, let alone, fence line communities. And now that I'm at a NGO coming from EPA, I mean, just like the transparency and seeing the information available, it is so different. But I think this translates to trust in chemicals. And this was the issue, I think, that led to Lautenberg, that there was such a lack of trust. And I just see that happening more and more. And, if you're just going to have this arm wrestle over exposure and people aren't sure if chemicals are safe that are in their consumer products, it's, it may be a short-term benefit, but it's a long-term loss.
You got thoughts, John?
I agree with everything. I don't have anything to add.
Anybody else have anything to add?
I'll wait for the next question.
Okay.
We got to move on.
All right. Question 5. How are EPA's decisions viewed by downstream users? Example, the consumer-facing brands, as compared to manufacturers. You ready?
Sure. So we a lot of our clients have really struggled with market acceptance of their new chemicals after they've been subject to consent order and/or SNR. So even if EPA were super efficient at getting SNRs out with orders, which that it's quite a lengthy time between the order signed and when the SNR is out, and that's problematic for a lot of reasons. But even if they were coming out simultaneously, or even in the years that EPA was using the non-order SNR authority, which of course is now gone, an order or SNR is, in our experience, in our clients' experience, a significant market disincentive, even if it says you can do what you want to do. The company usually doesn't have a problem with the restrictions and documenting them, but especially folks downstream that are not TSCA savvy, they're not practitioners, they're blending, or they're end users, and they've never had these record keeping burdens. They've never had to deal with TSCA 12B export notifications. They've never had to deal with some of the other record keeping that's required. They look at this and they say, I don't know what this means. We try to educate them. We try to educate them on what the record keeping requirements are and what the orders mean. And they just like, you know what? I don't want the enforcement risk. I don't know what it means. I don't like the look. And they just back away and they stick with the existing chemicals. And for, when we have these less hazardous things that people are working so hard to find and identify and deploy, to have them sit on the shelf because they have these sorts of market disincentives, to me is a real shame, because we're losing out on the opportunity to improve things. Because as Larry said, or sort of implied, right, the existing chemicals review, we're going to get through 500 or 1,000 of them maybe at 5 per year. I mean, that's a lot of years. We're not going to get through 40,000 of them. And so can we use innovation and lower hazard things to displace more hazardous stuff? And how do we do that in a way where these new chemicals that are very good, but don't meet EPA's low threshold, how do we not put these market barriers in place? And Bill, I don't know if your clients or if they struggle with the same thing that we've observed, because you're at a different place in the market.
I think various companies are in different places themselves based on their own brand positioning in their own sector. I'm not speaking for any of them. They're not even my clients. They participate in a kind of a collective endeavor to contribute. These are companies who are on their own journey towards safer chemistry, contributing money to a fund that gets re-granted in order to help solve bottlenecks and problems and implementing it further into the supply chain. And the imprinter of EPA saying something poses no risk under foreseeable use scenarios does not really protect them from the consumer base, who's increasingly finding out more and more information about their products. And my observation is that companies who used to kind of view the traditional NGOs, EDF, or the Toxic Free Future Group as antagonists increasingly see them as safe harbors, because they actually have defined programs for progress. A company can understand what we need to do in order to get an A on your report card. Whereas in this uncontrolled environment of influencers who can seize on any problem in the supply chain and attribute it to the most recognized brand in that supply chain, the companies are just trying to distinguish between science-based, honest efforts to improve their products, good information that their consumers receive, versus opportunistic influencers who have no endpoint and simply want the clicks on the controversy. So increasingly, this may be a change from even when the Lautenberg bill was passed, that I think there is a growing alignment around the interests of chemical-using businesses, environmental and health NGOs, and the general public to find a way to break some of these log jams. And I think much greater transparency and trying to expedite low-hazard chemicals, identify low-hazard chemicals faster, are a couple of points of common ground that we could explore.
All right, I'm going to move us on to the next question. This is a short question, but everybody wanted a piece of this. So let's just go to it. Is there an innovation crisis in U.S. industry? You want to lead it off, Larry?
Sure. I think what is determinative is how that's measured. So when the question was first contemplated, I started doing some online research, and there are grave pronouncements that big thinkers have made about the crisis of innovation in the US. And they've looked at everything from, or the people who were espousing this were remarking on everything from government funding to research institutions, the lack of, if you will, trickle down of the technologies to the operational phases in the states, and other sort of big thought processes. And I started asking myself, okay, but what does that mean for why we are here? And I suspect the question of the day might be, is TSCA, as it was amended, having an influence on innovation in the US? Then I started thinking, okay, well, how do you measure that? And some of the things that came to mind were, all right, are there fewer PMNs submitted if PMNs are a metric of novel chemistries? Novel meaning they're not on the inventory, at least. And I think the data support that there's been a decline in the number of PMNs submitted. Is that because of the statute? Is that because of fees? Is that because of the way the program for new chemicals, at least, is being implemented? I'm not sure I know that any one of those is the single contributor. I know that some of the things I frequently hear from clients is that the operational costs and time lag to get a new chemical through the process often leads to offshoring of substances, particularly when it's smaller volume chemistries that are more bespoke chemicals that are specifically engineered and manufactured for highly technical uses in the US. And so I think that is something that we should contemplate, and whether as a matter of public policy, we want to encourage more manufacturing scale chemical production in the US or not. I think from a regulatory perspective, there may be some people who would say, all right, that's not so bad. Maybe we don't want chemicals made in the United States. Maybe we don't want them released. And it certainly gets a PMN through the process easier if you can say, well, I'm only going to import it. It's going to be in small quantities, et cetera. So I think I would say our government writ large and our policymakers should ask themselves that question. I think they should go beyond the question of how many PMNs per year they're being submitted. And I think we should ask ourselves, really, what is innovation? Are new chemicals serving innovative industries that we want to have present in the US? Are the industries that we want to incentivize producing things that are having societal value? And I don't think there's any questioning going on about that. And I also don't know whether we're asking ourselves whether we are incentivizing regulatory agencies to be innovative. Again, I fear that the bean counting in EPA that is a product, I think, of the amendments to TSCA have disincentivized innovation within the regulatory sector. I don't think anybody's sitting around saying, I ought to call Bill and see if he can get, a bunch of the women and men with whom he works to come on in and talk to us about how we could make things better at EPA. I fear that the loss of that will lead to a continued lack of innovation sort of within the states. And I feel like on the international stage, we've lost that. In the chemical regulatory stage, we've lost it. I don't have an answer for how to get it back. I don't think amending TSCA remedies it necessarily. But I do think it's a fulsome topic that really should be focused on.
Okay, good. John?
Yeah, so to begin, and I don't interpret Larry to be saying this, but I would urge us not to define innovation based on the number of new chemicals that companies want to manufacture, the number of approvals that EPA is granting each year. I mean, I think there are a lot of new chemical submissions that are not that different from existing chemicals. And I think it's actually one of the ironies. Like, people talk about kind of, well, TSCA's delaying innovation, it's killing innovation. We have all these innovative products that aren't coming to market. And then you ask the PMN submitter for kind of a complete data set, and they're like, oh, we don't have it, but it's structurally, and the uses are similar to these other chemicals. So just compare it to those. So I don't have a definition that I would use for innovation, but I do think that we're living in a time of remarkable technological change and advancement, and that's even with the existing TSCA and EPA taking more than 90 days to review most new chemicals. And I think if you ask the average person whether they'd be willing to sacrifice their family's health to accelerate that technological innovation, however defined, I think the answer is going to be no. And to some extent, I think that's what we're seeing with the opposition locally to data centers that's popping up across the country. So even if there was an innovation crisis, whatever that means, I think Larry's right. The critical question is, what is causing it and what do you do about it? Was the United States significantly more innovative in 2016, kind of when TSCA was amended, than it is in 2026? I mean, I don't think there's anything that I've seen other than maybe EPA is approving fewer new chemicals, which I don't think tells you that much about innovation, to suggest that TSCA is really stifling innovation. And I certainly don't think that rushing more new chemicals through the TSCA review process is going to make us any more innovative.
Okay, Maria.
So could I start off and push back a little bit on Larry? So bean counting is a result of the industry pressure. It's not a result of Lautenberg. And this happened immediately after Lautenberg. And I see Greg shaking his head. So just from firsthand experience on that. And I totally agree with what John said, but I just want to talk a little bit about EPA's own statistics. Since the Lautenberg amendments, almost 2,000 chemicals have been allowed to be commercialized either with or without restrictions. And that's almost 80% of the approximately 2,500 cases that EPA has, it's gone through a full review. Only 1% were not allowed to be commercialized. And 20% were withdrawn by the company. Further, more than 2,200 low volume and low release and exposure exemptions have been granted, and that's 80% of the exemption requests submitted to EPA. So between the chemicals that underwent full review and those that were exempted from full review, 50%. And they underwent an exemption review, that accounts for more than 4,000 chemicals. And I think one should consider that in innovation. And as John noted, many of these are variations on a theme. The second thing we've heard about innovation is that any restriction on a chemical impedes innovation. But these restrictions may be the use of gloves, or maybe not allowing a chemical to be used in a consumer product because it's a sensitizer or cause developmental harms. And certainly these are restrictions that most would see as eminently reasonable. Is allowing a toxic chemical in a consumer product or not having a worker safety program, how we are defining innovation. And then I wanted to follow up on something that Bill said. And, there are companies, very successful companies, and I work with some of them at EPA with Canada as part of an effort looking at supply chains. And the successful company approached it totally different and just said, we look at chemicals by categories. And they're very innovative. And so there are certain categories of chemicals they just won't use. They don't go through this one by one and trying to control the exposure. So I think there's more than one way to look at innovation. And then finally, I think something that is useful and does not cause harm, that's the true innovation. And I wanted to go back to what Marissa Smith said, where do you need to use PFAS for something where you need preservation for 3 days? And everybody knows PFAS lasts forever. So I think that's another important point.
All right, Rich, you want to say anything?
Yeah. So I mean, again, I've seen example after example of demonstrably greener things being held up, unnecessarily restricted, or if allowed to go forward as intended, seeing the orders in the SNRs lead to market deselection. But in terms of a specific example about innovation, I need to be careful because there's the certain aspects of the case are still CBI. But the company developed a laundry ingredient, a bio-based, biodegradable laundry ingredient to replace a petroleum-based, non-degradable one. EPA determined that it was be efficiently removed during wastewater treatment. EPA's only concern was aquatic. But the EPA said, no, we have to have this surface water concentration limit with an order in a SNR. And I tried to do a calculation to show that I could not come up with a scenario that would exceed EPA's concern threshold, even using running the entire volume through EPA's worst case single small processing facility. The production volume would have to increase fourfold. So again, this imaginary small facility, the 4 times the production volume would be required to go through the one facility to exceed at that facility, as opposed to saying, well, is it more likely that there would be a second facility so you wouldn't end up exceeding? So we went around on this, and I asked the EPA, the new chemicals assessor, can you give me a reasonably foreseen condition of use where there'd be an exceedance? And they said, we don't do that. So even though we couldn't identify a condition of use that exceeded, because EPA had that concern threshold, and it was moderate, I'm not saying that it met the low toxicity threshold, but and we went around and around with EPA for quite some time on this, and the company, the innovator, was looking to expand, and they built a facility in Finland, and so they're a gazillion-dollar facility they built in Finland so that they can make this product. They've been deploying it throughout Europe. It's just now starting to be considered as a product in the United States. And so here in the United States, we are not getting the advantage of this demonstrably better product because EPA thinks that somebody someday might. Once it's on the inventory, anybody can do anything, even though EPA, not that they look at the database anymore, EPA couldn't identify an exceedance. They said, no, until we're sure that no one is going to do anything else, we're going to restrict it. And, so there's a specific example of this innovative, greener product that we've not only been delayed in years having access to, but the innovation has gone overseas.
Okay, that's a good discussion. We got time for one more question if everybody's quick with their answers. I kind of like this one. Do other countries have better systems for completing new chemical reviews on a timelier and more consistent basis than TSCA? Or are they less protective? If so, what about the other systems makes them better? Can how they assess and regulate new chemicals be viewed in isolation of how they regulate existing chemicals? Larry, you get the lead off here.
I'm not sure there's a clear yes or no answer. I will say that what I often hear is that it's easier for particularly lower volume substances to enter the market in markets and jurisdictions having a REACH-like approach where there may be a minimum data set requirement, but that there would be volumetric triggers. I'm not convinced that the REACH approach necessarily is more effective at regulating individual substances as opposed to categories or taking broad swaths of substances under examination after registration has occurred. But nevertheless, I know that there are some people who favor the ease of market entry in those places where you merely generate a dossier.
I would say predictability.
Good point. So I'm trying to be brief and yield the remaining seconds to others, but that's my thought.
Okay, Maria.
I think if you're going to look at something like REACH, you would need to look at all of REACH. It's rather than, picking and choosing. But looking at how other entities review new chemicals, and there's a question out there also on whether you should rely on approval from, let's say, another OECD country. And our moderator here is an expert because he was on an OECD task force that looked at this question, and I think there was agreement. Maybe I'll let you finish.
No, I think that was the OECD New Chemicals Task Force, but they worked together to try to solve problems that cross jurisdictions. And it was a nice program because we were starting to get industry buy-in in terms of developing data and looking for solutions that cross the board. Whether any of these programs were better, I don't know. I know China brought over a whole team of U.S. experts back in the early 2000s because they modeled their program initially on the U.S. program that Larry helped develop a long time ago. So it's other countries look to us for a while. I don't know what the status is now.
Right. And I think what happened was there was agreement among the countries in the OECD that you shouldn't accept the determination that maybe sharing hazard data was good, but that just because one entity approved it, it didn't mean that it should be accepted by the United States, for example.
Right. We had a parallel process where countries could work together on an assessment of chemical that was being introduced in multiple jurisdictions. So you wanted to
just
weigh in?
one sentence on REACH, because as Larry alluded to, in Europe under REACH, you can have new chemicals come to market without any affirmative risk determination or approval at lower volumes. I mean, we had 40 years of experience with that under TSCA. That was what the original kind of 1976 law did, and I think it created a ton of problems. So I do think there are certainly elements of those other systems that I would be wary of.
Anybody else want to weigh in on this one? We got an extra minute.
I think we're in extra time. This is like penalty time. I do think it's important feature of REACH and other programs such as that there is a minimum data requirement, and we've shied away from that in the States. I don't want to undermine my credibility in my job, but not a bad idea. I do think, though, that one of the facets of the U.S. program that I think lends itself to being a good idea is that we're often looking at substances in, I hope, under their intended condition of use, because I think that dictates to a great extent exposure, in addition to hazard being a factor. So I think it would be a shame if we opted for a minimum data set without also a concomitant willingness to look at the intended use, at least in terms of new chemical authorizations. It's just my personal perspective.
A minimum data set would be very good for hazard and environmental fate, and particularly set up in a way so that, like, for persistent bioaccumulative toxic chemicals, there was one minimum data set, and for sensitizers, there's another. So I'm a supporter of that.
Yeah, we could have consensus on that. I would save this video of Larry supporting a minimum data set.
I think we'd be more supportive of that if it made a difference in the outcome.
You ready, Madison?
Thank you so much, Greg, Larry, Maria, Rich, John, and Bill. We so appreciate you all joining us. We will now go into our next panel titled 10 Years of Lautenberg, Where Are We? This panel is being moderated by Jeremy Bernstein, who is a publisher at Inside EPA, where he has reported on all things EPA since 1992. From 2000 to 2022, he wrote a biennial post-election analysis for ELI's Environmental Forum. Jeremy has a bachelor's degree in journalism from Rhodes University in South Africa and a master's in journalism from Northwestern University. Jeremy, I will turn things over to you. Thank you.
Hi, good afternoon. Thanks to Lynn Bergerson and Bob Sussman for inviting me to moderate this panel and for putting on such a great conference. And thanks also to the great panelists we have here this afternoon, who I know have a lot to contribute. I'll introduce them quickly just by their titles, but you should take a look at their bios in the program. They're all very accomplished. Grant Cope is Environmental Health Policy Lead at the Michael J. Fox Foundation for Parkinson's Research. Jerry Curry, Senior Policy Director, American Fuel and Petrochemical Manufacturers. Honorable Lynn Goldman, Professor of Environmental and Occupational Health and Dean Emerita at the Milken Institute here at GW. Mike Gruber, Chief Operating Officer, Household and Commercial Products Association. Ryan Jackson, VP Federal Affairs at the American Chemistry Council. Dimitri Karakitsos, Partner at Holland and Knight. Bob Sussman, Principal at Sussman and Associates. And Tracy Woodruff, Professor of Epidemiology and Population Health and Senior Fellow at the Woods Institute for the Environment at Stanford. The panel is intended to synthesize a range of information and views from this conference and provide some insights from key players on and off Capitol Hill into how and why the Lautenberg Act was enacted and how it has worked in achieving its goals. What were the forces that drove the legislation forward? What were key stakeholders' goals and expectations of the time? What are the law's successes and failures so far? How is EPA doing? Have the law's core paradigms been validated? And looking ahead, is now the right time to be amending TSCA? And if so, how? The law was passed with great optimism that it would provide certainty and public health protections. But it seems in the 10 years since its passage, those expectations have not been met. As Lynn pointed out earlier, the law's implementation over the last 10 years and across 4 administrations has seemed like a roller coaster of competing legal interpretations of some of the law's most significant provisions, scientific debate and analyses, rulemakings, delays in meeting TSCA deadlines, and major milestones. The result is nobody is getting what they wanted. Industry is not getting the certainty it needs to quickly get new chemicals to market, and environmentalists are not getting the public health protections they were hoping for. Many now acknowledge the significant ambiguity and discretion baked into the statute, a fact that likely hasn't helped provide the policy stability many had hoped for. But the results of the roller coaster are evident in the deliverables. EPA has only begun to regulate a handful of existing chemical uses, and on the new chemical side, 409 chemicals, representing more than 90% of active PMN cases, have been under EPA review for more than 90 days, according to ACC's tracker. While such results may not be expected from a relatively new environmental law, they do not appear consistent with the heady optimism that followed the law's passage. To dive into these issues, I'd like to turn it over to the panel. We'll start with an introductory segment where each panelist has 2 minutes to tell us who they are, what they do, what were their roles in the legislative process that led to the Lautenberg's enactment, and their current roles regarding TSCA implementation. We'll then move on to a series of segments where I'll frame an initial theme with a series of questions that are intended to stimulate conversation and discussion, and the panelists will dive in from there. Grant, why don't you start with the introduction?
Okay, great. Thank you, Jeremy. My name is Grant Cope. I work at the Michael J. Fox Foundation on Parkinson's disease. About 26, 27 years ago, I moved to DC out of law school and started working for a national nonprofit running campaigns, national campaigns on environmental and public health issues. I eventually found myself on as a senior counsel on the Senate Committee on Environment and Public Works, where whoever knows Chairman Boxer, Senator Boxer, everything was about protecting children, protecting public health. And so the main issues that we really focused on with TSCA reauthorization, which started way before Lautenberg, started in like 2010, 2009, were a safety standard based upon reasonable certainty of no harm, which is brought over from FQPA. Minimum data sets to ensure quality data going to the agency so they could make decisions expeditiously, and there was a lack of uncertainty in terms of kind of decision making. No conflict of interest when it comes to making decisions about children's health. Who could argue with that, right? couple of other things really struck home too in terms of the level of protection that we were looking for. But when 2013 happened, we passed bills out of committee a couple times. When 2013 happened, all that dramatically changed, I think in large part due to the fact that there were certain senators who wanted to strike a deal with industry so they get Republican support. And so safety standard based upon reasonable certainty, no harm, gone. We had minimum data sets, gone. Making decisions based upon the best available science that looked at what the NAS said it was, the National Academies of Science, gone. So from there, I quickly shifted to when the Lautenberg Act actually was being debated. At that point, I was working for Cal EPA, negotiating on behalf of ECOS in the state of California around preemption. Why that was so important to me is because if the federal law didn't have some of those core protections, I knew that the states could provide that backstop against whatever the federal government might do. You've got California, you've got Minnesota. They'll regulate by class. You can look at what California's done with PFAS. It's amazing. And so at that point, working for the states, I really dug into preemption. But that was really kind of my role overall, on Hill and then working for states.
My name is Mike Gruber. I'm with the Household and Commercial Products Association. Our association makes disinfectants, cleaning products, floor care products, pest control products. I've been involved with TSCA since about 2014. When I was with the Grocery Manufacturers Association, and part of my portfolio was personal care and household products at that time. I had been hired to handle food policy in this portfolio. It was handed to me. I called my friend Jerry Curry, my former colleague on the Energy and Commerce Committee, and asked, what's TSCA? So here I am on a panel all those years later, but our primary interest at that point in time was really Section 5. Our companies in that space were interested in newer, safer, more sustainable chemicals, and that continues to be what I'm working for now with this trade association. And in terms of GMA's role at that time, it was one element of many within the industry, and it was relatively small compared to many of the other issues that were being discussed at that time. So I still feel like I'm learning the law. I still feel like I'm learning the politics of all of this, even though it is an issue we talk about every single day.
Lynn?
Hi, yes, I'm Lynn Goldman. I am a pediatrician and epidemiologist by training. Started my career in public health working for the state of California as well, and then served at the EPA as assistant administrator for what is now called the Office of Chemical Safety and Pollution Prevention. It had a different name then, but it did the same thing. And after leaving, and I was there in the 90s during the time when we celebrated the 20-year anniversary of the enactment of the statute in 1996, and where most of the people who came to speak, and we had a series of speakers, had given up on the bill. Especially the environmental groups, labor groups, public health groups, felt that nothing would be achieved. And part of that had to do with the asbestos decision, that the failure of EPA to regulate asbestos. But I have to say there were other reasons. So many grandfathered chemicals, lack of effective use of test rules to get information about those chemicals, almost autopilot, very rapid approval of new chemicals coming onto the market without really any health examination being done other than structure-activity relationships, which are very limited. I mean, we know a lot more about that today, but I'm talking about what we were doing in the 90s. And probably in 20 years, people will think what we're doing today is kind of pathetic. So, because the science keeps evolving. And so, at that point in time, and I was very committed to seeing the bill change, but it took a long time after that, not until 2017 for that to actually happen. If you think about that, that was another 20 years. And I do think that, I recall, and Bob Sussman was there sometimes, the planning meetings for the agency's budget office and policy office always wanted to cut our budget because everybody thought that TSCA did nothing, the people who worked inside the agency, which was not true. I mean, it did maintain an inventory. We knew it was on the market, many things that it did do, but it was the good things were invisible, and the things that people cared about, like dealing with an asbestos or a bad actor, weren't happening. My role since then has been as an academic. I went to Hopkins. I served here at GW as the dean of our public health school for 15 years. And during that time, I was able to do a little bit of, advice and consulting with Congress as they were looking at the statute and the reform of the statute. But really, that's my role today. I don't have any direct role, in implementation of TSCA.
Ryan?
Yeah, good afternoon. My name is Ryan Jackson, and I guess I'm the newbie on this stage. I've only been working on TSCA since 2015. So, I'm just getting started, I guess, Bob. I worked for Senator Jim Inhofe from Oklahoma, originally an Oklahoma guy, for 20 years, and became the staff director at the Environment Committee in 2015, 2016, to work with everybody on this stage and others in this room, and more than that, to take up the work that had been built up over years and try to push it across the finish line, which ultimately we did in the middle of June of 2016. As always, when you're putting together legislation, it's always a compromise. Nothing is ever perfect. There's a lot of discretion built into it. It's hard to avoid that, but now at the American Chemistry Council, trying to help our member companies, get their products through the process, try to help with, good administration, good implementation of TSCA and the Lautenberg Act changes. And, this Congress offers an opportunity to make a tweak here, maybe make a tweak there. There's a fee reauthorization, and Congress builds that into laws from time to time to give an opportunity not just to, cross out a date and add a new one, but extend fee authority, maybe add some things that give the act a little bit of clarity, working on that too.
Bob?
Yeah, I'm Bob Sussman, and I've had many close encounters with TSCA over my long career. I cut my teeth virtually out of law school on the enactment of the 1976 legislation, and then the early years of implementation, actually representing what was then called the Chemical Manufacturers Association and is now ACC. I escaped from TSCA when I went to EPA in 1993. I was the deputy administrator at the agency for close to 2 years and worked closely with Lynn, which was a great experience. Then I went back to private practice, and I became involved with the Obama campaign, and so I went to EPA again in 2009 as senior policy counsel to Administrator Lisa Jackson. So that brings me to the legislation, and interestingly, one of the very first things I did at EPA was to help the administrator draft a statement of legislative principles on TSCA, which was, I think, an important step by the administration. It laid out a framework for TSCA reform, which of course evolved, but many aspects of that original framework remained viable. Then I left the agency in the middle of 2013 and was able to get myself hired by Safer Chemicals Healthy Families as their counsel on TSCA legislation. And I took that position at a very fraught and difficult moment. There was, on the one hand, serious interest in the legislation in the Senate and also the House, but the situation was fairly difficult. There had been a bill that was drafted by Senator Vitter, which the NGOs and the NGO coalition were very concerned about. And there were also fractures within the NGO coalition at that point. So it was a difficult time to get engaged, and my role continued through the enactment of the new legislation in 2016. And I will say that seeing it from the NGO perspective, it was a classic glass half full, half empty situation. There were certainly things in the legislation that were significant improvements, but the NGO community wanted more than was on the table. There were a couple of hot button issues that were important to the NGOs, and those issues were, I would say, not fully resolved to the satisfaction of the NGO community, and also to the satisfaction of some members of Congress. I think your boss, Senator Boxer, was probably among them. There were people in the House who were also disappointed and frustrated, but nonetheless, the Congress came together. The legislation was passed with a very healthy bipartisan majority. It was signed into law by Senator Obama, and so the rest is history.
Dimitri?
Yeah, thank you all for having me. Dimitri Karakitsos, we're calling tonight. I was on the Senate Environment Public Works Committee Republican staff from 2009, started 2009 to about 2016, end of the year post TSCA. I think it was about 2011 when a colleague came to me who was leaving and said, "There's this TSCA thing. We never really do any work on it except for oppose Lautenberg's bill. So just take it over and it won't be a big issue for you." So that was about the start of my TSCA career. You know, as Bob alluded to and Grant alluded to, it really had been a partisan process for a while until Senator Lautenberg requested a meeting with Senator Inhofe and came in and said, "Hey, you're close to industry. I would love for you to help get them in the room so we can have some listening sessions and hear if we can bring the sides together." So we became, as staff, Inhofe and Lautenberg at that point, hosted a number of roundtable discussions with industry, with NGOs, to see where we could go and see if there's places we could find common ground. Ultimately, it looked like that was kind of fading, and Senator Lautenberg was going to reintroduce his bill, and that's when I think we were kind of given the instruction to start working on our own product. But rather than have it be, you know, where we viewed the Lautenberg bill on the spectrum, maybe at the 10-yard line, you know, not put it on the other 10-yard line, put it on the 35, put it on the 40, have it closer. So, you know, once folks internally, I think, saw that we weren't just putting out a bill to be a messaging piece, we were actually trying to advance the ball. That's where, you know, on the Senate side at least, the real bipartisan process kicked off, and it did lead to a 2013 bill introduction. So I think on the Senate side, at least, Senate Republican side, I think, well, Senate side writ large, I was the only kind of person, I think, through the whole bipartisan process from start to finish. Now at Holland tonight, working with a number of clients, working on kind of navigating the process and implementation of the process. I will say, Bob, just to make you feel better, there was certainly a bit of consternation and disagreement on the industry side also. And I can
We
tell.
thought they were monolithic.
Yeah, I can tell you I sat in a room with a bunch of conservative groups one day who read me the Riot Act because least burdensome was the best thing in any environmental statute ever, and we should export it to all of them, not be removing it from TSCA.
Absolutely.
So we all had our own, I think, battles throughout the process.
Jerry?
Good afternoon. My name is Jerry Corey. I thank you to Burgesson and Campbell and ELI for the invite, and I just want to say I'm so honored to be on a panel of such distinguished and accomplished people to talk about everybody's favorite four-letter statute, the Toxic Substances Control Act. The reason I'm on this panel is for about 35 years of my life, I worked on Capitol Hill. The vast majority of the lion's share of that time for the House Energy and Commerce Committee dealing with environmental policy and regulatory policy at EPA. Dr. Goldman and I back in the green room were talking about our foray into the TSCA universe in the early 2000s with the Energy and Commerce Committee's attempt to try to, what's the word I'm looking for, provide implementing legislation for the Persistent Organic Pollutants Treaty, the Stockholm Convention, and the Rotterdam Convention on Prior Informed Consent. So my contact with TSCA, unfortunately or fortunately, is more than passing. I did get to sit through a number of the reviews of legislation back in the early 2010s, the Kids Safe Chemicals Act, and then leading up to the Chemicals and Commerce Act, which is where the Energy and Commerce Committee started in the Congress right before the Lautenberg Act was enacted, and then worked on the Lautenberg Act itself. There were a series of hearings when Republicans took the majority back in 2010 that I put together to kind of help educate members, not only on the history of TSCA, but to get them to be able to level set on what's real, what's not, and the impact, because TSCA is a Title 15 statute that governs manufacturing, interstate commerce, and has a tremendous impact on American innovation and whether we are a serious manufacturing country. And so, yeah, these guys have largely covered some of the other stuff, and I don't want to bury the lead here, but we got the questions beforehand, so I know what's coming and don't want to chew some of that material up just yet. But yeah, it's a pleasure to be here, and now I work for the American Fuel and Petrochemical Manufacturers, working on TSCA, among other things.
Tracy?
Hello, I'm Tracy. I'm a professor at Stanford University, and I'm on this panel because I've been working on toxic chemicals and best available science and decision-making before and after the 2016 TSCA amendments. So I'm a scientist. I study how toxic chemicals and pollutants harm health, and they do, and they are contributing to the rise in chronic disease. I'm also an expert in best methods for evidence evaluation and risk assessment. So I had spent years documenting exposure to toxic chemicals and health harms to highlight the flaws prior to and during the TSCA discussions. So during the TSCA legislation process, I worked with public health groups and the American Congress of Obstetricians and Gynecologists to help policymakers understand the importance of including pregnant women as vulnerable populations included in the amendments, and to establish the Science Advisory Committee on Chemicals, the SAC, which also is in the amendments. But I just want to say the bigger picture here is that the 2016 law retained the fundamentally flawed structure, which puts the burden on the government and the public to prove existing chemicals pose a health risk, which was different than what Grant talked about in terms of the original proposed bills. rather than requiring the industry to provide adequate data to determine that either the chemicals on the market are safe, and if not demonstrated to be safe, are then regulated to remove risks. This disincentivizes innovation to safer chemicals for existing chemicals, and it incentivizes the industry to delay and obfuscate the science for risk evaluations for existing chemicals. So we've seen this fundamental flaw borne out in the implementation, which I have been involved in since 2016. In particular, we have been recommending how the agency should use best available science, in particular systematic reviews, which have been identified by Congress and the National Academy of Sciences as providing the most transparent, consistent, and reproducible risk assessment based on science, not stories. We have provided expert scientific public comments on almost all of the risk evaluations. We've commented on all the risk framework rules, and we have commented on most of the proposed risk management rules. We are really the only academic institution that have been involved in bringing the best available science to inform these decisions, including recommendations from the National Academy of Sciences in multiple reports and peer-reviewed literature that is unbiased. So this results in several thousands of pages of public comments. And what we're seeing is that the agency is bending under the weight of this process. The risk evaluations are inadequate and will continue to leave the public and workers exposed to harmful chemicals.
How are we doing on time? Bob? We okay on time?
We've got 49 more minutes.
Okay. All right. The next segment, I'd like to talk about what some of the stakeholder goals were at the time that TSCA reform, the Lautenberg Act, was enacted in 2016. And I'd like to get a sense from some of you what you felt the driving force for bipartisan collaboration and agreement were, and why the final law got such overwhelming support from both Republicans and Democrats. Dimitri.
Sure, and I'm sure a lot of folks will have a lot to chime in on here, but I can say, from the Republican perspective, at least, there was a growing unworkable patchwork of state regulations. And as Jerry said, this is not a statute that regulates air coming out of smokestacks or, water coming out of water pipes into water systems. This is regulating, intentionally created products for commerce. So really having a workable kind of federal system that would not hinder interstate commerce was a huge driver there. And I think folks really wanted it to be as credible as possible, as workable as possible. And then, not that it was a driver, but one of the guardrails, around it is something we've already talked a little bit about, is the desire to have kind of a very sound science process within that, and some accountability and transparency. I'll just say very briefly, I think, the driver that I saw, at least from Senator Lautenberg and others at that time, was the existing chemicals process, and the fact that the 76 law had the asbestos case and had really failed to regulate any existing chemicals. I know we ended up getting into new chemicals and a whole lot of other stuff, but the true driver, in my opinion, was really the fact that even asbestos and there was no chemicals really that the system could take that were existing and regulate at that point.
Grant?
Yeah, I would totally agree with Dimitri. I would also add on to that. One of the things that we did in oversight hearings and investigations is, let me back up. I would talk to people from ACC, I would talk to people from Consumer Product Specialty Association. I would, both kind of upstream and downstream companies. And I think a big concern from a lot of front-facing companies, consumer products companies, were that they were being given bad chemicals by upstream companies. And they were getting hammered in the press. They were getting hammered in Congress. And they were taking a hit from consumers because their products had these dangerous chemicals in them. And so to the extent that I could, as a senior counsel on the committee, when I would hold hearings, I would want either written or in-person testimony from companies. Because they would tell me kind of off the record, yeah, we can't really say anything public about this because Exxon would just be breathing down our neck. Okay, that's fine, I understand. But like, what are you willing to say publicly to support these types of efforts? And so having that division between upstream and downstream companies, I think was also a pretty good catalyst for action.
Can I say something here too? I just want to highlight how important the industry wanted preemption in the TSCA amendments because a lot of states had been passing laws because TSCA, the 1976 law was so ineffective. States were moving forward to pass laws to protect their citizens from toxic chemicals, and they varied by states. And this also, the industry wanted to have a mechanism to be able to overrule states' laws. And now they say it's uniformity, but the problem is that what we're seeing in the implementation is that if we have weak laws at the national level, though to be fair, we have no risk management rules yet because the industry is suing on all of them. But if we have weak laws at the national level, this is a challenge for states who want to move ahead and use best available science and do more to protect their citizens.
Mike, two things, preemption and upstream and downstream issues.
Yeah, I mean, I represent formulators and downstream manufacturers. So at the time, our companies were getting hammered, and that was our primary motivation for advancing TSCA reform back in 2016. Preemption is just difficult. Yeah, I think companies would prefer it. There was an obvious concern about the growing patchwork of state laws back then. That is an issue now. When I started lobbying back in 2012, I was happily enjoying federal government relations. Today, probably 85% of our work in our association is state issues, state proposals, laws that are being implemented in the states, and trying to navigate that for our member companies. So, preemption, depending on the Congress, it may be more advantageous if you're a proponent of preemption to get it, that to the finish line. But I think that's increasingly difficult now. So it's not become a priority for us. Although for many in the industry, it would make their lives a lot easier.
Lynn?
So I could add something. I think that things had really changed in terms of the global picture. When TSCA was enacted, it was the first national chemicals law in the world. And it was kind of the golden child. Everybody wanted to have a law like it. And by the time 2016 came along, EU had enacted REACH, which was far more protective, far more stringent. It really gave an advantage to the European chemical industry. Our companies had trouble dealing with REACH. Even Canada, CEPA, the Canadian Environmental Protection Act, was recognized as being, more protective of the public's health. And I think that was, our exceptionalism had kind of gone away. We had an advantage in commerce that we had chemicals that were approved in the United States. Well, what became an issue for countries other than the US and Europe and Canada were, well, what about REACH? Is it REACH approved? Not, is it US approved? And that wasn't easy. And now, not that that impacted all the companies. Not all the companies are involved in global commerce, but I would say a lot of the larger ones are and cared.
Jerry.
I want to agree with Dimitri on something and develop his point a little bit further, if I can.
2 minutes.
I'm a house guy, I can do it. The Energy and Commerce has a very broad jurisdiction. When you're regulating a chemical and its impact on commerce, we're talking about supply chains potentially, not just the manufacture of that chemical. And we learned that during COVID when supply chains became front of mind because various parts of it were not as strong as they needed to be. What the members on my committee cared deeply about was about making sure that conflicting claims about products a uneven domestic marketplace and the inability for people to coherently do business in this country be made more regular about it. That was the driving thing. It wasn't trying to stop one state or another. It was about making sanity out of the insanity that was developing.
Okay, I'm going to move us along to the next segment. Like you to talk about successes and failures that you've seen so far in the Lautenberg Act. Suggested issues to discuss. Is the law resulting in too little public health protection, or is EPA overreaching? Is Section 5 incentivizing safer chemicals, harming innovation? Has EPA fallen short of the law's deadlines, and what are the causes of this underperformance? What role have funding and resources played in implementation? Bob, do you want to start?
Yeah. If I can, I want to return to the origins of the Lautenberg Act as a way of creating a backdrop for looking at implementation. If you go back and you read the legislative history of the original 1976 law, you would get the distinct impression that that there was a chemical crisis in our country. The rhetoric was very alarmist. The image was a country that was being inundated by a sea of chemicals, which were poorly understood, that chemicals were causing significant adverse effects and were being allowed to enter the marketplace before those adverse effects were really understood. And so if you read the legislative history, you would expect that this statute would be immensely important. It would be aggressively implemented, and it would tackle some of the really big problems that Congress was concerned about. But the reality is that TSCA, for its first 40 years, was a backwater. And I saw this when I was at the agency for the very first time. And it was apparent that EPA's priorities were elsewhere. They were on air, water, then Superfund, which was a huge issue, even on pesticides, which I think was considered to be more important than toxic chemicals. So TSCA bumped along for about 40 years of interest, of course, to the chemical industry and maybe a couple of environmentalists, but basically operating under the radar. And then I think that something changed around 2010, maybe a couple of years earlier than that. And the change was that there was an upsurge of public concern, media interest, grassroots activity on chemicals, much like the mood that had existed at the time the original law was passed. And so I think that focusing on the chemical industry, I think that the chemical industry thought that they had lost control of the narrative. And they were dealing with a crisis of public confidence. They were also dealing with activist states that threatened to displace the federal government. And so because of that, it was in the industry's interest to recenter the National Chemical Program on the federal government. And I think certainly the industry understood intellectually that if you wanted chemical policy in this country to be made by the federal government, not by the media, not by the states, then you needed a credible federal program. You needed a federal program which was perceived as being effective and addressing the big chemical threats. So to come to the question about implementation, maybe people will disagree with this and say it's a little too strident, but I think the chemical industry has really struggled with what it means to have a credible national chemical program. It's something which sounds good. There's a business rationale for it. There's a policy rationale, but the reality of a credible chemical program is that you got to regulate chemicals, and you got to get them under control. You got to get them off the market, and that's where the rubber has met the road. And I don't necessarily want to put the blame on the chemical industry, but I think what has happened here is, faced with the reality of commercially significant chemicals like methylene chloride or TCE or carbon tetrachloride, faced with the reality of those chemicals being regulated and probably banned, the industry has said, wait a second, our ox is getting gored here. This is not what we signed up for. And so I think the story of implementation is in many ways a story of very different expectations between industry and the environmental community, different definitions of what a successful program should look like. And I think in the end, resistance to a program that is credible and effective. And therefore, the first 5 risk management rules that EPA put out, which were on chemicals that had been of concern for decades, and everybody knew were bad actors. But all 5 of those chemicals and the rules EPA promulgated are now in court. And the issue in the court cases is, did EPA go too far? Did it ban chemicals that could be used safely? Did EPA get in the way of OSHA in regulating the workplace? And so when you look at these lawsuits, what I think is at issue here are fundamental questions about how to implement this law effectively.
Ryan, are there successes that your members would point to since under TSCA since Lautenberg was enacted?
Well, you have a existing chemicals regulatory process that at least is, starting the process of prioritizing existing chemicals, what the agency ought to be putting their resources behind and regulating. Unfortunately, there's more problems than there are successes with it. As everyone has acknowledged, preemption and having a national program and having that national program, really operate was a principal driver behind the law. But litigation causing uncertainty with that is not helpful. Missing deadlines under the law is not helpful for preemption to be enforced. There's front-end preemption and or pause preemption that, if the agency misses deadlines, it's not going to happen. And then ultimately, with missing deadlines, litigation, preemption on the backside, is not, materialized as well. And so perhaps it will, but 10 years in, that seems to be a problem. We've spent a lot of time talking about existing chemicals, but new chemicals and the process of getting new chemicals on the market, maintaining U.S. innovation status in the world as a driver of new products is a problem. You mentioned the stats about the backlog of new chemicals coming through the process. Earlier this year, Administrator Zeldin said that he was going to ensure that more pre-manufacturing notices are approved in this year than the last 5. We want to help him accomplish that. That is a tall goal. May not realize quite how tall of a goal that was, but we're gonna try to help him with that. But during the putting together the legislation 10 years ago, one of the arguments that was made was, well, we would really like to, for these changes we're making in the law, codify what EPA is already doing in administering the new chemical process. Well, okay, that sounds good. That's not what we did. So that is a problem for our members as well.
Lynn, you wanted to say something?
Well, I have somewhat of a different point of view, perhaps, and maybe.
And I'm sorry if I could just interrupt. If you could also talk about EPA resources.
I will,
Right.
and because I think I'm going to start there, but maybe a little more cynical. And so, as Bob said, the program had been, like a backwater in a sense, but also, as I mentioned at the beginning, I had to fight really hard to just maintain any level of resources in that program at all, And I was actually advantaged by that we would have these really long meetings that would go late into the night, and having trained in pediatrics, I could stay up late and stay engaged. I mean, honestly, that program had so little support that no surprise that after the bill is enacted, you don't have an incredible amount of muscle there that can just kind of like go in place and suddenly be aggressive and start doing work that nobody in that program had ever done before, right? And there was no surge of resources that were appropriate to the task in terms of the kind of expertise that they needed, not only for the science, but also to manage new processes, including new legal processes. And also that even once you do that, a program needs to develop what I would call muscle memory. You build your strength, but you learn how to do things and you get better. So I had the experience of having the pesticide program shortly after the re-registration law had been enacted, and we were behind on that and had made pathetic efforts, in my opinion, things like re-registering garlic, which was not an impressive public health accomplishment, right? But it was, you could tick the box, I did one, right? But that kind of thing taught people how to do the process. And I do think that EPA has been learning that and has been beginning to produce. But I also think that it isn't realistic to think that everybody having compromised on a statute would then say, well, then everything's fine. Let's sit back and let the agency do its work. That isn't what happens. I mean, the minute after a statute is enacted, my experience is everybody goes back to their corner and tries to figure out, okay, how am I going to get back what I gave away in that negotiation? That's actual human behavior. I'm sorry to tell you. And in that sense, I may disagree with Bob. I mean, I was not surprised or shocked that after the law was enacted, that every risk management decision, that there was litigation over it. I don't think that demonstrates a failure of the agency. I think it demonstrates the agency was doing something that it needed to do. It was using new public health standards. It was making tough decisions that maybe some people didn't want to hear. They wouldn't have been challenged legally if they weren't like that. And I do think that it's kind of inevitable with something that's that new, that the courts are going to be involved. And I would wish there hadn't been so much litigation. Honestly, I would have wished there would have been a steadier hand at the tiller in terms of the successive administrations that have been over the EPA during this time, that it has been very confusing for the scientists and others in the agency to know what their bosses want them to do, right? So, that is not the agency's fault. I mean, the electorate did what it did, but it did create an issue, and you have an election that occurred right around the same time that the bill was enacted. I mean, I'm glad that the bill was enacted in 2016 because I can't imagine in the political climate we've had since then that it would have been possible, A, and I can't imagine that there's any scenario over which we continue to have the 1976 statute that would be better. I just can't see it that way.
Jerry? I'm sorry, Mike, go ahead.
I want to talk about resources because this is something that has bothered me for years. I came to Congress as a staffer in 1995 working for an appropriator, worked for 2 appropriators over a long period of time. And Lynn may remember that there was a time when assistant administrators would come up and testify before Congress after the administrator had testified about their budget proposal.
I remember that well.
Yeah, and
that
so
wasn't fun.
as members and staff, though, that required everybody to learn about every subcomponent of every department and agency, and that doesn't happen anymore. The administrator comes up, speak for 90 minutes, mostly about parochial issues. Staff and members have no incentive to read a GAO report, an OIG report. There's no incentive to understand about how many full-time equivalents are needed. And so over time, this neglect has resulted in these core regulatory functions essentially being level funded year after year after year. And I just read a story, I think it was yesterday, about the Rayburn House office building being structurally deficient because on that side, under legislative appropriations, they have deferred maintenance year after year after year. Now they have a multi-billion-dollar problem on their hands. Something similar has basically happened within the agency. So this is a huge, it's not an EPA failure necessarily. I do think that administrations, both Republicans and Democrats, are at fault of not putting the appropriate numbers into their budget justifications for OCSPP. But Congress has ignored the evidence that's been made available to them year after year after year. And here we are today with spending bills going through that, in my opinion, are inadequate for the needs of the agency. So I'll stop there, but that's my grind right now.
Tracy?
Yeah, I wanted to talk again about TSCA and pick up on some of the themes that Bob brought up, which is that it's true, it wasn't a high priority because we, since 2010, have had an incredible boom in science to be able to document that everyone is carrying around toxic chemicals in their bodies and they are increasing the risk of many adverse health outcomes, particularly in children. So this is why, and that Congress rightly was not doing anything about this because, in part, that the chemical industry has spent a lot of money lobbying Congress. And it was really the states starting to act on this that drove everyone to the table. Now, has it been successful? I would argue that, the law prioritized 10 chemicals that EPA had to evaluate. And 10 years later, and these are known toxic chemicals, people on the panel have said, they are still on the market. This morning, we talked about asbestos and how the industry is arguing why it's still okay to be using asbestos. I'm just going to go into the example of methylene chloride, which we know kills people, kills workers and small business owners. It's been documented in the peer-reviewed literature. But, and there's a safer substitute. And there are other health effects, cancer and adverse liver effects. EPA finally put into our risk management rule, and the industry has sued, and they claim that EPA has not established that methylene chloride is harmful. So these are important barriers. The chemical industry's arguing about the science is important barriers. Now, EPA is also not using best available science in the TSCA program, which we have documented. And I'll just give an example. The NAS has told them they need to use a method. It's called systematic reviews, which is essentially a consistent, transparent approach to how to evaluate the evidence. And if EPA had invested in doing this, they would have developed a whole process that is repeatable and reproducible and is even amenable to new AI tools to help with like literature identification and data extraction. Also, Tataska office could have been fully using existing IRIS assessments. Now, in some cases, they have disregarded aspects of the IRIS assessments they didn't like and redid them. Formaldehyde is a current example that's going on. So, and with formaldehyde in particular, which the National Academy of Sciences said that the IRIS assessment was good, it should be published. In the Biden administration, they re-brought the formaldehyde assessment before the SAC and essentially relitigated components of what the EPA had already done and the NIS had already affirmed, which set the stage for this administration to continue to undermine it and implement the recommendations by the American Chemistry Council in their risk assessment. So I think this is a big challenge that we have to address. And EPA, if they had set up the processes appropriately in the beginning, would be more resilient to these industry challenges to how to use best available science. Unfortunately, we are in a situation where a lot of these chemicals are both falling short of protecting health, and if the risk management rules are adopted, would continue to not only perpetrate that, but also ban states. And I just want to mention one more chemical where we see this sort of backsliding on science, which is phthalates. The phthalates risk assessments came out in the Biden administration and essentially did not consider almost any of the human epidemiological data since 2019. So, for example, there are studies, good, rigorous science studies, human studies showing that prenatal exposure to phthalates increases the risk of preterm birth. Not in the assessment. They also only considered half of the exposures. Well, this is going to mean that the assessments result in essentially underestimating risks and underestimating risk to those who are most vulnerable. So I think there's a lot of challenges here that need to be addressed in terms of ensuring, sure, EPA needs more money for sure, but EPA also needs to be more efficient in that office and how they're using and conducting science.
Jerry, what changes would your members like to see in TSCA reform? And I'd qualify that somewhat and ask, is now even the right time to be amending TSCA?
Who are you calling on?
Jerry.
I want to be judicious with my time because I know we're getting down there. There was a lot said in the last answer, so I'm going to try to wrap everything up as compactly as I can and answer your question. Now is the right time, in my opinion, yes. Congress, one of the smartest things they did was said, hey, in 10 years, we need you to come back because we're making significant changes to the way that this country manufactures and operates, whether or not we're getting this right for the states, whether we're getting this right for manufacturers, whether the country is in a better space, you need to come back and figure that out in 10 years. And so I would say that time was set by Congress. It was wise for them to do that, knowing the gravity of the situation, and I think that they should take advantage of it. I think that there are multiple problems that have poked their head up. I agree with Dr. Goldman. Just to kind of go back to the last group of stuff, I think that anybody who didn't expect litigation from all corners after this thing became enacted wasn't paying attention. It was going to happen, and I think we've seen that on all sorts of stuff, and which is why, as wonderful as it is for Dimitri and Ryan and Grant and I to write committee reports, case law always has a way of making those committee reports somewhat obsolete. I think there are a couple of really important things that in my mind, I think are important here. First is when TSCA was enacted, the Modern Clean Air Act did not exist. The Modern Safe Drinking Water Act did not exist. RCRA did not exist, which is why TSCA asks for EPA to look at disposal stuff. So we have a whole universe of law that has built up around that and is addressed through section 9B. And so the real question to me is, are we focusing on what we're trying to focus on right here? And are we doing it in a way that's credible? Over the last 10 years, EPA's risk framework has changed 4 times. And we have another one going out there. I'm not going to opine on whether it's the right one or the wrong one. I'm just saying, as a matter of course, that's 4 changes. And so I think we need to ask ourselves, is this the credible, predictable system that we envisioned? And I think for a lot of people, that answer is going to be hard to get to yes. What needs to be done? What needs to be done so that the agency can stay on task and not get sidetracked by Section 21 petitions? There will be a lot of bright minds that are going to opine on this. I just want to get to the resource question real quickly. I'm not suggesting that EPA doesn't need to have qualified staff. They absolutely do. And I'm not suggesting that the fees aren't important. They absolutely are. But I think, and to Dr. Goldman's point, we've had 10 years of practice. And I just want to talk about the new chemicals program. Within 3 years of the new chemicals program under the Lautenberg amendments, the amount of PMNs coming into EPA dropped by 2/3. We went from 600 before the law to 200. It has never recovered. The market learned 3 years in that this was not a predictable process. And the fee has gone up 14-fold. You have chemicals that are on, and I went back and looked and made sure that I didn't account for withdrawn and invalids. But you look at the PMNs. We have PMNs from 2010 still unresolved. The last 3 years, at least 40% of the PMNs that were put in are still unresolved. It's hard for people to feel good about a program if they're not getting the level of communication to be able to get it across the finish line. A program like this, if the way New Chemicals is working right now, if this was 20 or 30 years ago, I don't know whether NASA put someone on the moon now, then, and the way things are going right now, if we need new materials, I don't know they can do it again.
Bob?
Yeah, I think there may be a chicken and egg problem here, and we run the risk of condemning this program as a failure and then say the fault was the original statute, or the fault was the way EPA implemented the program, or the fault was, there was too much turnover on the EPA staff. And instead of looking in the mirror and seeing and asking what effect the stakeholders have had on the effectiveness of the program. And if your approach to the program is to say 3 years into or even 3 months into the implementation of a new PMN program, innovation is coming to an absolute halt, and therefore the law is a complete failure. Are you providing a self-fulfilling prophecy? In other words, are you saying this program, from our perspective, is not delivering the results we want, therefore the statute is failing, therefore the PMN program is failing? The same thing has happened with the existing chemical program, and I think it's really important to go back to the expectations that were built into the new law. And the expectations, very simply, were that we needed to evaluate and regulate more chemicals. And Congress was pretty explicit about that. They set timelines, they set minimum goals for the number of chemicals that EPA was supposed to be regulating. And so the metric of success that Congress agreed to consensually across the board is more regulation, more chemicals evaluated, more chemicals restricted, more risks reduced. So that's the metric of success that really counts here. And then the question is, well, why isn't that being met? And at least part of the expectation is that certain stakeholders may not want those expectations to be met because the commercial consequences for them are unacceptably large. So I think if we're defining the success of the program, we need to go back to the legislation and what the legislation was intended to do. And I think that's fairly clear.
Jerry, you want to? Dimitri, go ahead.
Go ahead.
So a few things. I think there's been a lot said, right? I wish I could comment on all of it, but what did the legislation intend to do? One, resoundingly, Congress rejected reasonable certainty of no harm as a standard for this law, and resoundingly passed in both bodies almost unanimously the no unreasonable risk standard, right? When you look at how EPA has been administering Section 6, it's usually looking closer like the old version that was rejected than the new version. It is not EPA, we're coming forth with a bunch of information to prove your chemical has a problem. It is guilt first, and you have to provide us with enough information to show that you're out of that. So I would argue that that's not consistent with the law on existing chemicals. When you look at new chemicals, everyone that got TA from EPA knows the goal was to codify the existing standard. That's what we were told we were going to do. The day after President Obama signed it into law, they yanked 400 PMNs and said, all new. So I think some of the reason why you see industry upset is because they feel like there was at best a bait and switch there. And when you come through these kind of deals, they're so delicate that if you had said we were going to drastically change the new chemicals program, we would have demanded way more preemption. We would have demanded less on other areas. So when one of those threads unravels, it starts unraveling everything. The last thing I was going to say is I think the resource issue is real. Part of the problem, though, is also choices that the agency has made in the process. And I think, you know, the reality is I don't know what the right resource number is. I don't know what the program gets, $90 million a year, let's say. You know, the Biden administration wanted 130. I don't see an environment anytime in the near future where we're giving this office $130 million. So the question is, you know, do we want to keep talking about resources or figure out how to fix it and live within the current constraints like everybody's company does, like everybody, you know, I mean, when resources are limited, you have to change practice, not keep complaining about resources, I would say.
Yeah.
Grant, go ahead.
Yeah, I just want to follow up on Dimitri's point. So just draw back, talk about two different chemicals, PCE and TCE. Used to work on Superfund sites, and they're everywhere in Superfund sites. Worked on remediating homes and buildings that have wooden structures that have literally been impregnated with industrial solvents. There's one instance where they moved in a children's school, a pre-K school. And when they shut the windows during summer, turned on the AC, they had to evacuate the kids because there are very high levels of industrial solvents inside. So in 2001, I want to say, early 2000s, in the second of 3 NAS reports on TCE, the NAS said, stop it. Don't look at any more studies. Do a risk management decision. Take care of the risk that people are experiencing in their everyday lives. It was not until a couple of years ago that EPA actually banned TCE. as has been mentioned, currently being litigated, right? To the point where the agency is not even, in fact, allowing effective dates to go into effect. They're holding them serially in abeyance. That's a broken system, right? That is a broken system, not the actual banning of the chemical, which we've known for decades causes cancer, fetal heart defects. The banning of the chemical is great. It helps us. So based on that measure, the law can be effective. The question is, because, and I think it was Lynn who said it, because everybody has some type of either profit-driven motive or other commercial-driven motive, when do you actually say enough is enough and allow that chemical to recede and move forward with other safer chemicals? And once again, I'm not trying to draw divisions in between, the front-facing companies anymore and upstream chemical companies, but it's gonna happen again. And Johnson & Johnson, they're gonna get taken to task. States are still gonna continue to try and protect their people because under the 10th Amendment, they have that right to do it. Protection, health, welfare, and safety. And I think, the upstream chemical companies are gonna find themselves back in that barrel where the fingers are being pointed at them and they're gonna have to make a decision, like, what do we wanna do? So yeah, I think the law has been effective because the prior law was so low in terms of effectiveness, but we have a law now that can work. The question is, will everybody allow it to?
I'd like to,
Lynn,
can I
Ryan,
just tag on for a second? The fact we have court cases that are underway, we don't know how they're going to be decided. And even if we change the law tomorrow, there would be other court cases. And I mean, to me, the idea of looking at the law and amending it now doesn't make sense. I don't think that we've seen how this law actually plays out as it's worked through the judicial system. And it could well be that at the end of the day, methylene chloride and PCE and TC will be banned in the way that they should be after these things, and asbestos as well, and it may be not, and we'll have to go back. But, and then it will be the same issue with how does everybody get what they need, in doing that. But, if there were some way of saying, wait a minute, today isn't the time, but I think, Jerry, you have a point. At some point, Congress needs to come back. But to me, it's early to come back. It's maybe even 5 years too early.
Ryan?
I've lost track of the original question.
Should we amend the law, basically?
Oh,
A lot of blah, blah, blah.
Should we amend the law? Gosh, Bob told me before coming in here that Senator Udall said no, and I really hate to disagree with Senator Udall, but there was a time, to get nostalgic with my, congressional staff colleagues. Congress came back 4 years in, 5 years in, some amount of time in. You're passing a piece of legislation as big as this to come in and do cleanup, to come in and do even technical amendments to it. I don't think that anyone anticipates 10 years in with the opportunity to make some changes to it, possibly to a company extending the fee authority. Everybody should support extending the fee authority. Industry supports extending the fee authority, to be sure. We have to have this program resource to operate. But to add some changes to it, some improvement to it, now really is the time to take advantage of that opportunity to do it. Nobody's going to enact a bill the size of the Lautenberg Act, anytime soon. But there are some fine tuning of evaluating new chemistries for the reason that they're being manufactured. There's some fine tuning for the existing chemicals program. Look, we messed up Section 21. We need to fix that. We can't have outside groups determining what gets regulated. EPA needs to set some priorities there. And then there were some things that we didn't even think about 10 years ago. Should there be data protection programs? Should there be data compensation programs to protect the investment that our industry is making in new innovations. The chemical industry plants $15 billion a year into R&D to make the safest, best new products to come onto the market, and they genuinely believe that. Being able to protect that is important. So there's a lot of different issues. Are we going to be able to hit all of them? Absolutely not. But there's an opportunity to, and we should at least try this year.
Tracy, short of changing the onus for existing chemicals, what changes would you want to see in the law?
Well, I don't think we should open it, but I would like to see that we have adherence to best available science as recommended by the National Academy of Sciences. They have multiple reports that EPA should adhere to. Of course, I want to change the onus, but you took that off the table, so I will give you that. But I think the other thing that's really important here is that the process should be free of bias. And what I mean is free of financial conflicts of interest in the process. So one thing that we have been recommending is that, for example, the science advisory panels, not only at EPA, but across federal agencies, should not have people on them that have financial conflicts of interest. It's been well documented through empirical based research that these people who have a financial stake in the outcome of the decision serving on science advisory panels, even when they declare their financial stake, and I mean these are from the regulated industry, for example, or their trade groups, will bias the panel's decisions. And I think this actually was recommended in the Make America Healthy Again first report, that there's a lot of corporate influence and corporate capture in these federal agencies, and this is one way to take it out. I think that it's also really important. I think though, so that improving the science basis, we're having ability to require a whole minimum data set in the data acquisition component of the law without legislative influence, and then strict penalties for lying, because sometimes industry does not provide all the data. And we know from, for example, PFOA, they sometimes have data on the toxic harms of their chemicals for decades without giving them to the agency. So there should be penalties for not following the law.
Our time is up. Thank you.
Thank you.
Thanks. I got stoned.
Thank you so much to our distinguished panel. Thank you to Jeremy, Grant, Jerry, Dr. Goldman, Michael, Ryan, Dimitri, Bob, and Tracy. We so appreciate you taking the time to look back over the past 10 years with us. We'll now jump into our final panel of the day, TSCA Reform Redux, Change Beyond Fee Reauthorization. This panel is moderated by Pat Rizzuto, a senior chemicals reporter at Bloomberg Law's Environment Desk. With a passion for covering chemical-related issues, Pat explores the intersection of environmental policy and industry practices. Pat's work over the last 20-plus years has included reporting on nanotechnology, biotechnology, and commercial chemicals for Bloomberg Law. Pat, I will hand things over to you. Thank you all so much.
Well, thank you all for staying despite it being late in the day. And despite these issues being teased at earlier sessions, these people wouldn't be on this stage if they didn't have additional valuable insights to share. So with that, let me start at the far end. Liz Hitchcock, Director of Federal Policy for Toxic Free Future. Then it's Ryan. Ryan Schmidt, Principal. I'm reading here. Ryan Schmidt of Counsel with Bergeson and Campbell. Then we have Danielle Savory, Senior Legislative Representative for Earth Justice, and Karen Schmidt, Principal with Squire Patton Boggs. So let's start with a really fundamental question. Is it too soon to change the 2016 law? Do we need more experience with implementation? Daniel?
Yeah, happy to start. I'll start with a simple yes and turn it over to Ryan. You spoke about sort of some of the things that were covered before. I want to thank the great Senator Udall for kind of stealing a lot of my thunder and talking points. But I hope you all got to see what he said earlier, or definitely go back and watch it. I took a couple of notes. He said, opening up the law now would be a bad idea. We should be focused on funding and not gutting. The TSCA framework is sound. We don't need a new law. We need the will to implement it. I couldn't really agree more with that. There was, I just wanted to briefly address something that was said on the last panel, that something to the effect of, like, we shouldn't act as if OCSPP is going to get more funding and they should live within their means. But yet there's still efforts underway to change the law. I just fundamentally disagree with that. I think Dr. Friedhoff mentioned in her Senate testimony earlier this year that essentially prior to Lautenberg, only 20% of new chemical reviews were sort of done completely. So basically when she took over, EPA had 5 times the work to do and nowhere near 5 times the resources. So I know resources have been part of the discussion today, but I just wanted to briefly note that I think the idea that EPA has a lot more work and shouldn't have additional resources to do that work, I think it's just a false choice, and we should all be focused on making sure the agency is adequately resourced, certainly more so in my opinion than changing the law. Senator Udall stole some of my thunder. I want to just briefly mention a couple of things that some other people have said with a few quotes. I will steal some of their thunder from the past as well. Starting with the quote here, we're definitely going to need more than 9 years to fully implement the Lautenberg amendments. Let's see if anybody wants to guess who said that. That was Nancy Beck at this event last year. The next quote I wanted to say, a panelist from earlier today said last year, there was not a big difference between Trump to Biden regarding new chemicals. We're still talking about 90% of PMNs getting regulated and don't expect that to change. The third quote I wanted to note, a shout out to the Bergeson-Campbell podcast. I believe the gentleman to my left mentioned after the House hearing that the conversation hasn't gelled around a common purpose or problem that needs solving. I couldn't agree more with that. So we need more time to implement the law, no real change in new chemicals between the administrations, and not really gelling around a problem that needs to be solved. So it begs the question, at least for me, of sort of why we're here. The fee authority has certainly come up. Yes, the fee authority is sunsetting. Fee authority sunset. It could be extended very easily. It could have been done at any time over the last year and a half of this Congress. In fact, the Energy and Commerce Committee last year reauthorized, did a clean reauthorization unanimously of the FDA's drug fee program. Unanimously last year in this Congress. It can be done, and think sort of it should be done. There's just also to address a point from earlier, there's nothing I've seen in the legislative history that says that Congress intentionally said that, the reason why we have a 10-year fee authority, Congress often does things in 10-year windows for appropriations and fees. It was not Congress explicitly telling all of us that you guys need to go back and look at this law. Our country is 250 years old. We've essentially had a chemical safety law for 10 years. So yes, I think it is a bit too soon. And Congressman Tonko, I mentioned the Energy and Commerce Committee doing drug program reauthorization, a clean fee reauthorization there. And I think that's part of the reason why Mr. Tonko at the House hearing earlier this year said that he doesn't want to start a precedent of every 10 years we're sort of chipping away at the law, and I agree with that a lot. So I think, again, the fee authority is an important issue, and we'll talk more about that. I think why we're really here, to use another quote, is shortly after the election, a member of industry said that it was a once-in-a-lifetime opportunity to fix the law. And he was not talking about the fee authority. He was talking about the GOP trifecta. That's the opportunity that we're all sort of, I think, respectfully kind of dancing around a little bit. And it's fair. When environmental NGOs, when Democrats had a trifecta, we pushed our priorities very hard. It is completely understandable that industry with a Republican trifecta would try to push their priorities very hard. I don't think we should dance around that. But that is the once-in-a-lifetime opportunity to fix the law, that is the opportunity that has been discussed a lot today. So I think we should be upfront about that. I think the challenge is that the public wants more protection from toxic chemicals and not less, and I think industry knows that. I think and that was true, of course, in 2016, and it's arguably even more so now. So folks can't really, with a straight face, say we need to gut the law, something like that. They say we need to make tweaks or things like that. But I think you don't have to look further than, and we'll talk about this a little bit, what is actually in the discussion drafts. Senator Ricketts also has a bill that's similar to particularly the House discussion draft that members of industry supported, testified on behalf of. So it's not even do as I say, not as I do. It's like do as I say, do as I say. It's like you can't say we just want tweaks to the law, but we're supporting bills that actually gut the statute. And I think that's really what we're concerned about. It's not simply like let's not look at laws or have conversations there. We know the ultimate goal here. It's that once-in-a-lifetime opportunity, frankly, to gut the law. And I think the discussion drafts that are on the table would do that, and that is extremely concerning to us.
Ryan, too soon?
Yeah, well, first of all, I want to thank the organizers and thank my co-panelists here for having me here. It's really a wonderful opportunity. I feel honored to be on the stage with this group of esteemed folks and to share the stage with all of the panelists from earlier today. But to answer the question, and well, to respond a bit to Daniel first, I think that we do share some common ground on the resources question, which I'll get to. But I want to go directly to the "is it too soon" question from you, Pat. And no, in my opinion, it's not too soon. I don't think it's ever too soon to start to look at a law, whether it's TSCA or other laws, and try to identify possible areas for improvement. And I think in the TSCA context, we've had a decade's worth of experience implementing the law. That's more than enough, in my view, to start to identify some of those key problem areas. And I think Daniel mentioned that, at least in part, this particular panel is assembled here today because the fee authority is sunsetting at the 10-year mark. And I think Congress did that for a reason. I mean, that was said in the previous panel as well. It gives us the opportunity, all of us, EPA stakeholders, to take a step back and consider, what's working and what's not. And as someone who was at the agency, in 2016, when the Lautenberg amendments became law, I can say with confidence that it didn't take us 10 years to start to realize some of the real challenges that were associated with the new statutory framework. Certainly, I would agree that more experience is going to improve implementation, and I think that's not true just for EPA, it's true for all of us. I think that the more that EPA, the more that the regulated community, the more that the broader stakeholder community becomes familiar with TSCA processes, the more effective that I think we all can be in our respective roles in the process. But there are, in my view, and again, I'm speaking on my own behalf, not on behalf of our clients or the firm, but in my view, there are some real ambiguities and in some of the fundamental terms and statutory requirements that I think that 5-10 more years of implementation experience are just not going to resolve. The way that I think about it is that ambiguities require interpretation. Interpretation invites disagreement. Disagreements invite reinterpretation and litigation, and I think that cycle just continues. And it's not really a hypothetical that I'm describing. This is the actual story that I think that we've all lived for the past 10 years. There have now been 4 different administrations who have tried to solve the challenges of implementing new TSCA through various different approaches. Whether that's trying to bring all hands on deck, whether it's trying to focus implementation efforts on a particular aspect of the program or a particular challenge. There have been efforts to lean processes. There's been efforts to implement in a way that's that's right-sizing, so to speak, approaches. And all of those have had, I think, varying degrees of success. And I know that there's a lot of optimism. It was mentioned earlier that all eyes are sort of on the Fifth Circuit at this point and other courts for some potential rulings that could come out and provide some clarity and potential resolution to some of the key issues. But in my view, targeted legislative changes to TSCA are going to be the surest and the fastest way to put EPA on the path to long-term success.
Question, you mentioned improved implementation. And that there were some things that time wouldn't solve. Can you elaborate? Are there some problems that we've heard about today that might be fixed administratively by EPA through improved implementation, or is legislation essential? Do you want to pick that ball up and then toss it to Daniel?
Sure. I mean, yes, I do think that some of the problems can be addressed through implementation. And I would say address, maybe not solved entirely, but there are certainly things that EPA can and should be doing to advance the ball a little bit. But, just to take a step back, I think for all intents and purposes, and I know I'm preaching to the choir here, but the 2016 amendments effectively created a brand new TSCA, a brand new law. And I think everyone recognized at that time that, as with any new law, there was going to be some bumps in the road, there were going to be some issues to work through, and that it was going to take some time for EPA to work through all those issues. And I've heard, I understand the perspective that, for example, in the existing chemicals program, EPA has only taken up a handful of risk evaluations, a handful of risk management rules. There are 86,000 or so chemicals still waiting in line. But I think, on the other hand, the new chemicals program has been implementing the new Lautenberg requirements since day one. So we're talking about thousands of reviews of new chemicals. And so there's really not a comparable lack of experience there. And, I think the efforts to improve the new chemicals program over the years have really been Herculean. Those efforts to improve processes continue to this day. I think that they've been productive, but EPA, at the end of the day, has still been unable to complete a review of a new chemical within 90 days, as I think Congress always expected. We've heard already, the number of submissions coming into the program has dropped dramatically since 2016. The review times are still extremely long. The outcome is always or almost always a regulatory restriction. And what we're seeing as a result of that is that innovative companies are choosing to just skip commercialization in the United States and opting to introduce their chemicals, their new technologies in foreign markets. This is obviously not a good outcome for businesses, but it's also not a good outcome for public health. I think chemicals are just a part of our daily lives. That's a fact. They surround us in everything that we do. And I think that the absence of a well-functioning new chemicals program, just the gateway for chemical innovation, the gateway for the introduction of newer, safer, more sustainable chemistries, can unfortunately leave us with older and sometimes more hazardous existing chemicals to work with. So legislation, again, in my view, is a way to be helpful in terms of clarifying, some of those ambiguities to ensure that the new chemicals program is both functional and appropriately protective. And when we talk about changes to the law, Daniel touched on this. When I talk about them, I'm not thinking about a total gut of TSCA. I'm thinking about more narrow clarifications, like in the context of new chemicals, the scope of the review. So, what is reasonable to foresee in the context of an exposure assessment? What should EPA be considering as it reviews new chemicals? What is reasonable in the context of estimating future circumstances with respect to exposures and uses? And given those uncertainties with what may happen in the future, what's the appropriate way to address risk? What did Congress mean with respect to some of the new affirmative determinations that they added in 2016. And I think Rich mentioned earlier, where's the line between not likely to present an unreasonable risk and may present an unreasonable risk? These are open questions, and I would just stress that those challenges are not issues of lack of experience on EPA's part. They are outcomes that are driven by the statutory language and EPA's view of the statutory language. And in my view, the impact of those nuances, they may seem small, but they just can't be overstated. In our view, the discussion on what's working in the new chemicals program, what's not, is something that would really benefit from open dialogue in Congress. So I think ultimately the best way to get there is through some targeted legislative adjustments that aim to make EPA's obligations as clear as possible.
Daniel?
Yeah, thanks. Happy to pick up there. I'm glad I think there's some agreement that certainly a lot of what needs to be fixed, and we'll talk a little bit more about whether there's agreement on what the problems are and what needs to be fixed, but that certainly many of those issues can be done administratively. And I'll start first by taking a half step back, right? Senator Udall talked about implementation and funding related to that. Funding is an implementation issue. I don't think that's a wild statement, right? Like if you want to implement the law well, if you want things to move timely, you need to have people there to implement the law. So I think that is a critically important issue. And we saw with the DOGE cuts and everything that happened earlier last year, I mean, just the impact of that alone on implementing the statute, I think is going to be massive. And we probably don't even have a full understanding and appreciation for that yet. Of course, if you're picking up a theme, I have to go to another quote. One of the leading industry proponents for making legislative changes said recently, shortly after the Senate hearing, what's interesting with the Senate draft are things that EPA can do with existing authority. What can we do now that doesn't rely on statutory changes? It's a lot. So again, I could not have said that much better. I'm surprised actually this hasn't come up yet, but I think everybody in this room knows just about 18 months ago at the end of the Biden administration, they put forward a new chemical rule to help provide some more clarity in the process, some more guidelines around what is required in a PMN. And so I think, again, I haven't heard anybody mention that today, but I do believe that provides some additional clarity in places where there wasn't clarity before. And just in terms of I wanted to also, we haven't talked much about this other than maybe around the edges of sort of delays in reviews, because that has been what has been driving a lot of the conversation on Capitol Hill and elsewhere for the last, really 2 years. And I just wanted to put sort of a fine point on that. Dr. Woodruff, who was on the last panel, mentioned when she testified before the House earlier this year, another statistic, which is that 100% of the new chemical reviews that are open for longer than a year are waiting on some form of industry action. 100% of new chemical reviews open longer than a year are waiting for industry. Just one example we saw recently, a fragrance company had their order approved by EPA, and it took them, I think, 23 months to countersign it. We never hear about those stories in the delays. There was talk on the last panel about a PMN that's open since 2010, 40% haven't been, are still waiting for some type of action, but the rest of that sentence is rarely finished of why. And the reason why the sentence isn't finished is because it leaves in the listener the idea that it's the bureaucratic delay at a government agency that is the problem, and therefore the statute is the problem, and therefore we need to change it. It's not why is a particular chemical, why are 100% of the reviews waiting on industry? They have not signed a form. Maria Doa talked earlier about sort of the arm wrestling that goes back and forth. EPA has authority to sign unilateral orders, but they choose not to work with industry to find some soft landing place to land the plane. Again, they don't have to do that, but they do that for industry's benefit. So the idea that there are these delays because we have a bureaucratic agency that may or may not be sufficiently funded, again, most of the delay is waiting on some part of industry. So the idea that we need to reopen and gut, as a lot of the drafts that are on the table would do, to this statute, because there is a problem of getting chemicals reviewed and approved timely, at the very least, the whole story needs to be told on that. And I'm afraid it hasn't really in the public discourse so far.
And so can we also ask some folks to elaborate on something that's come up, which is what are the arguments for and against revising the law? Karen.
All right, so I'm going to get at this a little bit of a different way. So you asked the question of, is it too soon? And I think that's the wrong question. The question is, when do you need to make a change to a statute? And there are multiple occasions when you may need to do that. You can have statutory language which is exquisitely crystal clear and unambiguous, and there are still problems implementing the statute. So a perfect example of that is the 90-day requirement for PMN reviews. That couldn't be more crystal clear in the law, and it isn't working. EPA can't do it. Why is that? That's a perfect opportunity to re-examine making statutory changes to make sure that that 90 days means something and can in fact be met. Now that possibly could be augmented with additional implementation, with regulatory changes, with guidance, and on some rare occasions even it's possible a court could weigh in on that. But in this case, we know as a practical matter that courts aren't weighing in on that question. And EPA has been working on that issue since 2016 across multiple administrations and cannot figure out how to get it done yet. So if there's ever a case for going back to the statute and saying, wait a minute, maybe the issue is in the design, not the mandate and not the specificity of the mandate and not the unambiguous nature of it. It simply has to get fixed. So that's an example of where something is really, really clear. So there are other examples. There's examples where EPA is given discretion to do something under the statute. A great example of that is the Section 9 referral process to another agency. So the way the statute is written now, EPA gets discretion to decide, the administrator decides, whether the other agency has the ability under its laws that it administers to solve the problem. Okay. So one way to fix that would be that EPA applies its discretion differently than it's been doing. In other words, it makes those referrals as a matter of course. However, it hasn't been doing that. It's been using its discretion differently and not making those referrals. So that's another example of a case where some additional clarity could be incredibly helpful. Why do we ask for statutory changes? Because there's a need for Congress to make a change. There's a need for Congress to explain what it meant, and not necessarily what it meant then, what it means now. Another example, there's been a lot of discussion today about the role of TSCA with respect to workers, worker exposure evaluations, risk evaluations, risk management, and how that referral process is supposed to work in the first place. Okay, so we have legislative history from 2016, and we have the entire history of TSCA before that with respect to how workers were evaluated and how they're risk managed now. But it is now 2026. So looking forward, we can see that if there are no changes to TSCA, we are on a path to having all worker cohorts included in all risk evaluations all the time, and almost inevitably risk management action, which means for every single chemical from now until eternity, I don't want to sound scary, but from now until eternity, as those chemicals move through risk evaluation and into risk management, you're looking at a new ECHL, a new WCPP for every chemical. So is that a problem in 2026? No, we're right at the front edge of that problem. That's going to be a problem in the next 5 years, the next 10 years, as we start finalizing those rules. And EPA is not designing its risk management actions in a way to ensure that workplaces don't get double, triple regulation or different requirements under different risk management rules that don't align themselves. There's a lot of discussion about EPA needing to align its program with OSHA's, but this is EPA aligning its requirements with itself. So that's something else that really I think should be considered as part of the overall approach.
Liz, I'm sure you have some different approaches.
Respectfully, I have a few different ideas about whether or not the law should be reopened or revised at this point. One of the things, well, first, let me stop and thank the Environmental Law Institute for holding this conference year after year, and thank all of you for coming. I think Ryan and I were at the first TSCA at 1 conference, and here we are at TSCA at 10. And many of the topics we're discussing were the same topics we were discussing 10 years ago. 10 years feels like it's a long time, and it feels like a very short time. And in the life of a statute, the Lautenberg amendments are not quite 10 years old, and the problem with looking at those 10 years is that it has been identified by many of the other panelists who have addressed you today, talking about how uniquely enough the statute came into effect in 2016. Then the other parts of the statute came into effect in 2017. A new administration came in 2017. Then we had another new administration doing different work that came in 2021. And then in 2025, a completely different administration that was somewhat familiar to folks. And the two different administrations have approached implementing the law very differently. Daniel mentioned the need to implement the law, to actually put the law to work. And I would say that in the case of this statute, which we'll remember, revised a 40-year-old, by the time it was revised, universally recognized as ineffective to meet the needs of protecting public health from toxic chemicals. That law that went into effect in 1976, the date of our nation's bicentennial, the 200th anniversary of the U.S. We are approaching now the 250th anniversary. And I would say that 10 years, particularly because it's been such a different kind of 10 years, to take those changes that were made to TSCA in 2016 and put them to work, that hasn't been nearly enough time. And we don't have the time to make changes to TSCA this year, and the changes that have been proposed are not the changes that do anything more to protect public health from toxic chemicals. So I would say that we don't have the time. Senator Udall and Mrs. Lautenberg talked about how long it took to get to 2016. Senator Lautenberg introduced the first law, the Kid Safe Chemical Act, after working on it for a couple of years with organizations like the organization I used to work with, and other NGOs and the chemical industry. So he introduced a Kid Safe Chemical Act. It came back a few years later and introduced the Safe Chemicals Act. And as both Mrs. Lautenberg and Senator Udall noted, he was not able to get bipartisan support for that law. And so as he went farther into the process, he approached Senator Inhofe and said, what do I need to do to get a Republican onto this bill, get Republican support for this bill? And it took time to do that. After 2013, when the Lautenberg-Vitter Act was introduced, it took additional time to revise that law, to take it from being more weighted toward the convenience of not convenience, but the satisfaction of the chemical industry to bring in pieces like the new chemicals program and like the addressing unreasonable risk of harm until it got to a bill that that was not perfect by any regard. And there are many of us who, and Bob Sussman alluded to this earlier, who would have wanted more protections for communities that live near factories and facilities that are using toxic chemicals, more protection for people who are already damaged by their association with toxic chemicals, children who are born pre-polluted, pregnant women who are going to suffer the consequences of toxic chemicals. So there were things that we did not get in the final legislation, but my point is that it took a long time to get to this law that we then went to work making sure that the implementation of the law actually addressed the needs of public health and the environment. And so I come back to the question of, should we open up the law? No, we shouldn't. It is too soon, and it takes a long time to address the needs of communities on the fence line, of people who are already pre-polluted by the time they are born, and of the very vulnerable populations that we wanted to make sure were addressed in the Lautenberg amendments.
On that note, you listed a whole lot of vulnerable populations. Do the bills need to enhance public health protections to have any prospect of enactment? And let's have Ryan's perspective first.
Sure. I mean, I think that this question really gets to the idea of what is the problem we were trying to solve for. And in my view, the question is not so much, do we need to strengthen the safety standard? Is the safety standard too strong and we need to weaken it? I think it's really a question of how do we get the law to work as it was intended? And I think everyone probably in this entire auditorium knows that there was, very strong bipartisan support back in 2016 for a strong federal chemical regulatory framework. The vision then, I think, was that it would ensure the public is protected against unreasonable risk, and it would give the public some greater confidence in the safety of chemicals. So I think that the amendments that we're talking about now should be focused on ensuring that EPA has what it needs to implement the law effectively and efficiently. I think that when EPA is doing its job, when it's identifying an unreasonable risk, that the TSCA authorities should deliver those enhanced public health protections. I think that's absolutely true. And on the other side, when EPA is doing its job and does not find unreasonable risk, the TSCA process should again give the public some greater assurances in the safety of those chemicals that are part of their daily lives. So I hope that we can all agree that of EPA's laundry list of needs, at least one of those includes sufficient resources. That's both appropriations and fees to ensure that EPA can hire, can train, and maintain the staff that they need to implement all of these responsibilities. But in my view, I think that EPA also needs some clearer direction. Some of these undefined key phrases I mentioned earlier have led to different interpretations between different administrations. They've led to differing policy approaches, and I think in turn, a growing volume of legal challenges. And the situation, I think, has cast a pretty big shadow over the entire TSCA program. It's hard for any stakeholder to say with confidence, which way the wind is blowing. Where's the program going? What is EPA going to get done? What will it not get done? What might get done, but then will later get undone or redone? And it's a big cloud, and I don't think that anybody wants this cloud hanging over the program. My view is that lawmakers and TSCA reform stakeholders on both sides should be able to find some common ground on trying to position EPA for success And I think, success looks like TSCA implementation that's predictable, that's consistent, that provides some certainty to the regulated community, but also, ensures that the outcomes are appropriately protective of public health and the environment.
Liz?
Sure. When I was thinking about this question, I was thinking about the representatives of health-affected groups who came to Washington last week to talk to their members of Congress about not. Their message was clear: don't reopen TSCA, don't make changes to TSCA right now, because they brought their stories of contamination in their communities. We had Jess Conard, who came in from East Palestine, Ohio, where a trainload of vinyl chloride and other dangerous chemicals derailed in her tiny little village and has changed her life forever. We had Craig Miner come in from Michigan, who is a veteran who was affected by PFAS chemicals used in firefighting foam being spread in the military communities in which he lived. His son died prematurely, was born with cerebral palsy, and died prematurely. Carrie Reinhardt came in from Indianapolis to talk about the TCE plume under her community and the children, including her daughter, who have suffered from and died from rare cancers because of their community's contamination. Linda Robles, Craig Miner, and John Hancock all left their visits here to go to Tucson to a meeting of the National PFAS Contamination Coalition, where they are talking about how PFAS has affected their communities and has changed the health of their communities irreparably, and their concern that the old new chemicals program allowed thousands of PFAS onto the market and then let that genie out of the bottle and allowed contamination of their communities, which then damaged the health of their families, damaged the health of the workers in their communities. So I mention all of that to say that we need an EPA that is able to implement the law that was passed in 2016 that thinks about the communities that are on the fence line, the communities that are already contaminated, the communities that are suffering from contact with and exposure to toxic chemicals. We need to keep all of those in mind as we implement this law. I am not proposing, and we would not propose any health protective changes. There are things that we should do better within TSCA. I think Daniel made a very compelling case for doing any of those changes administratively to making sure that the law lives up to the promise of actually protecting communities from toxic chemicals.
All right. If you could be as quick as possible in answering the next question, are there changes to TSCA that are contemplated in the Senate and House bills that are essential? Just maybe name one or two. And are there non-starters? Should be dropped, just one or two. And Liz, why don't you start?
The Senate bill reauthorizes the fee authority, and they should do that because EPA needs the resources to implement the law.
Karen?
As was noted in a previous panel, Section 21 should have been fixed contemporaneously when the other changes to Section 6 were made. That didn't happen, and we now find that it essentially can be used to short circuit the very elaborate and specific approach that Congress put into place to prioritize, risk evaluate, and then risk manage existing chemicals. So the emergence of the use of Section 21 in that way is really a problem. And there's no limit on that. There's nothing in the statute that limits stakeholders from filing those petitions. And as we all know, that puts automatically into a process of acceptance or denial with the ability to litigate in court. So for those of us who are very concerned about EPA's workload and resourcing and overload, Section 21 is a substantial problem now and has the potential to be even bigger later. So I think that fix is not only necessary, it was a fairly clear omission from the 2016 package. The Section 5 changes, in my view, are essential. The problems emanate, some of them emanate from the statute itself. It may be that all the statutory changes that would be desirable from at least an industry stakeholder standpoint can't be made. Maybe it would require some statutory changes in tandem with some disciplined regulatory approaches to try to get things back up on the rails. When you asked the question earlier about, how soon is soon enough? When do we know it's time to change the statute? I think back to 2016, and I believe within about the first 6 months of the passage of that statute, or that bill, there was already early discussion about, there are some issues with this statutory language that maybe weren't fully thought through. And now that we see them there, and now that EPA is trying to implement, we see that there are some fundamental changes. And those of you who are familiar with Section 5 know what they are. It's the changes to the need for the affirmative determination, the changes to the legal standard for review. So those changes put into place a very different program. And again, 10 years of an inability on EPA's part to really fix the problem. So I would say, if I had to pick, which you made me do, I would pick those two at the top of my list.
Are there viable scenarios to enact legislation in this Congress, or do you think the bills are just placeholders for the future? And important to part of that question is, if Congress can't agree on broader changes, should it simply reauthorize the fee collection authority or just let it expire? Ryan.
Yeah, well, I mean, time is obviously quite short here. The number of legislative days left in this Congress is dwindling. The number of legislative days that remain before the expiration of the fee authority at the end of September of this year is even shorter. And Congress obviously has a whole host of other competing priorities that they're dealing with. I'm ever the optimist. I think that where there's a will, there's a way. So we'll have to see. But certainly, I think Congress has demonstrated a will. I think both the House and the Senate have showed that they're committed to making changes to TSCA by putting out the discussion drafts, by holding the legislative hearings. I would note that neither of the legislative discussion drafts, either in the House or the Senate, has been introduced as a bill. They have not gone through committee or subcommittee markup processes. So in terms of legislative development, there is a few miles to go yet there. But we do know that there's a lot of hard work, an awful lot of hard work that's going on in the background. Discussions are continuing. I very much doubt that the discussion drafts were ever put out with the intention of being placeholders for the future. I think that the folks working on those documents, are very much of the mind to get something real done. In terms of viability, I think that most people recognize here that any legislation that's going to have a chance of getting enacted is going to have some bipartisan support. And I think if you did listen to the legislative hearings, if you've followed the press releases and the reporting, you would know that the discussion drafts so far have obviously not attracted that kind of bipartisan support. But they were meant to start discussion. I think they were very effective at doing just that. But given the shortness of time now, I think you've rightly raised the question of what's the backup plan, what's the contingency in the event that broader changes can't be agreed upon before the fee authority expires. And I would just say that, in my view, allowing EPA's fee collection authority to expire would not be wise. TSCA fees, as many people probably know, make up around 25% of EPA's operating budget. The rest is supplemented by congressional appropriations. And of course, the deficit from the loss of fee collections could be made up by additional congressional appropriations. And that's assuming that Congress would agree to do that, which is a question mark, I think. But in the short term, I think that the expiration could present some pretty significant additional challenges to a TSCA program that's already struggling to keep pace with its obligations under current staffing levels, current resource levels. So, my hope is that conversations on the TSCA reform front can continue. I think in terms of a contingency plan, I think that it may be wise for folks to start thinking about a reauthorization of the fee collection authority that might be paired with smaller, more incremental changes towards improving the statutory structure, perhaps things that are more readily agreeable by both Republicans and Democrats. And certainly with the view towards the longer term, reauthorization of the fee collection authority paired with, continuing the discussion on broader changes that can, again, position EPA for that long-term success.
Daniel, I think that you offered some examples of just clean fee reauthorizations. Was there anything about those that enabled that?
Fortunately for my and maybe everyone else's sake, I don't work on FDA drug policy, but I am aware that, again, a bipartisan, unanimous panel at the Energy and Commerce Committee in the House, again, last year, this Congress, same makeup, did a clean fee reauthorization of that authority. So it can be done in this Congress. We shouldn't treat it as anything different than a distinct possibility. Just in terms of those couple of other points, viability, I agree with Ryan. The calendar is definitely is short at this point. I mentioned earlier the industry stakeholder line of viewing this Congress as a once-in-a-lifetime opportunity. I think industry folks are not viewing this as a placeholder time, that they are shooting their shot in the 119th Congress and they are going to try to run through the tape. So perhaps there will be conversations that continue next year and beyond, but I have certainly not heard anyone say, like, we're just trying to start the conversation a little bit and we'll pick things up next year. Turning to the fees piece in terms of just more on the reauthorization versus sort of letting the fees expire. We've all talked about, like, EPA needs money. The fees are an important part of that. I believe the 25% is really on the new chemical side, but still an important piece of the equation. I don't want the fees to sunset in any way, shape, or form. What I want less is for them to be used as a Trojan horse to gut the law, and that is what we're seeing right now. It is coming up sort of largely in that context. And so I have a lot of concern about any TSCA bill moving this Congress as not being sort of an avenue for mischief. Again, we've seen the discussion drafts. They reauthorize the fee authority with gutting the law at the same time. So that is not a trade that I would certainly be willing to make. So there's an important need for the fees, important need for funding, but it should not be used as a Trojan horse to gut the law.
Let's look forward. Are there any emerging future issues that may not have been fully arisen yet, but that would benefit from statutory changes? Something that we haven't discussed in this room, but warrants people thinking about it. And if we could start with Karen and then just head down the line.
So we did already talk about Section 21. So I think that's a great example of something that, again, wasn't considered at the time of original passage. It became an issue, and forecasting into the future, we can anticipate that has the potential to become an even bigger issue. So there are any number of other things that could be either improved or could be a stumbling block at some point in the future. To the extent that those can be identified now and stakeholders can agree on the problem and agree on the solution, those could be tweaked. So I don't know that those are in the mix. Both of the discussion drafts are, I would say, an articulation of current problems for a current fix and don't really forecast what's coming down the road. One of the notables is that as we think about what's important today in 2026, whether it's supply chain fractures, global pressures, international pressure from China, cybersecurity, whatever your issue du jour is, and of course our domestic infrastructure issues, right? Wanting to get battery infrastructure up and running, wanting to get semiconductor infrastructure up and running. Those are today's issues. So a really healthy, functional statute, in my view, doesn't necessarily double down on those sorts of today's problems, but does provide a flexible enough framework so that the problems of the future can be reasonably addressed without actually needing to reopen the statute again. So maybe that is something we can all agree on as we think about how this statute should be structured.
Daniel.
Yeah, happy to go next. I want to just briefly address the Section 21 issue and start. You all know I couldn't finish my remarks without coming up with another quote. This is not from the 2016 law, but from the 1976 original House report. Section 21 provides an important mechanism for public initiation of actions to protect health and the environment. That was in the original law, and I think it stands now completely. Just a couple facts on that. There has not been some major influx post-Lautenberg of Section 21 petitions, or sort of a steady flow before 2016, and now most of them are denied, and most of those are not challenged in court. And as Congress said 50 years ago, it is an important avenue for the public to be able to raise these issues. And the idea of it being sort of a resource drain on the agency, look, again, the agency needs to be properly funded, and the public shouldn't have to take a back seat to a lack of resources because of that. I think at the top level, what we need to be focused on at the North Star of protecting public health. That's what the public wants. And so as we go forward in the future, anything that we're focused on talking about should be keeping that front and center in mind.
Please, Ryan.
I'll chime in on Section 21 too, just because everybody's doing it. I agree with Karen that well, I also agree with Daniel as well in part. But there is this real inherent tension between the new requirements in Lautenberg for EPA to carry out the Section 6 process for existing chemicals, from prioritization to risk evaluation to risk management. And on the other side, the authority in Section 21 for a private citizen to compel EPA to basically skip all of those steps and go straight to rulemaking. I know from experience that the petitions can be very disruptive to agency processes. It's a 90-day deadline that the agency has taken seriously, and it's a whirlwind of work group meetings and analyses and consultations with lawyers and management briefings, all leading up to a decision to grant or deny the petition. And if a petition is granted, it's yet another sort of unplanned resource expenditure and activities for the agency. And it's just extremely hard for the agency to plan its annual budget activities with a petition authority that allows these big, costly actions to sort of parachute in without notice. So I do think that it is an important tool. That's the part that I agree with you on, and agree with the 1976 law drafters. That it's an opportunity for the public to elevate their priorities, their concerns to the agency for consideration. I just think that there are probably ways for Congress to think more about the issue and better optimize the alignment between the new Section 6 process coming out of the 2016 amendments and the authority for citizens to petition in. And as I was thinking, on a separate topic, just quickly here, in terms of issues that may not have fully materialized, issues that have not been raised, in this discussion so far, in both the House and Senate discussion drafts, there's no mention of two issues that I think are important, and one is discretionary scoping authority. The other is the whole chemical risk determination notion, and those were discussed earlier today in the first panel on risk evaluation, but they're notably absent from the discussion on the Hill in terms of providing some clarity on those topics. I think the controversy there has already materialized, and I think it will stay until there's some resolution from either Congress or the courts. So I think irrespective of your views on those two topics, I would put those squarely in the bucket of could benefit from congressional direction.
Just super quickly, one thing I forgot to mention before that hasn't come up today, as far as I recall, is of course manufacturer-requested risk evaluations, right? That is sort of the other side of the spectrum of when a company wants EPA to essentially, hopefully for their sake, find no unreasonable risk. I haven't heard calls to stop that process because it adds to the burden. So there is the flip side of Section 21 that industry has available to them and uses that. And I would argue is a very similar type of approach that Section 21 provides the rest of us. Sorry.
Liz.
In the very short time I have left, I am not going to talk about Section 21 petitions, although I do agree with Daniel and Ryan. I'm struck that as we've done poll after poll, and I've seen a dozen of them, the public consistently says that they want more, not less, protection from toxic chemicals. So anything moving forward, and I'm thinking very prospectively, has to take into account the public health protections, take into account the babies that are born pre-polluted, the people who live near facilities, the people who are being exposed by their clothing, by their carpet, by the furniture that they sit on. We need more, not less, protection from toxic chemicals. On the new chemicals panel, they mentioned a minimum data set, which was in an earlier version of TSCA reform, which I think is still a valid thing to be seeking for a new chemicals application.
All right, well, thank you all. Any last thoughts you'd like to share?
I would just like to say for the record that we could do another 30 minutes on manufacturer-requested reviews.
You have 10 seconds.
But we have 8 seconds. So we'll take that up another day, but I'm glad you raised it. That's a good point. I think that's a great mechanism to actually reduce burden on the agency if it were done correctly and more were accepted. So
we're taking pre-sales for
next year.
TSCA at 11 conference next year. Welcome.
Well, thank you all. Thank you all the audience, and thank you Environmental Law Institute and Bergeson and Campbell for hosting this. It is always a terrific forum.
Thank you so much to our speakers for bringing such great energy to the last panel of the day. Thank you to Pat, Liz, Daniel, Karen, and Ryan. I know it's been a long day, but stay with us for just a few more minutes. We'll now have some concluding remarks from Sandra Nichols-Chom and Jordan Diamond at the Environmental Law Institute. Sandy is the Vice President of Research and Policy here at ELI. She is an attorney specialized in developing and implementing effective legal and policy approaches to solve sustainable development challenges. She has over 20 years of experience in strategic program development, promoting rule of law and good governance in natural resource sectors, advocating for communities, advising governments on comparative best practices, and designing and implementing training programs for a broad spectrum of stakeholders. Jordan Diamond is the president of ELI. She is joining us remotely today. Known for her work on ensuring evidence-based, inclusive, and transparent decision-making, Jordan was previously the executive director of the UC Berkeley's Center of Law, Energy, and the Environment. She has been recognized through the ABA section of the Environment, Energy, and Resources Distinguished Environmental Advocates, the Next Generation Award, by ELI's Environmental Futures Award and as a member of ACOEL. Sandy and Jordan, I will hand things over to you to close this out. Thank you so much.
Hi, everyone. We'll be brief at the end of a really stimulating day. We just want to offer some thanks. On behalf of the Environmental Law Institute and our co-sponsors, I want to thank you for attending today's TSCA reform 10 years later. ELI is delighted to partner with the George Washington Milken Institute School of Public Health and Bergeson and Campbell for this annual day-long conference on TSCA reform. The excellence of the presentations and rich diversity of the speakers' point of view embody a core component of ELI's mission: to convene people with diverse perspectives to build understanding through robust debate. As you all know better than anyone, there are many fast-moving considerations involved with understanding, managing, and regulating this complex set of issues. This year, we returned to a hybrid format featuring in-depth, outstanding content all day long. We began the day with Lynn Bergeson setting the stage for a day of candid and vigorous debate on the state of TSCA play and the big issues that remain unresolved 10 years into the enactment of the Lautenberg Amendments. Throughout the day, we featured 5 lively panel discussions on various implementation topics. Some provided the latest updates on topics that we cover every year at our TSCA conference, including risk management, risk evaluation, and new chemical review. We were also excited to feature some topical discussions recognizing the 10-year anniversary of the Lautenberg Amendments. We took a step back during our 10 years of Lautenberg panel to consider where we are and how things have moved over the past decade. Dr. Lynn Goldman, Senator Udall, and Bonnie Lautenberg had a thoughtful keynote discussion on the progress we've seen since the amendments were passed. We also looked ahead with this stimulating last panel to the future of TSCA through this last panel on TSCA reform. Such a complex web of issues and a diverse set of perspectives. We hope very much that you are leaving this day of rich and stimulating panels inspired. With that, I will turn it over to our president, Jordan.
Thanks, Sandy. And I want to pile on to your thanks. And on behalf of ELI, echo the gratitude to the multiple of people who made today's conference possible. This will take 1 minute and then I'll get to the fuller closing comments, but I want to say the thank yous first because they are so important. And yes, I do in fact make my kids sit through the credits when we go to the movies. First, thank you to George Washington Milken Institute School of Public Health and Bergeson and Campbell for co-sponsoring today's event, as well as to GW itself for hosting us in such a beautiful space. And yes, it even looks great online. Thank you to the team at George Washington, including Dr. Lynn Goldman, Ebony Smith, David Jocelyn, Rafi Mansour, Daniel Mack, and Natalie Hasak. In addition, this conference wouldn't have been possible without the generous support of Bergeson and Campbell, Beveridge and Diamond, Squire Patton Boggs, and Wiley Ryan. Thanks to each of you for your contributions. And thank you to Lynn Bergeson and Bob Sussman. Lynn, Bob, I can't actually see you right now, but there are no words, who co-chaired our TSCA steering committee and put forth so much time and effort to create a robust, thoughtful, and engaging program. And speaking of the steering committee, thank you to each additional member of it, Maria Doa, Mark Duvall, Martha Marapease, and Karen Schmidt. And to the people who work daily to make this happen, the Bergeson and Campbell team, Heidi Brown-Lewis, Emily Scherer, and Chad Howland, you were each instrumental in helping prepare for today. And last but most certainly not least, and not just because I'm a little biased when it comes to them, thank you to my ELI colleagues, especially Madison Calhoun, Cecilia Diedrich, and Nika Sider. We are grateful for everyone's collaboration to make this event happen. Now more than ever, ELI feels that our role as a convener is essential. We bring people together, as Sandy emphasized, in multi-perspective conversation to respectfully express views, foster vigorous dialogue and debate, and enable passionate and committed stakeholders to come together to think, to evolve, and to collaborate to make the world a better place. Today was a tremendous example of experts coming together to truly engage. We embrace the idea that progress comes not from glossing over differences, but digging into them and finding a path forward. Whether it's the scientific process, questions of when and how to revise or not, how to evaluate progress and what the measures are, resources adequacy, review timelines, sunsetting provisions. The list goes on of topics that were not just alluded to, but explored today. So I want to say my personal gratitude to every one of our speakers who contributed to that atmosphere of candid and constructive dialogue, and to all the participants who joined us today for it. As we say every year with the TSCA conference, we hope this is a continuing conversation, not an endpoint. We hope that you walk away having learned something about TSCA and what the last 10 years in particular have held, whether it was a new fact or you learned about a new perspective or identified a new person you'd like to follow up with. The annual TSCA conference is one of over 50 programs that ELI offers every year to educate and deliver resources to environmental practitioners around the world. Our programs break down and explain and explore complex and pressing environmental challenges and build the skills and capacity of tomorrow's leaders and institutions. In addition to our educational programs, we have an entire research team of attorneys and scientists and experts who work to fill voids in our collective understanding and inform the most critical environmental decisions of the day. For example, you heard from Cecilia Diedrich at the beginning of the program today, who leads our work on toxics law and policy, which in addition to educational programming and focused dialogues also includes research and analysis tracking trends in law, litigation, and regulation. So today, more than ever, if you enjoyed today's conference and conversations, please stay involved with ELI. You can join our mailing list. You can become a member and gain access to our resources, newsletters, and more. You can donate during a challenging period of funding when every donation is profoundly appreciated. Or you can just reach out to me or any of our staff. Sandy, I don't know if you can hold up your green lanyard. If you see someone with a green lanyard, thank you, appreciate that. If you see someone with a green lanyard, feel free to approach them and ask and follow up about how to engage with ELI. So with that, I'll stop blocking you from enjoying the post-conference conversations, or if like me, you have been listening and live streaming, you'd like to get up and stretch. Just with one final thank you for being here today and engaging in this collaborative experience. So on behalf of the entire ELI team, we offer our best wishes to all of you. And with that, our day has officially come to a close.